Do a couple thank yous. Number one, I want to thank you all for being here and everyone online. We've got a lot of work to do today, a lot of good testimony. I kind of want to really start off by thanking the staff. People don't realize how much work they do and how much we appreciate what they do. So what I'd like to do is start in the back and have them introduce themselves, if they would. So we'll start back over here.
Carter Montgomery with the AV team.
Elena Rudder, Senior Research Analyst, Legislative Research Department.
Good morning. My name is Leanne Thone. I'm a Senior Research Analyst with KLRD.
Morning. I'm Jackie Gutierrez, Committee Assistant.
Mike Heim with the Revisor Statutes Office.
Jason Long with the Revisor Statutes Office.
Okay. We've got one back here, too. We're not going to let you slip out, Shirley.
Hi, everyone. I'm Nicole Fielder, and I'm a research analyst with KLRD.
So a lot of time, we can't tell you how much we appreciate the work you guys do down that area. And I'm excited today, when I look at this committee, we got the A team working up here. So I'd like to start and go around the room with this and kind of introduce yourself, if you would, and we'll start over with Senator Peterson.
Representative Buchheiberger, 46th District, Lawrence.
Will Carpenter, Representative 75th District, Butler County.
Mike Fagg, District 14, State Senate, El Dorado area, and McPherson.
Mike Thompson, Senate District 10, Shawnee, Lake Quivira, Lenexa, a little bit of Olathe.
House Rep Tom Kessler from South Wichita in the 96th District.
Larry Alley from Winfield, Senate District 32.
Representative Nick Hoheisel, 97th District, Southwest Wichita.
Representative Heather Meyer, 29th District, Central Overland Park.
Okay, thank you, committee. I think we're at 9:05. One thing I'm sure going to try to do today is do our best to stay on time because we've got a lot of stuff. So what I'd like to do, it's 9:05. Hopefully the other two will be showing up here, but first on the agenda, we have an overview of marijuana history, and Elena Rudder. Is she here today? There she is, okay. Thank you, it was behind me, wasn't you, Elena? So you might state your name and away we go. Thank you.
Thank you, Mr. Chairman, members of the committee. I am Elena Rudder. I'm a Senior Research Analyst with the Legislative Research Department, and I'm going to be presenting a memo on KLRD with the heading at the top for KLRD, overview of marijuana history. And this memo is going to cover an historical marijuana use, a few scientific discoveries, and how marijuana has been regulated throughout the contemporary U.S. history. So we're going to start way back 12,000 years ago. Historians believe that cannabis has been grown for at least 12,000 years and to have been domesticated in Central Asia for fiber, food, and oil. History also shows there's a correlation between migration of nomadic people throughout Asia, Europe, and the Middle East, and the dispersal of cannabis seeds. The earliest written record of cannabis being used medicinally is attributed to Chinese Emperor Xin Nung around 2727 BC. And then around 1500 BC was the first record of a topical application of cannabis to reduce inflammation. That was in Egypt. And then Herodotus, around 450 BC, who's the father of history, described how after a king's burial, Scythians would prepare small, hermetically closed chambers to burn hemp seeds, and how they were delighted by the fragrant smoke. The first physical evidence of marijuana being used medicinally was discovered in 1989, but it traces back to 390 AD. And then the oldest physical evidence of marijuana being used medicinally was discovered in the 2000s, and it traces back to 700 BC. There's also accounts from Pliny the Elder, Pedanius Dioscorides, and Claudius Galen throughout the Greco-Roman Empire. There was medicinal use of marijuana, and there's details in the memo more about specifically what they talked about and what they wrote about. In early modern history, cannabis was brought to the Western Hemisphere by Spanish colonists. They brought cannabis seeds to Chile, and then English colonists brought hemp to Jamestown, Virginia. And both sets of colonists used cannabis mostly for fiber. And then the first written record of the appetite-stimulating effects of cannabis was noted by Portuguese physician Garcia da Horta in 1563 while he was living in India. Moving to late modern history, in 1839, William Brooke O'Shaughnessy published his observations of cannabis use, and in 1941, he introduced cannabis to Western medicine after he lived in India. He noted the intoxicating effects of cannabis and how those effects depended on the resinous secretion that cannabis in India had that cannabis in Europe did not. He also, then Jacques-Joseph Moreau de Tours also wrote about and experienced the effects of cannabis on the mind, the intoxicating effects, and he wrote about the psychoses and the abulia, which is a lack of will, drive, and initiative for action, speech, and thought. In the 19th century, Queen Victoria and Empress Elizabeth of Austria both used cannabis medicinally. One used cannabis for painful menses, and one used it for coughs and to stimulate appetite. In 1878, J. Russell Reynolds was appointed the physician in ordinary to Queen Victoria's household, and he later summarized his 30 years of experience with cannabis. And he found that it was useful for treating a variety of painful illnesses, which is congruent with some modern studies. In the US, during the 19th century, medical professionals started recognizing the value of cannabis. It was added to the United States Pharmacopoeia in the middle of the 19th century as a treatment for pain, convulsions, menstrual cramps, lack of appetite, depression, and other mental illnesses. Military physicians also use cannabis for pain relief when treating soldiers injured during the US Civil War. And J.B. Mattinson published a paper in the St. Louis Medical and Surgical Journal indicating that cannabis was effective in treating cocaine and opiate addiction and migraines. Now moving to some scientific milestones on page 3. There have been over 100 cannabinoids isolated from cannabis, and the two most popular that you probably know of are THC and CBD. The first cannabinoid was isolated in 1898, and that was cannabinol CBN. And then in 1940, CBD was isolated, and in 1964, THC was isolated. After THC was isolated, scientists continued to study the endocannabinoid system, and in 1988, the first cannabinoid receptor, referred to as CB1R, was characterized, and then the endocannabinoid that targets CB1R was also identified a few years later. And on page 4, we move towards the United States history of regulating marijuana. In the early 1900s, marijuana was legal and used medicinally. In 1906, the first step of regulation was taken, and that was the 1906 Pure Food and Drug Act. And the focus of this act was to guard against contaminants and require products containing marijuana to be labeled. In the early 1900s, recreational use started to increase, and so did the movement to regulate marijuana. And as a result, the Harrison Narcotics Act of 1914 was passed, declaring drug use a crime. It also established the Narcotics Control Board to enforce drug laws. And then following the Harrison Narcotics Act, California became the first state to ban marijuana possession. Kansas banned marijuana possession in 1927, and then by 1937, when the Marijuana Tax Act was passed, 29 states had similar bans. The Marijuana Tax Act of 1937 imposed excise taxes on growers, sellers, and buyers of marijuana, imposed strict registration and reporting requirements, and imposed a high-cost transfer tax stamp on marijuana sales. Harry Anslinger, who was the commissioner for the Federal Bureau of Narcotics, was a major supporter of this act, as was Clinton M. Hester, the U.S. Department of Treasury's Assistant General Counsel at the time, and they both stated that the Marijuana Tax Act was to help deter drug use and drug addiction. Following the passage of the Marijuana Tax Act, products containing marijuana were removed from the market, and marijuana was also removed from the United States pharmacopoeia. In 1951 and 1956, there were two more federal acts, the Boggs Act and the Narcotics Control Act, and they established minimum and mandatory prison sentences for drug offenses, including marijuana, and excluded the possibility of probation and parole for offenses related to drug importation. These laws also aim to reduce drug addiction and deter drug use. In 1969, the Supreme Court heard Leary v. United States, and in that case, the Supreme Court ruled that the Marijuana Tax Act was unconstitutional. They found that the Marijuana Tax Act violated the Self-Incrimination Clause and Due Process Clause of the Fifth Amendment of the U.S. Constitution. Following the Leary decision, in 1970, the Controlled Substances Act was passed. The CSA placed marijuana under federal jurisdiction and designated it as a Schedule I controlled substance. And the classification effectively prohibits manufacture, distribution, dispensation, and possession of marijuana. The DEA was established in 1973, a few years later, to enforce the Controlled Substances Act. Specifically, when marijuana was designated as a Schedule I controlled substance, it was provisional and it was meant to be reviewed. There were two studies that happened, that they were conducted by the National Commission on Marijuana and Drug Abuse, also known as the Schaefer Commission. The Schaefer Commission released reports in 1972 and 1973 and concluded that a total prohibition is functionally inappropriate and a partial prohibition of marijuana, which focused on prosecution of drug distributors and traffickers, would be the most beneficial. The Schaefer Commission also found that the risks from marijuana were low compared to psychoactive substances, that widespread consumption of marijuana use does not involve the same social cost associated with most stimulants and depressants, and marijuana generally did not cause aggressive behaviors, which contradicted the theory that marijuana induced acts of violence. President Nixon rejected the Schaefer Commission's recommendation, and marijuana remained listed as a Schedule I substance under the CSA. The CSA also contains a process to petition Congress for a hearing to demonstrate that a drug should be reclassified. Some of the first petitions to reclassify marijuana were submitted in 1972, 1975, and 1986 by the National Organization for Reform of Marijuana Law. A hearing was conducted in 1986 and over 2 years, and then an administrative law judge, Judge Young, recommended rescheduling marijuana from Schedule I to Schedule II. Ultimately, the DEA administrator rejected the recommendation, and the final order rejecting the rescheduling was issued in 1992. Since then, subsequent petitions have also been submitted and rejected by the DEA, and federal courts have upheld those rejections, and there's currently a reclassification happening now, and you'll hear about that from others later. In 2005, provisions of the Controlled Substances Act were challenged in Gonzalez v. Rake, and the U.S. Supreme Court held that the provisions criminalizing the manufacture, distribution, or possession of marijuana for intrastate growers and medical users did not violate the Commerce Clause of the U.S. Constitution. In this case, specifically was about California's medical marijuana program at the time. Moving into more recent years, we have U.S. Department of Justice memos and congressional responses on page 7. Starting in 2009, the first guidance for enforcing the CSA in light of states authorizing medical marijuana was provided by the Department of Justice in the Ogden memo, and it's named that for its author, who was the Deputy Attorney General. And the Ogden memo provided that it was a core priority of the Department of Justice to prosecute significant drug traffickers and disrupt illegal drug manufacturing and trafficking networks. And the memo stated that federal resources should not be focused on individuals whose actions are in clear and unambiguous compliance with existing state medical marijuana laws. In 2011, there was a Cole memo, and that to clarify the 2009 Ogden memo, and the 2011 Cole memo stated that the previous memo was not intended to shield medical marijuana dispensaries from criminal prosecution, and it made a clear distinction between caregivers and then dispensaries. Following the 2011 Cole memo, the DOJ began criminally prosecuting medical marijuana dispensaries, again, for violating the CSA. So for that 2-year period between 2009 and 2011, there was confusion about whether dispensaries were considered caregivers, and caregivers were recommended to not be prosecuted under the CSA. After that was cleared up, then Colorado and Washington legalized recreational marijuana. So the DOJ released another memo, the 2013 Cole memo, and it stated that it would not pursue prosecutions under the CSA in states that legalized marijuana as long as each state has implemented strong and effective regulatory and enforcement systems to control the cultivation, distribution, sale, and possession of marijuana that address the threat legalization could pose to public safety, public health, and law enforcement. There were specifically 8 priorities listed in that memo. I don't have them listed in the memo, but if anyone's interested, I can provide those. And then the following year, in 2014, there was another Cole memo issued to address state legalization, banking, and money laundering laws. In 2014, there was the Rohrabacher-Farr Amendment, which was added to an appropriations bill, and it prohibits the Department of Justice from preventing sales from states from implementing their own state laws authorizing use, distribution, possession, and cultivation of medical marijuana. In 2018, the DOJ released the Sessions memo, and that rescinded all previous documents issued under the Obama administration, including the Ogden memo and the Cole memos. However, the Rohrabacher-Farr Amendment still prevents DOJ from using funds to prevent states from implementing their own state programs, and that the Rohrabacher-Farr Amendment has been passed, and it was every year since 2014, and the last one was effective through September 30th, 2024. Also in the mix is the 2014 and 2018 farm bills. In 2014, Congress permitted certain post-secondary institutions and state departments of agriculture to grow industrial hemp, and they also provided a definition of industrial hemp. However, it did not modify the Controlled Substances Act to exclude hemp or hemp-related products from Schedule 1 as Schedule 1 controlled substances, and that led to some confusion about whether hemp was a controlled substance or not. So to clear that up, in 2018, in the 2018 Farm Bill, Congress explicitly authorized the production of hemp and removed hemp and hemp seeds from the Controlled Substances Act. It also broadened the definition of industrial hemp. And then on page 9 of the memo is focused on state regulations. And so some states previously had decriminalized marijuana, but policies did not begin to change until 1996 when California legalized the use of medical marijuana through the Compassionate Use Act. And then since then, 38 states, the District of Columbia, Puerto Rico, Guam, the Northern Mariana Islands, and the U.S. Virgin Islands have all permitted some form of medical marijuana use. And then 9 states have authorized CBD or low THC programs. And in the memo is a table which details the years that every state has passed either a CBD low THC program, medical marijuana program, adult use program, and when they decriminalized marijuana possession. And with that, if there are any questions, I'd be happy to answer them now.
You're right on schedule. Thank you, Elena. That was a great presentation. Is there any questions from the committee? Representative?
Thank you. You referenced the 19th century medical uses. In your research, did you encounter what forms the cannabis was administered in for those treatments?
Yes, but I'll have to double check what they were. I think one of I'm pretty sure one of them was tinctures, but I need to double check exactly.
Senator Thompson.
Thank you, Mr. Chair. Elena, on like these Ogden memos, Cole memos, were these agency directives or executive orders? Not exactly. I think the only one I saw that was an actual congressional amendment was that I'm trying to find it here, Rohrabacher FAR amendment. But then it looks like, just to be sure that I'm reading this correctly, then the Sessions memo rescinded that so that did allow funds to be used to go after states who are not, or pursue actions against those in states that legalize recreational. So the status of it right now is they can go after people with in states that have legalized recreational, but if they're breaking the law, they can still use that, correct?
The Sessions memo did rescind the previous Ogden and Cole memos, which allows federal prosecutors to pursue action against individuals or companies or whoever in states that legalized recreational marijuana. However, the Rohrabacher FAR amendment, having been passed every year since 2014, does prevent federal prosecutors from implementing medical, or from prosecuting those participating in medical marijuana programs. So recreational marijuana can be prosecuted, medical marijuana cannot with the Rohrabacher FAR amendment.
So, if I may follow up, so if, I think you, and maybe this is one for law enforcement when they come to testify, if you purchase a firearm and you check off that you are not using Schedule I drugs or something like that, and you purchase a firearm, then it's later found that you are, they can still go after you. Is that a state offense or is that a federal offense?
I am not sure. I would probably like to defer that to law enforcement.
Okay. All right. Thanks, Elena.
Thank you, sir. So Elena, I thought we had did something around CBD with those two girls that were they're actually from my district. What was that?
I think it was Claire and Lola's law, and Leanne has something in her memo about that, actually.
Okay, so I don't see any, Mr. Chairman, so I don't see anything on here underneath the CBD low THC program for Kansas on this list, so that was kind of confusing to me.
I'm going to toss that to Leanne if that's okay, Mr. Chair.
Well, she's up next, so we'll have her address that.
Okay. Thank you.
Anybody else? Okay, Lena, thank you very much.
Thank you.
So Leanne is next. So if you'd please step to the mic, name, title. Also, Leanne, you might tell the people listening where they can find the information, if you would, for us.
Sure. Okay. Good morning. My name is Leanne Thone. I'm a senior research analyst with Kansas Legislative Research Department. So this morning for legislators, all of the testimony is located on the S drive. It's under the interim committees folder, and then there's a folder for this committee. For everyone else, for the public, it is being uploaded now to the website, ks.legislature.gov, and then you just navigate to the committee page, and it will be under agendas and testimony, I believe. But that is still being uploaded. Hopefully it will be all available later this morning. So this morning I'm going to talk you through a memo just about the legal status of marijuana, cannabidiol or CBD, and Delta 8. I added Delta 8 to this because it tends to be something that comes up along with CBD. And I thought, because it is kind of a confusing situation on the law on that it might be useful to have that information as well. So this memo basically goes through what the status of the law is in all of the states. And so we'll start with marijuana. Medical use, as of right now, 38 states and the District of Columbia have comprehensive medical marijuana programs. Nebraska will be voting on this very shortly in November. And so a comprehensive program is one that includes generally protections from criminal penalties for using marijuana for a medical purpose. Some of them include access to marijuana through home cultivation, but they typically include access through dispensaries of some kind, and then allowance for various types of products and strains. They might have limits on the amount of THC that's included, and they might have limits on the types of products that are included. For recreational use or adult use marijuana, there's 24 states and the District of Columbia have legalized that. They typically will have a legalized possession for an amount of marijuana for people over 21 or 21 and over. Florida residents will be voting on this issue in November as well. And then for decriminalization, I added this to this memo as well. This differs from legalization. It is just the lowering of criminal penalties for possession and use. So that might mean like no one's going to go to jail for possessing marijuana, but they might still impose a ticket or a fine of some kind. There are states that do not have recreational use or adult use, but have decriminalized on some level. And then there are also states that have not decriminalized at the state level, but there are municipalities that have done that at their level just to make it so that they're not prosecuting people for possession. As of right now, 31 states in the District of Columbia have decriminalized cannabis. That includes all of the states that have recreational use and then a few that don't. And then this memo does have a note about the federal rescheduling. I believe that our advisor will be talking a little bit more about this. But on May 21st, 2024, the DEA published a notice of proposed rulemaking to transfer marijuana from Schedule I to Schedule III under the Controlled Substances Act. So Schedule I drugs include things like heroin, LSD. They are drugs that have no currently accepted medical use and a high potential for abuse. So the proposal is to move to Schedule III, which includes things like Tylenol with codeine or ketamine. These are drugs with a moderate to low potential for physical and psychological dependence, and they currently have an accepted medical use. So as part of this proposed rulemaking, they take public comment, and they received more public comment, I believe, on this issue than they've ever received before. And so that period closed in July of 2024. And I think that the final rule is expected to be published by the end of the year, but I know it's taken them some time to get through all of the public comment. What this would basically do, and I know that we'll have other people discuss this as well, is that it would permit pharmacists to dispense, substances that include CBD. There would not be any impact on the legal status of recreational marijuana. This would not legalize marijuana in any way in states that do not already have those laws in place. Okay, and then looking at CBD. CBD is typically derived from hemp or manufactured in a laboratory. It's one of hundreds of cannabinoids, and it's not intoxicating on its own. People typically use it for things like anxiety, insomnia, chronic pain, and CBD was kind of allowed to become legal when the 2018 Farm Bill went into effect, and it said that hemp and byproducts of cannabis with less than 0.3% THC were not included under the definition of marijuana under the Controlled Substances Act. So since then, there's been some legal quibbling over this, but in this year, the Fourth Circuit Court of Appeals ruled that all hemp-derived products, including those that undergo a chemical process during manufacturing, are legal under federal law. So while the law federally makes CBD derived from hemp with less than 0.3% THC permissible, states may enact their own laws to regulate its consumption. So there are states like Indiana and Wyoming that just adhere to that federal standard, and they allow for CBD derived from hemp as long as it doesn't have more than that 0.3% THC. Other states allow for CBD that contains a higher but still limited amount of THC. So this would be like the CBD/low THC states. So anything that is 0.3% THC is just, that's under the federal law. If they say, okay, well, we'll let you have CBD that has 1% THC, that would be like a low THC program. So that's kind of the difference there, if that makes sense. It's still very low in THC. It's still, not necessarily going to be a product that is intoxicating in that way, but the rules are just a little bit different and a little bit looser in those states that have the CBD low THC program. And then there are some states that are even more kind of restrictive. Idaho specifically requires all CBD to contain no traceable THC content, and so that's pretty strict. The law that you were thinking of, Representative Carpenter, is Claire and Lola's law. This was passed in 2019, SB 28. Part of what that bill did was to provide an affirmative defense to prosecution for possession of CBD if the person has a debilitating medical condition or is the parent or guardian of a child with a condition. And so it says, if you possess a CBD treatment preparation being used to treat a condition and you have a letter from your doctor that has been dated in the last 15 months and signed by a Kansas licensed physician who diagnosed that condition, on the physician's letterhead that identifies the person and or the child that would be receiving that CBD, then you would not be prosecuted for possessing that CBD. The part of that bill that was referenced as Claire and Lola's law prevents state agencies and political subdivisions from initiating child removal proceedings and protections based solely upon the parent or child's possession or use of CBD. So, next in the memo is the legal status of Delta 8 THC. And this is where it gets really fun. So Delta 8 THC is kind of similar to Delta 9 THC, but Delta 9 is kind of the thing that we think of as being intoxicating in cannabis, and Delta 8 produces a milder effect. Generally, Delta 8 is usually used to ease stress, depression, chronic pain. It usually has effects like pain reduction, sleep support, relaxation, improved appetite. Concentrated amounts of Delta 8 are usually made from hemp-derived CBD. The natural amount of Delta 8 in hemp is very low, so they use a chemical process to convert that. Much of the Delta 8 THC available for retail sale is synthetically produced, and it comes from hemp. In 2022, the Ninth Circuit ruled that Delta 8 and similar hemp-derived cannabinoids are legal if they fit under the statutory definition of hemp in the 2018 Farm Bill, and that was reaffirmed in 2024 by the Fourth Circuit Court of Appeals. However, some states have enacted laws regulating, restricting, or banning Delta 8. And so the end of this memo is a really big chart, which I hope will be a helpful reference for everyone. I wanted to talk a little bit about the column about Delta 8 because it's a little bit more confusing than the other ones. There are some different things going on with it. So some states only allow you to purchase Delta 8 through cannabis dispensaries. Some states have legalized Delta 8 and it is regulated, meaning that the state has requirements for the manufacture and or sale of Delta 8. Some states it is legal, but it's unregulated. And what that means is their law just aligns with the 2018 Farm Bill. It says Delta 8's legal as long as you don't have more than 0.3% THC in it. And then there are a few states where it's considered restricted, and that basically just means it's legal, but there are laws that are limiting what can be produced or sold. And so one example is in Kansas, there was an attorney general's opinion that said Delta 8's legal as long as it only has 0.3% THC, all types of THC. So that would include Delta 9, that would include Delta 8, Delta 10, any kind. And so that restricts a bit more what could be available for sale. Also, though, this chart reflects what the law says. And if you start looking around, there are definitely states where people say, well, that's the law, but it's not being enforced. I didn't indicate that on this memo because I can't verify that, but that is a reality that we have to consider, is that there are definitely places where there might be laws in place, but they're not being enforced to their full extent, or maybe they're only being enforced minimally. So I would be happy to take questions if you have any.
Sure, we got a lot of them here.
Yeah.
Representative Holheiser.
Thank you, Mr. Chairman. Thank you, Leanne, for that presentation. I have two questions, Mr. Chairman, if I may.
Sure.
The first one was, of the 24 states that have legalized or the 31 states that have decriminalized, has any of those states gone back and scrubbed criminal records of simple possession of marijuana? If you don't have that answer right off the bat, that'd be something the next time we meet.
I do believe that there are some states that have done that, have done expungement. I don't know off the top of my head which states have done that, but I can find out.
Appreciate that.
Yeah.
Second question, Mr. Chairman. On Claire and Lola's law, I remember working on that in the Judiciary Committee. I believe 2019, Representative Heiberger was working on that too, on that committee. I'd be interested to know, because I don't have any reason to believe you'd have this information offhand, if that defense strategy, affirmative defense, has been used in any cases since we've passed that law. Okay. If we could have that information, as well as how many cases in total since we passed that law of prosecution of CBD oil with over the amount we've had in the state of Kansas. Okay. So I'd be kind of interested in those numbers, if we could get those by the next time we meet, Mr. Chairman.
I think that's doable. Thank you.
Okay. Thank you so much. Thank you, Mr. Chairman.
Committee. Representative Kessler.
Thank you, Mr. Chair. So this is actually the first time I've kind of heard some of this, and thank you for this. But so if I heard you correctly and read the testimony correctly, CBD in the state of Kansas is only legal under that medical provision?
Yes.
So,
well,
yet my gas station can sell it?
I think, so there's the federal law that says you can have CBD as long as it has 0.3% or less of THC. And I think that's legal at the federal level. The way that the law reads, I don't want to speak to that just because I personally am not a lawyer, but I think that I would defer that to the revisers or perhaps our law enforcement, just to speak to like what is actually legal and what is being enforced and that kind of thing.
Okay.
Yeah.
And my second part to that was that when we were talking about the Delta 8 products and Delta 10 products, I mean, those do have to be under industrial hemp, right? Manufactured from industrial hemp?
Yes, I think so, but I would need to check on that. There may be people behind me that know and are like,
Okay. Representative Meyer.
Thank you, Mr. Chair. Thank you for your presentation, Leanne. I was wondering if you happen to know offhand how many Kansas municipalities have decriminalized at the local level?
I am not certain about that. I believe that it has been decriminalized at the local level in at least 2 places, but I would have to check on that just to make sure.
Thank you. If you could get that back to me, that would
Sure.
Okay, Representative Howe.
Thank you, Mr. Chairman. Thank you for your testimony. In your written testimony as well, you gave some examples of Schedule 3 drugs under the federal rescheduling of cannabis.
Mhm.
It says Schedule 3 drugs, substances, or chemicals such as Tylenol with codeine or ketamine
Mhm.
are defined as drugs with moderate to low potential or physical psychological dependence. Are you, it says such as Tylenol with codeine or ketamine.
Mhm.
So are you talking that Tylenol is administered with codeine or with supplemented with ketamine, or what are you talking about there? It was
Those are
unclear.
two like separate things. So Tylenol with codeine is something that I think you can get with a prescription. And so it's just, acetaminophen and codeine in one pill. And then ketamine is a separate thing, and that's also available with prescription. So those are substances that you need to have a prescription in order to get.
Okay, so you're not referring to over-the-counter Tylenol?
No,
Okay,
no.
thank you for clarifying that.
Hey, Senator Thompson?
Thank you, Mr. Chair. Thanks, Leanne. Two quick questions. Number one, what about the status of any mail order of CBD products that come in from out of state? Is there any regulation on that you're aware of?
That is a great question. I know that we've also looked at that question in terms of like alcohol shipment and things like that. So I'm not sure. I know that, the Postal Service says you're not allowed to mail things like that. The level of oversight,
There's none.
yeah, it's,
Basically, yeah.
but we can certainly look to see if there's been any, stories about that, or if there's been any statements from the DEA or anything.
Be curious about that.
Sure.
The other would be, as this descheduling process continues late this year, I'd be very interested in having any of the actual white papers, scientific research that shows the justification for descheduling,
Sure.
and make that available to us. I think that would be very helpful.
Yeah, we can do that for sure.
Thanks, Leanne. Thank you, Mr. Chair.
Anyone else? I've got a couple simple questions for you. You had the hard ones here. When you talk about 0.3, what's the highest number? You have any idea how high you can go up on that schedule?
The highest number of like THC concentration.
Yeah.
I'm not sure what, manufacturing maxes out at. I know I've read things about THC concentrations in products going into like the 80s. But I think that that's also a bit different depending on what kind of product you're talking about. So it's kind of a hard question to nail down.
Because how did they ever decide the 0.3?
That's a great question, and I'm not sure.
Because I heard 1 in there too, so.
Yeah.
Just wondering about that.
Yeah, the 1%, I believe, is Texas's law. They have a low THC program, and I think that they allow for products like CBD that include up to 1% THC. So that's where that number was coming from.
Ken, another question I have for you. If we go from this 1 to 3, like you're talking about the end of the year, with the programs that we don't have in Kansas, how would that affect Kansas if that law come into effect? I've had people say that we should have something in place or we've got a problem. So I just wonder if you might talk about that a little bit.
Sure. I do know that the pharmacists that will be here today providing testimony will speak to that. I believe it's just a matter of changing our Controlled Substances Act to mirror the federal, which is something that we have to do every couple of years anyway, just to add in drugs that have been approved by the FDA and just to make those little shifts that they sometimes do. So I think that the main issue would just be updating that law to mirror the federal, but I know that the pharmacist will speak more to that later, what those changes would need to be.
So if we didn't do that, what would happen?
I think that it would be just a conflict of, federal guidance says one thing, state guidance says another, and they would probably feel as though they had to continue abiding by state guidance. that would be my thought, would just be that there would be a conflict that they would have to deal with.
Okay, committee, we have any other questions? Okay, Leanne, thank you very much.
Thank you.
Okay, next we will go to the financial considerations and the Safer Banking Act, Nicole Fielder. So if you'd state your name, title, I'd appreciate it. Welcome to committee.
Thank you. While state laws vary, federal laws such as the Controlled Substances Act, the Bank Secrecy Act, anti-money laundering laws, and asset forfeiture laws prohibit the possession and distribution of both marijuana itself and assets tied to marijuana sales. As a result of these legal restrictions and potential liability, many financial institutions are unwilling to provide debit or credit card payment services, business loans, electronic payroll, and other common banking services to these businesses. Reuters reports that only about 10% of all U.S. banks and 5% of all credit unions provide cannabis banking. Marijuana businesses, therefore, largely operate in cash, which raises concerns with public safety and tax compliance. Financial institutions that do wish to provide services to these businesses must follow guidance issued by the Financial Crimes Enforcement Network, or FinCEN. FinCEN is a bureau of the U.S. Department of Treasury that works to detect and prosecute financial crimes and money laundering. Under their guidance, financial institutions are required to file suspicious activity reports, or SARs, on activity involving marijuana-related business each quarter. In the first quarter of 2024, FinCEN reported 815 unique filers, which includes banks, credit unions, and non-depository institutions in the United States. And of the over 23,000 total SARs filed in the U.S. in Q1 of 2024, Kansas institutions filed 345 SARs, and Missouri institutions filed 727 SARs. So that's, again, suspicious activity reports for any activity involved in marijuana banking. Not necessarily suspicious, but just by virtue of it being related to marijuana, they have to file suspicious activity reports. And then, as mentioned by my colleague, the federal proposal to reschedule marijuana would not have implications on banking, since marijuana would remain a controlled substance and would still be subject to the federal laws previously mentioned. For more information on rescheduling, KLRD has a memo titled Marijuana Classification and Implications of Rescheduling that is currently available on the website. I believe it's also on the S Drive somewhere, but it's definitely on the KLRD website. I can make sure that it's in both places. Do we have any questions at this time?
Committee? Representative?
Thank you, Mr. Chairman. Thank you, Nicole, for that. And I wouldn't be a good banking chairman if I didn't have any questions about this. One question I had is I haven't read the whole Safer Banking Acts. Would you be eligible under that if they passed marijuana dispensaries or businesses be eligible for small business loans or anything like that? Would that kind of clear up that language? Do you know?
Yeah, I'll talk a bit more about the acts in this next section.
Okay.
And I am not very well versed in the minutia there, but it would definitely provide safe harbor, so they would have access to a lot more of those services.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. Senator Alley.
Thank you, Mr. Chair. Is there a difference between the banking laws with hemp and the banking laws with marijuana?
I believe so, because hemp is explicitly not a controlled substance. The main difference is just the categorization as a controlled substance. So because marijuana is not only Schedule 1, but just in that Schedule 1 through 5 categorization, it is, banks are hesitant to work with these businesses because there are paths to bank them, as exhibited by the 815 institutions that do, but there's extra paperwork, and the law is murky, so a lot of banks don't want to deal with it.
If I may. CBD products derived from hemp would not fall under that banking law then?
That's my understanding.
Okay, thank you.
Committee, any other questions? You ready to continue?
Yes, just a few more paragraphs here, but I want to discuss the Safe Banking Act and the Safer Banking Acts. So in response to the underbanking of marijuana businesses, Congress has proposed the Secure and Fair Enforcement, or SAFE Banking Act, and its later Senate version, the Secure and Fair Enforcement Regulation, or Safer Banking Act. The memo mentions the various bill numbers for your reference. And then, so all versions of the bills would create safe harbor protections for financial institutions. The bills would state that a federal banking regulator may not prohibit, penalize, or otherwise discourage a depository institution from providing financial services to state-sanctioned marijuana businesses. And just a note that the later Safer Banking Act does not include the words otherwise discouraged because the committee deemed them to be too vague. But federal regulators would still be prohibited from, they could not penalize on the virtues of that. So the bills would also designate that proceeds from a transaction involving a state-sanctioned marijuana business are no longer considered proceeds from unlawful activity under anti-money laundering laws. So that's one of the current issues, is that anti-money laundering laws state that any activity related to marijuana would be considered proceeds from unlawful activity. So the bills would change that. So the Senate's 2023 Safer Banking Act would also make some additions and changes to the Safe Banking Act, with the most substantial differences being found in Section 10 about requirements for deposit accounts, most of which are listed in the memo. And there's also a few minor edits to the definition of a covered mortgage loan, timelines for updating guidance and annual reports. The Senate first entertained this legislation in 2023 when the Senate Committee on Banking, Housing, and Urban Affairs favorably reported the Safer Banking Act by a vote of 14-9. The chambers themselves have not acted on either version of the bill in the 118th Congress thus far, but in the 116th Congresses and 117th Congresses, the House has passed versions of the Safe Banking Act 7 times. So now I'm happy to stand for questions.
I don't think so. You need to proceed, or you got all of it?
That's it.
Okay, thank you very much.
Thank you all.
Okay, next we will head to the Kansas law and Kansas recently considered legislation and implications of rescheduling. And Jason Long, welcome to committee. You might state your name and.
Thank you, Mr. Chairman, members of the committee. Jason Long with the Office of Revisor Statutes. My colleagues in the research department have done an excellent job this morning, so I'm going to try to give you some information that you haven't already heard from them. You have 3 memos from our office before you. I'll go through each one of those briefly in detail. The first one regarding current Kansas law regarding the possession, use of products containing THC, basically details the 4 acts we have under current statutory law that govern or regulate the possession and use of products containing THC. The first, and the one you're probably most familiar with, the Commercial Industrial Hemp Act, that is in KSA 2-3901 and following. This was passed after the 2018 Farm Bill, as you're all aware of, which legalized industrial hemp production and processing. There's 2 different licensure schemes under the act, one for those who produce industrial hemp and and those who process it into industrial hemp products. The cultivators, producers are regulated under the State Department of Agriculture. The processors are regulated under the State Fire Marshal. They both have to go through licensure processes to do that. That is where we get the legal basis for the CBD products that you find in the CBD dispensaries throughout the state. It's the limit of the 0.3% THC content, not more than that. That's based on the federal limit, which it's my understanding, to the question raised earlier, is basically the point at which it has THC in it, but not enough to get you high, kind of like our alcohol blood alcohol limits for whether or not you're intoxicated or too intoxicated to drive a vehicle. It's a limit of THC content that the federal, that Congress considered a safe amount for people to use through a CBD product under industrial hemp laws. So that's the legalization of industrial hemp and industrial hemp products. Outside of that, then we have the highly regulated controlled substances. There are a series of criminal statutes under the criminal code in the state that criminalize the production, distribution, and possession of marijuana and products containing THC. That includes 215703, 215705, and on down. There is and 215706D, the affirmative defense that's based on the Clare and Lola's law that you heard about earlier this morning. And so there is that affirmative defense for cannabidiol treatments under those particular set of circumstances with the doctor's letter that allow you to possess those products in those particular circumstances. I will note the criminal code is largely dependent on the schedules that are in our Uniform Controlled Substances Act, which is the third act, the third set of statutes under state law that control products containing THC. The Uniform Controlled Substances Act, as Leanne noted, is based and closely follows the same schedules as are in federal law. And under our state schedules, KSA 65-4105H includes marijuana as a Schedule I drug, which is the most restricted. It's deemed to have no accepted medical use under the scheduling of Schedules 1 through 5, 1 being the most restrictive, 5 being the least restrictive. And then I will note also a question was raised earlier on decriminalization. To the extent any municipality in the state has attempted to decriminalize the possession of marijuana within their own jurisdiction, that does not negate or nullify any of the state prohibitions or state criminal law that still make it a crime to possess marijuana in the state of Kansas. And those individuals, regardless of being residents of a particular municipality, could still be arrested, tried and prosecuted and convicted of unlawful possession of marijuana under state law. There are also, I would note, no state regulations on shipping CBD products into the state. I believe those probably largely slip through private shipping companies and not through the U.S. Postal Service. But the production and distribution of those would be on the processors who are producing those under the Farm Bill and whatever CBD, industrial hemp regulation there is in the state in which they're created. The last and fourth state law I would just note is Clare and Lola's law, and I believe Leanne covered that rather comprehensively, so I don't think I had anything really to add to that discussion unless there are any further questions from the committee. I'd be happy to take any questions at this time before I proceed.
Committee, we got any questions, point? Representative Hoheisel.
Thank you, Mr. Chairman. Thank you for that presentation. This is just another request for data, Mr. Chairman, if we could. If the numbers are available, I'd like to know how many, we'll do over the last 3 years, how many prosecutions in the state of Kansas of simple possession of marijuana or, what is it? What's marijuana or What do they use it with? No, not cannabis. No, paraphernalia. That's the word I'm looking for. Or marijuana, sorry about that, paraphernalia. And that's it. It's an additional charge onto another crime. In the last 3 years, how many cases in Kansas have been prosecuted of simple just possession of marijuana or the paraphernalia? Thank you, Mr. Chairman.
Okay, Senator Thompson.
Thank you, Mr. Chair. Thank you, Jason. As always, excellent presentation. As long as you're looking up that research and prosecutions, I'd be also interested in knowing how many are repeat prosecutions of the same offense. Also, just to clarify on the mail order CBD products, so if I heard you right, they produce it based on what, say they're coming in from out of state, they base it on what's legal in their state, but it may not be legal in Kansas, and that may be coming in via Amazon, some other private delivery. Is that what you said, Jason?
Well, to the extent the individual who's receiving it and is residing in Kansas, they have to comply with their local jurisdiction, the state of Kansas, in terms of what they are legally allowed to possess. And so while they may be allowed to possess certain products in, like, say, the state of Colorado, they would not be able to possess those in the state of Kansas. And so even though they may have been able to be produced and shipped in Colorado, receiving those and being in possession of those in Kansas may be a criminal act for that individual. They would have to, know what they could legally possess in their state.
Okay. And one last question with regard to the Industrial Hemp Act. Is there, and I apologize, I should have read the statute beforehand. Is there anything that addresses the disposal of the portions of the plant that are higher concentrations of THC?
I believe, I am admittedly not an expert in the Commercial Industrial Hemp Act because it's largely a creature of the Department of Agriculture, but I believe there is a waste disposal plan that's supposed to be part of the licensing process and overseen by the Department of Ag. I will definitely check into that, though, to be sure.
Thank you, Jason. Thank you, Mr. Chair.
Okay, we got one more question, Representative Carpenter.
Thank you, Mr. Chair. So, Jason, on our list of CBD, we didn't have a law. Is that because we don't have a state law, but we've just assimilated the federal guidelines of the Hemp Act? Or should we actually be listed on there as someone that has a legal CBD?
I assume you're referring to the chart in that first memo. I am not entirely sure where the basis for that chart is. Some states have a more fully fleshed out CBD program with regulation, licensure of the retailers and things of that nature, and we don't have anything of that nature really on our statute books outside of the Industrial Hemp Act. I think maybe that column was directed more at not so much industrial hemp producers and processors, but at the actual production of CBD products with those oils and retail sales and things of that nature and used as a medical supplement treatment product. That may have been the defining criteria for whether or not you had a program under that chart. I'm not entirely sure. We have our Commercial Industrial Hemp Act, but then we really just have some affirmative defenses for the use of CBD products that go beyond that 0.3% THC in terms of being able to use those legally with the affirmative defense and clear and low list law is all we have in the state.
I was just curious, you can't even throw a stick and not hit a CBD shop. I mean.
Okay, Jason, you have anything else? Okay. Senator Alley.
Thank you, Mr. Chair. Following up with Senator Thompson's question on the waste product of the hemp, is that higher or lower in THC, the waste product, is it higher or lower in THC than the 0.03?
I wouldn't know. I would have to defer to the actual producers or the Department of Ag.
And,
with that question.
and did that, is that, what do they do with that waste product, I guess is the question.
I don't know. I don't know if if it's incinerated. I'm not sure what the waste disposal plans are. I haven't seen those again. We can certainly inquire with the Department of Ag on those questions.
Thank you.
Representative Kessler.
Thank you, Mr. Chair. I just want to make sure I kind of understand this correctly. Reading the Clare and Lola's law, that has allowed for CBD with no more than a concentration of 5% THC. So that's one side of it. And that's what Representative Carpenter, I guess, is alluding to, that we have a medical program as long as you fit into that, conform to those rules. But outside of that, am I understanding it correctly where CBD is legal in the state of Kansas as long as it is industrial hemp and less than 0.3% THC?
Yes, so you can produce CBD products with 0.3% THC concentration under our Industrial Hemp Act in the state of Kansas.
To follow up on that, I remember reading it. I can't remember where I read it at because I read a whole lot of this stuff, but I also saw in our statutes where hemp products by our statutes are not allowed for human consumption or animal consumption.
That's correct.
So CBD is allowed to sell, but it's not legal for human consumption.
That's correct.
Under our current statutes.
As I understand it, yes.
Thank you.
Representative Hoheisel.
Thank you, Mr. Chairman. Jason, I kind of want to just, will you clarify for the committee what an actual affirmative defense is? Because I think there's possibly some confusion. In affirmative defense, it's not legal. They can still be arrested. They can still be charged. It's just when they go to court, they can have an affirmative defense they can present to a judge, and a judge can take that information into account, or a jury. Is that correct?
Yes, that's correct. They could still be arrested and charged for the possession as an unlawful act, and they would then present the circumstances and the physician's letter as you stated, as an affirmative defense to that charge of unlawful conduct. And then, yes, the trier of fact, the judge or the jury could consider that as a lawful defense to that charge and acquit the individual on those charges.
But they're not obligated to, is that correct? They could take that into account, but they're not obligated to, I guess, follow
Yes,
that.
you're correct. There is a legal distinction between an affirmative defense versus a exemption from criminal prosecution. Those are two separate legal distinctions, and they are not exempt from criminal prosecution, which means they could still be convicted for those offenses, although, again, we'll get the information. I'm not aware of any convictions of those in those particular circumstances thus far.
Yeah, I just wanted to clarify that. Thank you, sir. Thank you, Mr. Chairman.
Representative Meyer.
Thank you, Mr. Chair. And kind of to bounce off of Representative Kessler's question, so with the way that CBD is currently regulated and CBD or THC containing products in Kansas, am I to understand that that means that hemp producers in the state cannot use their products to produce CBD containing things? Is that what I'm understanding? It sounded like hemp producers in Kansas couldn't produce CBD containing items.
They can. There's two different, the Industrial Hemp Act has producers and processors, and there's two different licensures. And my understanding is, I believe a lot of the operators have both licenses and do both. They both produce it and then process it, I think is my understanding. And they have their limits on how much THC concentration can be in those products that they produce. And then they can sell those products, to other individuals. What we don't have in Kansas is any kind of regulation of the CBD shops, the retailers who are selling these CBD products that you see out in your communities. That is an unregulated business currently under state law.
Okay, thank you for clarifying. Thank you, Mr. Chair.
Jason, did you have some more?
I do have two other memos I can briefly go through, Mr. Chairman, if we have time. The next one that was requested is a summary of recent medical marijuana legislation. And so that's a lengthier memo that you have going through all of the bills that were introduced during the immediately preceding biennium, the 2023-2024 legislative biennium, that proposed to regulate the production and sale of medical marijuana or medical cannabis in the state of Kansas. I went into some lengthy detail on the very first bill that was introduced. That was Senate Bill 135 at the beginning of the 2023 session, simply to give you an idea as to what the basic structure of these bills is. It's to divide up the regulation among multiple state agencies, typically with KDHE regulating the patients or caregivers who are purchasing the end product at retail for use. Regulation of the doctors, nurses, physicians, assistants, what have you, by the State Board of Healing Arts, regulation of pharmacies by the State Board of Pharmacy, and then regulation of the businesses that are cultivating, processing, and dispensing or selling at retail these products. Typically, that's been regulated on these bills by alcoholic beverage control, or in the case of Senate Bill 135, they renamed the agency to a different name and called it the ACC, Alcoholic and Cannabis Control Division under the Department of Revenue. And so it goes through basically the different components of these types of bills in terms of what's regulated. Some of the regulatory provisions that have been included in these bills, such as like caps on the licensure fees. I just want to point out the key differences on a lot of these bills comes down to who's doing the regulating and what the taxation scheme is, and then what are the statutory protections for the patients, caregivers, and businesses that are conducting business with under the Act. And so, for instance, under Senate Bill 135, there was an excise tax of 10% of the gross receipts of the retail sales of these products, and then it was earmarked out for some local revenue to go to local communities to help with the enforcement of the act, similar to what's done under the Alcoholic Liquor Regulation Acts. And then on page 5 of the memo, you can see there in the middle a bullet point list of some of the statutory provisions that were included in that legislation to protect patients from being discriminated against simply because they were a patient who was registered and purchasing and using medical cannabis as allowed under the Act. And that includes not being discriminated against in terms of housing, organ transplant, donation, having their child removed from their home because they were a patient using medical cannabis, workers' compensation benefits, things of that sort that you can see there. Also in 2023, House Bill 2417 was introduced. It's very similar to Senate Bill 135. The large difference came in the fees that were being charged for the businesses that were being licensed and the statutory protections for patients and caregivers. And then 2417 just made the sale subject to whatever the applicable state and local sales tax was. So it'd just be subject to sales tax as if you were going into any other retail store and purchasing a product. Also, Senate Bill 310 was introduced in 2023. It was identical to House Bill 2417. So you had those bills. Senate Bill 171 was introduced that same session. It was a little bit different. It was the Veterans First Medical Cannabis Act. Still had multi-agency regulation, but created a special regulatory commission to regulate the business aspect of the industry, and relied on the Board of Pharmacy and dispensaries to regulate dispensaries. It also would have imposed an excise tax at $115 per pound of cultivated medical marijuana, or $3 per ounce on the products that were sold at retail. So it also applied an excise tax. And then jumping into this current, this last session, 2024, you had Senate Bill 558 was introduced, the Kansas Medical Cannabis Act. Again, multi-agency regulatory structure. It was unique in that it authorized physicians, assistants, and advanced practice registered nurses to also be able to recommend treatment with medical cannabis, not just the patient's doctor, but those other licensed individuals could recommend treatment as well. And so it had additional regulations for those individuals. Businesses were going to be regulated under ABC with licensure fees. That bill would have imposed a 4% excise tax on the retail sale of medical marijuana, and then it also had specific $4 million earmarks for those revenues from those retail sales taxes for broadband internet connectivity, community crisis stabilization centers, and the state water plan, which made it rather unique from the other bills in that respect. I would also note that many of these bills also impose various restrictions on the forms of medical cannabis that could be dispensed, whether it's limited to just tinctures and creams and what have you. And also most of them included a THC concentration limit dependent upon the form. So you could only sell it in this form at this THC concentration percentage, or this form at this THC concentration percentage. Generally, they all prohibited smoking and vaporization forms of medical cannabis. So that would not have been allowed as a allowable dispensed form of the products. I would also note Senate Bill 558 included a separate act in the legislation to regulate those CBD retailers that I just mentioned. And so they would become regulated licensed entities under Senate Bill 558. The last bill in the memo, Senate Bill 555 from this last session, was a pilot program proposal, and it was a 5-year pilot program administered by the Secretary of KDHE. And basically, the Secretary would have entered into a series of contracts with private entities. And so there would have been up to 4 contracts with basically a medical cannabis operator, an MCO, to cultivate and process medical cannabis products. Then there were provisions, contingency provisions on whether or not pharmacies would be allowed to dispense these products or not. If they weren't allowed to dispense the products, the MCOs could then also contract to become dispensaries. If pharmacies were allowed to dispense these products under federal regulation, then of course they would go to the pharmacies, and pharmacies would be allowed to dispense these products. There's also provisions in that bill for distribution to like home delivery, like a third-party delivery service to the patient or caregivers, residents of these products. It also would have imposed an 8% excise tax on the sale of these products to patients and caregivers, with 20% of those revenues being earmarked for medical cannabis research and education. So that's just a very brief overview of the legislation that was introduced in the last 2 session years. I am more than happy to provide further detail and do a more comprehensive comparison if the committee would like, or if anybody's interested in the more specific details on those. But that gives you an idea as to what the legislatures looked like in terms of medical cannabis regulation, potential regulation over the last 2 years. I'll be happy to stand for any questions on that.
Okay, committee. Representative?
Actually, just a comment. I mean, you are the expert on this, Jason. I don't mean to want to try to correct you, but my memory is that HB 2417 did allow for smokable cannabis and a small amount of growing by patients.
I am not going to disagree with you at this point because I have read so many bills. I probably have misremembered it and going back through. So I can double check with that. But again, I'm not going to disagree with you if that's how you recall it.
Representative?
Thank you, Mr. Chair. Yeah, I believe that amendment was offered on the floor and then rejected. But I do have a question for you. So I want to back up a little bit. And I was just kind of still thinking about some of the earlier stuff that you said. And when you're talking about states limiting the quantity of or the amount of THC in products, that kind of jogged my memory. So I want to go back to like, okay, so Delta 9 produced from industrial hemp with a THC level of 0.3% is legal in the state of Kansas.
Yes.
Okay, so if I take that product and I put it in this drink cup right here, I see products on the shelf that say 20 milligrams of THC. But it's produced from industrial hemp Delta 9 with a dry weight of 0.3%. But by mass they can have up to, I don't know, I've seen it as high as 20 milligrams in a product. So do we have things that cover that kind of issue? I mean, I guess my question is, where do we stand on that? I mean, because 0.3% is a lot by dry weight. I understand that, but then you put so much of that concentration in here that I can get like 20 milligrams of THC out of this beverage right here. Do we have things that cover that? Or is that wide open? Is that just a gray area, or is that we just don't have anything concerning that right now, as far as legality goes?
So we have our standard criminal provisions, and of course, there's discretion among the local prosecutors as to how vigorously they want to prosecute and go after individuals who are in possession of products that may be unlawful under our current criminal statutes. With respect to a specific product like that, first, I don't know what the concentration of THC would be under 20 milligrams versus the total volume of that beverage. And so you have that question. And two, you have a question of who produced it and how it was produced. Other states have much more open CBD production and processes. We stick strictly to the Farm Bill from 2018 and commercial industrial hemp and have strict statutory restrictions against human consumption for hemp products that are produced in Kansas, but I can't speak for what other states may allow in terms of production.
So by sticking with the Farm Bill, this product, and this obviously this doesn't have it, I just was using an example, this product, they can prove to this product through the COAs that this is made with industrial hemp with a THC level below 0.3. I'm just saying, but we don't have any regulations about how much of that concentration of that 0.3 industrial hemp THC they put into a beverage for a serving. We don't have anything that regulates that.
Well, we do have, we do have one, there's only certain products are allowed on the Industrial Hemp Act, and the criminal code, my understanding, is somewhat tied to that in terms of CBD products. And so I would be, I'm not an expert in criminal law and the Controlled Drug Substances Code. So I'd have to go back and look. But I'm not entirely sure that that type of product is legal under our criminal code, depending on how much CBD content it had, depending on how you were possessing it and for what use you were possessing it. There are a lot of those factors go into it. And then again, there's the whole question of prosecutorial discretion. And so, and with products coming in from out of state, there's that question too. I can tell you what the Industrial Hemp Act says. I can tell you generally what the criminal code provides, but I'd have to do more digging into very specific hypotheticals like you're proposing. Those have a lot of other factors going in, and we'd have to do more analysis.
Yeah, well, I appreciate that. I was doing some digging and trying to find something, and I couldn't find anything that really talked about that as far as specifically saying that that's illegal in the state of Kansas. I mean, I couldn't find anything in our codes that I could wrap my hands around and say, yeah, it's definitely not legal or definitely legal. I couldn't find anything that kind of I couldn't find anything, you know. I just wondered if you knew of anything.
Again, I would want to go back and confirm. My understanding generally is the criminal code prohibits, you know, THC, you know, marijuana possession with THC in it, outside of the Commercial Industrial Hemp Act. So if it's not allowed under that act, it's generally prohibited under the criminal code. But I would have to look more specifically at products like that and what they contain and what they have.
Jason, is that it for you?
Real briefly, Mr. Chairman, I do have a memo for the Committee on Federal Rescheduling of Marijuana, just kind of outlining the basic regulatory process under the federal regs. There was the U.S. Attorney General and then acting through the DA can reschedule drugs on the controlled substances, the federal controlled substances schedule, so they can move drugs from one schedule to another. Generally, they ask for an evaluation recommendation from the Health and Human Services Department at the federal level before doing so. They request a scientific and medical evaluation. In August of 2023, the Department of Health and Human Services did one of those and issued recommendations to the DEA to reschedule marijuana from Schedule 1 to Schedule 3, which would make it a prescription pharmaceutical, basically controlled substance based on those. The DEA then issued a notice in May of this year that it would hold hearings on December 2nd of 2024 on the rescheduling of marijuana from Schedule 1 to Schedule 3. The date for filing notice that you wanted to appear and participate in the hearing was this past September 30th. So if you wanted to go attend those, I'm sorry, you're out of luck. You missed the deadline. However, you can attend. You just can't speak at the hearing. I will note that historically the DEA has followed the recommendations of the HHS when it comes to scientific and medical evaluations on rescheduling controlled substances. That, as Leanne noted, simply rescheduling marijuana from Schedule 1 to Schedule 3 does not just suddenly, by a snap of the finger, make all the state marijuana laws compliant with the Federal Controlled Substances Act. There would have to be a number of different federal subsequent actions would have to occur for people to then be able to access marijuana for medical purposes across the country. Most importantly, the FDA would have to approve a form of marijuana as a pharmaceutical that could be dispensed by licensed pharmacies across the country. There would probably be some federal criminal code changes that would likely need to take place. There also would be your producers would have to then become registered with the DEA and follow all federal and state requirements for production of pharmaceutical marijuana for distribution and then retail sale by the pharmacies as a prescription. Patients would have to obtain a valid prescription from their licensed medical provider, following all federal and state laws for doing so in order to obtain medical marijuana. At the end of the day, as Leanne pointed out, recreational use would still be prohibited at the federal level, and so there would not be sales of recreational marijuana readily open and available to any state. It would still only occur in those states that had actually passed recreational marijuana use. There are also questions that would rise because under current federal law, there are individuals are barred from public housing, obtaining immigration visas, and possessing firearms for possessing marijuana. With the change from Schedule 1 to Schedule 3, there's some questions about whether or not those prohibitions would still be in place for those individuals. There is a federal tax law that prohibits business tax deductions if you're trafficking in a Schedule 1 substance. By moving it to Schedule 3, those pharmaceutical manufacturers could then arguably start deducting their business expenses when they file their taxes for producing medical marijuana, not for recreational purposes, but for medical purposes. They could potentially have those business deductions. And all of that then comes with the caveat of Congress could clearly act in the interim. They could either act preemptively before the DEA actually makes a reschedule official and reschedule marijuana themselves. Congress could deschedule marijuana altogether, take it off the controlled substances lists altogether. And so there's a number of different things Congress could do as we await to see what the DEA does with respect to rescheduling marijuana from 1 to 3. So probably more questions than answers at this point. I'm happy to take questions on that at this point, but I likely have just the same questions you all have.
Is there any questions? Jason, thank you very much. You did a great job. Okay, next we're going to move into testimony from state agencies and organizations. And it's my understanding that Debbie Devers, is she here? There she is. But you've got a plane to catch, so we need to, when do you have to leave? Oh, okay. So welcome to committee. Please state your name.
Good morning, Mr. Chairman, members of the committee. My name is Debbie Beavers. I'm the Director of Alcoholic Beverage Control. Thank you for the opportunity to be here this morning. You should have a copy of my testimony, which I'm not going to go over in detail with you. You're aware there's been a lot of bills over the past few years. And in preparation for this testimony, I went through the bills, looked at old testimony, fiscal notes. Many of the bills, ABC has been named as the primary regulator in those bills. So we have been proactively trying to learn about cannabis and regulation. We joined the Cannabis Regulators Association a couple of years ago, been to a couple of conferences. They have a lot of information that's available to us as a member. Members are only state regulators. There are no industry members that are able to join that organization. And we've been trying to proactively learn best practices, and we don't think there's any need to have to reinvent the wheel if we don't have to. We can just change the tires on the wheel. You may be aware, and it was spoken about earlier, that Nebraska has gained enough signatures to put both medical and recreational on their ballot in November. If they do legalize marijuana, Kansas is going to be basically an island that's dry with no legal marijuana. We know, and I just read a study by Vincenti LLC that stated medical marijuana in the state of Nebraska would generate over $925 million in new economic activity through 2020. So that's just for medical. I do know that there's a court challenge going on. I don't know if they're actually going to vote in Nebraska, but we do know that marijuana is here in Kansas. We all know that. Where do Kansans get their marijuana? Do they buy it on the black market? Do they grow some? Or do they buy it in a state where it's legal and bring it into the state? When Missouri legalized recreational marijuana, it also gave them the ability to issue medical cards to out-of-state residents. I asked for an updated count from the state of Missouri. On October 9, their records indicated that there's 1,015 active medical marijuana cards issued to Kansas residents. That is down about a little over 800 from when I asked in April, and that's probably largely due to the legalization of recreational marijuana. Why would you want to get a medical marijuana card if you live in a state where it's not legal? I think there's probably, well, for one thing, the medical, at least in Missouri, is taxed at a lower rate, so it's a little cheaper. And secondly, they probably have a false sense of security, like, well, if I get picked up, I got a Missouri card. Well, you're in Kansas. it doesn't matter. So anyway, I found it very interesting. They've issued cards to a lot of out-of-state residents, but Kansas by far has the most of any other state in comparison. And, you know, when I was asked to testify, I'm like, what do you want to hear from me? I went through the old bills and I looked at things that were very important to us if we're going to be regulating. And our experience with alcohol regulation, it's really important to have clear language and comprehensive definitions. And that helps to avoid a lot of confusion because gray areas are open for interpretation and that's never good. So some of the things I pointed out in the testimony are a regulation model. Some states have set up a whole new agency. Some states have parsed it out to various agencies. I will say that the more agencies that are involved, the more complicated it becomes because you have new systems, you have to have interfaces, and everything has to talk to each other. So that does make it a little bit more complicated. One of the things in the past we have been concerned about is the effective date of the bill. One of the bills went into effect like July 1 of 26, but that's when we're supposed to be ready. So it causes us to question, do we even have the ability to do anything until that effective date of the bill? So that's something that's important to us. I mean, the bill, a bill could go into effect on July 1, but we could be ready to issue licenses like on the following July 1. So that's something that is important to us. Also, if ABC is going to be regulating the industry, we have an issue. We have a statute that says we have to have an assistant attorney general, and it's the attorney for the director and the division. It would be our preference to repeal that statute and just use Department of Revenue attorneys. The Attorney General's office puts a restriction on, our AAG is embedded in ABC, and they put a restriction on there. It kind of hampers me a lot. So what does that mean? It means that the AAG can't come into the State House when I'm testifying for a liquor bill. I can't sit there and ask him a question. I'm sitting there texting him and hoping for an answer. So that's something we would ask for consideration if ABC is going to be the regulator. Us talked about medical conditions should be in the statute, definitions. In previous bills, we've asked for different definitions to be added in just for clarity. And I think it's important that the definitions are comprehensive. Ownership, I've listed out a few concerns, but the biggest one is the fingerprinting of all owners, officers, and their spouses that own 5% or more. We think it's really important that they're fingerprinted. Licensing recommendations, a liquor license is not transferable. A cannabis license shouldn't be either. One thing that's near and dear to our hearts, if you've heard me testify on this over the last few years, is the license fees to be set in statute. A lot of the previous bills have had a range, and then we have to determine that in regulation. And then liquor license fees are set in statute. I think for transparency, it would just be good for the legislature to do that and not the division. Also, transporter license, do cultivators and processors need that as a right, or do we need to have a transporter's license as well? Does the legislature intend to cap licenses? If so, will there be a lottery system used? Will there be a social equity program? On the licensed premise, we have requested in past bills that records be maintained on the premises for 90 days. And then for 3 years. We also believe video surveillance is very important with the ability for the regulator to review that remotely, and strict security measures for access. Labeling and packaging is something that's kind of near and dear to my heart after being at these cannabis conferences. One thing we would request label approval like we do for alcohol. Packages need to be child resistant. And I would strongly suggest for a medical program, like black and white packaging. Black packaged white letters, white packaged black letters, and the only graphics as the medical, or as the marijuana symbol, the universal marijuana symbol. Making packages appealing to children is something that, as a medical, I mean, when I go to the pharmacy and pick up a prescription, it's usually a brown bottle with a white label, you know? So I think if it's a medical program, it should look like a medical program. Also, should the legislature consider limiting the types of products that are medical? I know the state of Illinois told me they had hot sauce that was registered as a medical type of marijuana. So, and should the products themselves, for instance, gummies, should they look like bears or should they be a geometric shape? So those are the kind of things that, you know, I know one of the states, I believe it was Florida, said that they couldn't have neon colors on their packaging, but they had no definition for neon colors. Several of them had suggested black and white would be the way to go if they had a do-over. So again, learning from others that have gone before us has been very important. Labs, you know, obviously there will be licensed labs to test the products, but we also need a state lab or a contract with another lab to do quality tests on the labs and on the products at retail. Medical marijuana cards, who will be issuing them? How will law enforcement validate that it's a valid medical marijuana card? And will the legislature want reciprocity with other states? Penalties need to be authorized in statute. Taxes need to be determined and specified. Funding, the legislature would need to obviously fully fund the program. If it anticipates being fee funded, once the program gets going, the fees need to reflect the ability to maintain the program. To issue licenses and regulate the industry, depending on a final bill, a rough estimate, ABC would need about 30 full-time employees. 12 of those would be enforcement agents. We'd have licensing, background, administrative staff. It'd be roughly about $7.5 million the first year. And that includes a rough estimate of $3 million for a seed-to-sale system. Enforcement agent startup costs are significant. We have to buy a vehicle and body armor and all that. So we estimate roughly it'd be about $3.8 million subsequently. Some of the bills in the past have provided for a pilot program. As a regulator, we just recommend considering implementing a well-defined bill and giving all applicants the opportunity at the same time instead of a pilot program, which would allow a bit of a head start. Previous bills have also changed ABC, that was mentioned by Jason, to the ACC. And if we were the primary regulator, we thought about it later, you know, considering renaming ABC to Alcoholic Beverage and Cannabis Control, so we could be ABC or ABCC, be a little easier. After 40 years of saying ABC, it'd be a little easier just for us. A little food for thought, as we've looked at the bill, it would be easier probably to start with a recreational program, be significant cost savings because of all the various things a medical program would require. And I did want to address some of the concerns that were brought up about the hemp-derived THC. The federal definition, as has been discussed, it's no more than 0.3% THC by weight, but 0.3%, to your point, Representative Kessler, it's not a non-intoxicating level, especially for edible products. Some of those products are currently being sold in packages that are as high as 400 milligrams And that's more than is allowed in most adult use states. Some of this information is derived from the cannabis regulators. It's a publication on their website. But they fall under the definition because of the 0.3% delta 9 THC by weight. So, but having said all that, there's no age restriction to purchase these products. Many of those products on the market are packaged to look almost identical to candy that kids like, and kids are buying it. And it's a problem. And I want to just, the legislature's obviously aware of it, but I just want to make sure. Recently, the governors of Missouri and California banned the products. Anyway, so I think that's a summary of my testimony. I'll be happy to answer any questions at the appropriate time.
Okay, thank you, Debbie. Representative Kessler.
Thank you, Mr. Chair. Thank you, Ms. Beavers, for being here today. So I know you serve on some boards and you visit with your peers in other states that do overlook and control these subjects. So, which obviously your list of things to kind of make sure we take a look at, it's impressive. So I was just, thank you for that. That was you hit on a lot of subjects that I hadn't come to my mind yet. So that was awesome. But I wanted to kind of circle back to the video surveillance real quick. Is there some constitutionality issues with that? I mean, do other states do that?
Other states do that, and the access is very controlled. They do it internally, but they also, many states have it so that the regulator can remote in and look, to see what's going on. And they move plants from one room to another as they grow, and so part of tracking the plants.
Okay, I was just curious if that is already in practice. But another interesting fact that I'm going to highlight in bold letters on my notes here is that you in your personal opinion, you think that if we went recreational, it would be much easier to regulate or maybe cheaper to regulate.
It would be simpler because with a medical program, you've got the physicians, the pharmacists, the KDHE, the medical cards, and you've got all these systems that have to talk to each other. I think law enforcement will speak for themselves. I think law enforcement, it's going to be difficult for them to know if they stop someone, do they have, validating that it's a valid medical card? Do they have more than they're supposed to have? I mean, I think there's a lot of questions that surround that. And so I just thought I'd throw some food for thought out there.
I appreciate it. Thank you, Mr. Chair.
Okay, Representative Holzheisel.
Thank you, Mr. Chair. Just one quick follow-up on what Representative Kessler was asking on the surveillance footage. In other states, that's at least exempt from CORA, is that correct?
I can't speak for other states, but I would assume so.
Okay. That wasn't my main question. I was just curious on that one. My main question, the number of medical marijuana cards that were issued in Missouri, I think you said, October, it was 1,015. That's down 819 from April. So a total of 1,834. Was that 1,834 number the peak?
I did not ask Missouri that, but that was considerably higher than when I asked for it the year before. So
1,834. Okay. And then I'm kind of curious on the 819 card reduction in about 6 months. Is that just people didn't renew? What is the process? How do you get an inactive medical marijuana card?
I don't know what Missouri's processes are, but I would assume that those were cards that were not renewed. And my assumption is it's likely due to it being recreational now and they can just go buy it.
Yeah, no, I don't doubt that. I was just curious if it wasn't renewed, how long that card is good for. Is it a yearly thing?
I believe it's a yearly card.
A year? Okay, that's what I was looking for. Thank you so much, ma'am. Thank you, Mr. Chairman.
Okay, we have a question from Senator Holscher, and she's online. So good morning, Senator. Can you hear me?
Yep, I can hear you. Can you hear me?
Okay, yes, we can.
All right, excellent. Good morning. Thank you. Thank you, Deb, for the presentation. I want to say too, I really appreciate how you've delved into this topic. Going through all the information that you shared with us. So thank you for that. I like your recommendation on the packaging and the products themselves, because I have seen some states where to me it appeared enticing to younger people. So I liked your recommendation on the black and white marketing of the packaging. I did have one question here. We've had several bills, and it seems like we have gone back and forth between very, very specific bills and then going to maybe bills that weren't quite so specific, that gave agencies discretion and control over making certain decisions. And like I said, it seems like we've kind of bounced back and forth over the past few years. Senate Bill 558 seems to be a pretty good model, but I wanted to ask you, is there a bill out there that from all of this knowledge that you've acquired is a good model, or is there a particular bill that was utilized in another state that's a strong model?
I'm not aware of any bills in other states that would be a strong model, but I think in the last couple of years, we've been really close on a couple of bills. For us, definitions are very important. We deal with it all the time in the alcohol arena, even though we've been doing alcohol a long time. As to discretion by the agencies, those that have been around me a few years have noticed I've tried to get everything I can in the statute so that it's right there before everyone, and they know the framework, and then we may have to come back and fill in with some regs, but I do like it. I do like the statute being more specific than vague.
Okay, great. Yeah, I know sometimes too, legislators will say, well, gosh, it's such a long bill if it's, over 100 pages or whatever. And so it's like trying to find that soft spot as far as making sure we have a well-regulated product, but then also making sure it's not so lengthy that it kind of intimidates us. So thank you for that.
Committee, we got any other questions? Senator Alley.
Thank you, Mr. Chair. I'd like to go back to your statement earlier about revenue in Nebraska. 925 million for medical marijuana. Was that revenue to the state, or was that what the sales were?
The study said the medical marijuana would generate over $925 million in new economic activity through 2030.
That means sales.
That means everything. I mean, the businesses, everything.
That wouldn't be revenue to the state.
Correct.
New taxes, though.
Correct.
Thank you.
Okay, Representative Meyer.
Thank you, Mr. Chair. Thank you for your presentation. I had a question about what the reciprocity would look like with other states. Can you tell me a little bit more about how that would work? I know some states have conditions where if you have a medical card, they issue a temporary one to you, but do you have any idea how you would favor that?
I think reciprocity would be quite complicated until there's some federal legalization, going across state lines. And how are you going to validate with that regulator if it's a valid card or not? So I'm not sure how many states are doing that. But I think it would be difficult to have reciprocity unless you're just going to look at the card. Someone's got in possession of marijuana, they have a valid card, it's out of state, and you're like, okay.
Thank you.
Okay, I have one more question, and Senator Thompson, because we're going to have to keep moving here.
Thank you, Director. A couple quickies very quickly. Do you know how many medical marijuana cards have been issued in Missouri for Missouri residents?
Yes. Well, no. Hold on.
You can get it and send it to the committee if
I
you'd like.
can. They sent me every state but Missouri.
Okay. I'm just curious about that, because from what I understand from the prosecutors in Missouri, once they went recreational, they stopped tracking any kind of crime or anything, any stats. And with regard to your estimate of the cost, that's just for tracking legal operators. That does not account for dealing with cartels or any of the black market. Is that correct?
Correct.
Okay, thank you.
Okay. Debbie, I think we can let you go catch your airplane. Thank you for being here, and thank you for your presentation.
Thank you.
Next, we have from the Kansas State Board of Pharmacy, Alexandria Blasey. Please state your name and welcome to committee.
Thank you, Mr. Chair. I'm Alexandra Blasey. I'm the Executive Director of the Kansas State Board of Pharmacy, and I am just going to admit right off the bat that I am not a pharmacist. But fortunately, I did come with two of our staff pharmacists with me today. So if you do have specific pharmacy practice related questions, they would be able to answer them for us. You have my testimony, and I want to thank the committee for the opportunity to come and testify on this topic. The board has really identified a few items over the years of reviewing this information. We've also remained engaged with our National Association of Boards of Pharmacy and have followed how other state boards of pharmacy have been addressing these issues in their respective states related to all things marijuana or cannabis. So first of all, I'd like to go back to Jason's testimony. I think he did an excellent job giving an overview of the Federal Controlled Substances Act and some of the additional steps that would have to be taken. One of the things that we have been trying to emphasize for those that have inquired of us is that essentially this proposed federal rule that would move marijuana from Schedule I to Schedule III of the Federal Controlled Substances Act would be the beginning of what would probably be an if-then domino effect. So for example, I think Jason highlighted this, but if the federal government made that change would still need to be made in the state of Kansas in the Kansas Controlled Substance Act in order for that substance to be mirrored and be legal in the state of Kansas for prescribing and dispensing. In addition, and this is the part that I'm not sure people fully understand, the key distinction in Schedule I to Schedule III is that medical use component. And ultimately, the authority in the United States for who makes a determination about accepted medical use is the Food and Drug Administration. And so the FDA would be responsible for vetting any of those new drug applications and going through the traditional phase trial pipeline for approval of medications prior to it becoming available for general prescribers and dispensers to actually send that product to their patients and get them on that medication. One of the good things, I think, just in hearing your conversation today, if then domino effect were to occur and the federal government made the change, states made those changes to mirror the federal law, and there were substances that made it through the FDA approval process and became prescribable, then that would create a significant amount of uniformity among states, which is something that we do severely lack currently, because it would follow the infrastructure that is already in place for the routine prescribing and dispensing of all controlled substance medications. And that is, of course, that a manufacturer generates that drug, they send it through a regulated drug supply chain, and that includes distributors, it includes third-party logistics providers, things are stored in warehouses and ultimately sent to the pharmacy or a medical care facility or other doctor's office, et cetera, where that can then be prescribed to and dispensed to a patient or ultimately administered to a patient, like in a hospital setting. And so there already is an infrastructure in place in the United States for this. I did want to mention that the Kansas Board of Pharmacy is responsible for regulating and licensing and registering all of those players in the space, not just the personnel that you see at your pharmacy and your local pharmacy. So we are responsible for the personnel and the pharmacy, but we are also the registrants of those wholesale drug distributors, third-party logistics providers and drug manufacturers, even if they're non-resident and they are doing business with the state of Kansas. So they're required to be registered in their home state and in the state that they are actually shipping that product into and ultimately sending it to patients. And so that's how you might think of a mail order pharmacy that might be located in another state or a distributor that's sending drugs into our state. And so that is a responsibility of the Board of Pharmacy in the state of Kansas. Then I also wanted to highlight just some key things that the board has shared testimony on in the past as different bills have come before the legislature in Kansas. First of all, the board does support, at a minimum, the requirement for a pharmacist consultant of some kind to be engaged and involved in all medical marijuana dispensing programs. Under current law, Arkansas and Louisiana do require retail dispensaries to consult with a licensed pharmacist who's available during normal operating hours to do a variety of things. In particular, the calculations required to determine what the dosing is of some of these products, if it's not through a routine pharmacy, do require some actual scientific consideration. And then in addition, to ensure patient safety, pharmacists can also do a verification of and match to see what other medications that patient might be on to ensure that there's no conflicts or concerns associated with adding marijuana to their patient profile. Director Beavers mentioned the poison control situation with pediatric patients in particular, but this is actually relevant to everyone. So the Board of Pharmacy has strongly supported appropriate labeling, packaging, and storage requirements for all medical or cannabis products. That includes mandating child-resistant packaging and encouraging safe storage to prevent accidental ingestion or other adverse events. I had the privilege to attend a continuing medical education seminar on marijuana and high-potency THC products earlier this month and by Dr. Kevin Osterhout of the Children's Hospital in Philadelphia. And he gave some staggering statistics on the accidental ingestion by individuals under the age of 18 because often of the seductive nature of some of the way the products are looking. And so the board has looked at what other states have done. And I've just provided a list in my testimony of things that we would respectfully request the legislature carefully consider in proposing any additional legislation and include in the statutory language. So first of all, packaging, opaque packaging. The board also would encourage unit dose packaging. So instead of having a package of like something, think about a giant package of chips where you have a whole bag of chips, you open it once, and then you have access to all the chips in the package. Instead, in pharmacy, we like to think of maybe unit dose packages, maybe like what you'd see at a long-term care facility, where you have to open each individual dose of the medication to ensure that it's a little bit more difficult to get into a large quantity. States like Colorado and Oregon have actually restricted the THC potency to 10 milligrams per serving and then 100 milligrams per package to help ensure that there's not a larger potential exposure incident. And then, of course, we would encourage child-resistant packaging in compliance with the Federal Poison Prevention Packaging Act of 1970. There's been conversation about limiting advertising targeted to individuals over the age of 21 for any kind of non-medical program, prohibiting treat-like designs or formulations, candy, Pop-Tarts, other foods that often are enticing to children, conspicuous labeling consistent with board requirements, and we do actually have quite a few regulations on the appropriate labeling of medical devices and substances. And then we would encourage patient counseling by a pharmacist or other medical provider. And I've just provided some additional resources there specific to pediatrics so that you have the opportunity to look at those. Last, I want to mention something that hasn't come up yet today, and that's the Kansas Prescription Drug Monitoring Program, otherwise referred to as KTRACS. And the board is responsible for the maintenance of this program. It tracks and monitors the dispensing of all outpatient controlled substances in Schedules 2, 3, and 4, as well as a short list of drugs of concern in Kansas. And that is overseen by a KTRACS advisory committee, which is composed of both prescribers, dispensers, and members of law enforcement that oversee that program. But ultimately, our pharmacies in the state of Kansas daily report all controlled substance dispensations to that program. And then that program is made available electronically. It's a web-based platform available 24/7 with the appropriate credentials to all of our prescribers and dispensers in Kansas so that they can get into that platform and review a patient's full controlled substance history prior to making any prescribing decisions or a pharmacist deciding to actually dispense that medication to the patient. Several bills in the state of Kansas have included marijuana dispensations in a medical capacity in the KTRACS program. Obviously, if there was a state law change that moved marijuana into Schedule 3, under current law, it would automatically be required to be reported. But if you decide to go a different route, and this body or the legislature considers a separate medical marijuana program, we would still encourage you to consider inclusion of dispensations of medical marijuana cannabis into the KTRACS program, just to ensure it's a one-stop shop for those higher risk, higher dependency potential substances. So with that, Mr. Chairman, I'd be happy to stand for any additional questions. I don't want to be too repetitive of the testimony you've already heard today.
Okay, thank you very much, committee. Senator Alley.
Thank you, Mr. Chair. Thank you for being here today. One of the things that struck my question was dosage. Do we have any dosage recommendations for different illnesses? And who makes that recommendation?
And I think the critical question that you just asked is at the end there, because currently in the United States, we rely on the FDA to approve products that have been tested and gone through appropriate phased trials to make the determination about any particular medication and what those appropriate dosages are for different conditions. And so ultimately then when the FDA makes those approvals, that is the messaging that is sent out to the prescribing and dispensing community about what those safe areas are. There are a handful of substances that do contain cannabidiol or other marijuana derivative CBD related products that have been FDA approved and are prescribable in the United States currently. So those would be the only ones that I would be able to reference in terms of what we do, what we know and has been documented and proven in the United States that the Board of Pharmacy would look to as a resource.
So the states that have already approved medical marijuana, where do they get their information?
I don't know the answer to that question. I don't know if we have, I don't think I can answer that with authority.
And then do we have any testing on the dosages? Or that's done by, and who is that doing? Who's doing that one?
Right. So again, in the traditional pharmaceutical drug supply chain, that is all done by the manufacturers, their quality control, and they of course are FDA inspected. They go through routine screenings and inspections by their home state. We would do those inspections for manufacturers here in the state of Kansas and check their records and make sure that they're complying with common good manufacturing practices and those kinds of things.
I believe that the pharmacist should be involved in this situation, and your recommendation should be with that dosage and testing also. Thank you.
Thank you.
Representative Kessler.
Thank you, Mr. Chair. One thing I didn't pick up in your testimony, and I was listening when I was out there, but if the feds don't reschedule, just to say everything stays the same, and we do a program that involves credentialed pharmacies, whatever that looks like, do we have some conflicts there with the pharmacies as far as them dispensing something that's not federally legal? Do we have some conflict there that might prevent some pharmacies wanting to do that?
I think you'd be hard pressed to find an attorney that would say that there couldn't be a conflict. However, I think what we have seen in practicality in other states is that we have not seen actors go after pharmacies that have been engaged on this. So let me give you an example. Louisiana has actually been running their medical marijuana program through pharmacies now since the outset of their program. My understanding is now that they are actually moving away from that and they are transitioning it to another agency. So it is moving away from the Board of Pharmacy and Pharmacies in Louisiana. I'm not an expert on that, but I do think, to your point, the potential exists in law for the conflict to be there because we have a pharmacy that is supposed to be complying with state and federal law that is then dispensing a Schedule I product that is not supposed to be in those facilities.
Right, so similar to the banking industry, right? So the feds say we're not going to go after the banks for states that have it legalized, but at the same time, the bank's like, well, I don't want to take a chance on losing my FDIC or, so they're like staying away from it. So we probably could run into that same issue with the pharmacies, especially the national chains probably. Could be difficult to find pharmacies willing to do that or maybe take that risk.
I think
Possible.
that's a valid point, yes.
Senator Thompson.
Hi, Alexander. Thank you. Quick question on the descheduling from 1 to 3. That seems like a big leap to go from no medical use to the same as Tylenol.
We have seen the DEA take some proactive steps in recent years, not just in this area, but in other areas, primarily to begin the if-then domino effect. So for a while, there has been a question about how much research or trial study can actually be done in the U.S. without further permission from the FDA to be able to take those steps and study those things so that the more products could potentially be approved. So I think potentially, and I can't read the mind of the DEA, I don't know for sure, but in similar conversations we've had with them about other proactive steps that they've taken, their goal is to allow the pipeline to start, and so that other medications could come in for new drug applications and then potentially be approved by the FDA.
One quick follow-up, if I could, Mr. Chair. I was looking at the cost and the ongoing annual contractual fees of $30,000 for the board with each vendor. Does that anticipate any cost of some of the vagaries of packaging that you mentioned? If that was not, I'm assuming the cost might go up.
Oh yes. No, I'll be very clear. The numbers that I've included for the cost are just for our inclusion of reporting into K-Trax. I have provided no other economic impact to the agency because ultimately I don't know what direction the legislature might go, and so I didn't want to speculate. But we had looked specifically at the inclusion of that product in K-Trax reporting, and that is the information that our vendor delivered in 2023. So that might be a little bit outdated.
And I think Marinol and Epidiolex, for example, I think they're 2 milligram tablets from what I understand.
That's correct. And they are, again, they've gone through that FDA approval process.
Okay. Thank you. Thank you, Mr. Chair.
Representative Kessler, you got another?
Thank you, Mr. Chair. Yeah, I was just going to kind of speak on the senator's topic there. When we're talking about going from Schedule 1 to Schedule 3, when you figure what's kind of in Schedule 2, that includes, products that are like fentanyl, that's a Schedule 2. Morphine's a Schedule 2. Methadone's a Schedule 2. All those are Schedule 2s. So the leap isn't, going from a 1 to 3 is not a big leap.
Mr. Chairman, if I might, I thought one of you might ask this question. I had included it in my testimony, but I'll just emphasize too that one of the questions we've been asked is if in this proposed rulemaking, ultimately the regular medical drug supply chain ended up dispensing these, what would prohibit a pharmacy from just choosing to become a marijuana dispensary? And I just want to clarify that under current Kansas law, there would be nothing. So our pharmacies are not required to do any functions. They're required to comply with the law, but if today a pharmacy up and decided they did not want to dispense antibiotics, they don't have to do that under law. So likewise, they could choose to only dispense antibiotics. I believe that would also be true with medical marijuana. So if a pharmacy, as long as they met the requirements of being a pharmacy, down the road, if they decided, oh, well, we're only going to dispense medical marijuana at this pharmacy, or we're not going to dispense medical marijuana at this pharmacy, that either of those options would be consistent with current Kansas law.
Any other questions? One that I would like to add, the FDA process, how long is the average timeline on something like that? You know, they change this, they go in. Does that take years? Does that take?
Yes, absolutely. Most do take years. I think we've seen some expedited. There are some factors that the FDA can move, fast track things. There are also allowances for individuals to be able to apply for access to a drug that's in a certain phase trial if they have certain end-of-life conditions or other terminal, and meet those very specific terminal requirements to be able to try a drug that is in the trial process. But yes, it can take years. I wouldn't be able to tell you an exact timeline.
Okay. Committee, any other questions? If not, Andrea, thank you for your presentation. Very much. Next, we got the State Board of Healing Arts, Susan Gill, Executive Director. Welcome to committee. Please state your name and title into the microphone, please.
Oh, I thought the light was on. I apologize. One of the bills talked about in one section a primary care physician, which for us at the Board of Healing Arts, physician is very, very specific term. And then later in that bill, it talked about a physician, an APRN, a physician assistant, et cetera, all being acceptable to recommend or prescribe. The board is not taking a position on who we think the legislature should allow to do that, but just that be clearly defined, who you feel should be allowed to do that. Please be clear on whether you feel that medical marijuana should be allowed to be prescribed or recommended using telemedicine. That will be very important and could have very different ramifications. Address, please, how a physician can or could revoke a certificate and under what circumstances. So in some of the bills, those certificates were good for, I believe, a year. What would happen if during that year a physician felt that that medication was being misused, or if the condition for which it was prescribed resolved? Most of the conditions aren't going to resolve, but if they did for some reason, or if the caregiver, some of them are, issued to caregivers. If that caregiver was no longer the caregiver or wasn't an appropriate caregiver, how do you revoke one of those? And then how are the dispensaries notified or informed that that is no longer a valid certificate? And then also just ensuring that you all are aware that passage of any bill will likely increase the workload of the agency and will very possibly require additional staff. And again, I'm not here to tell you all how to do your job, but just making sure that if there is passage of of a bill, we will very likely be asking for additional staff. And, you know, we sometimes hear through a separate budget process that we don't want to grow government. And if we're asking for additional staff, we're not growing government. We would just be right-sizing our agency to properly and appropriately implement the requirements of a bill that's passed. And so just making sure that, that you all are aware of that and that your other friends are aware of that as well. We want to make sure this is going to be a big lift, and I think it's going to be very public, and people will be watching how we do this, and we want to make sure that we're able to do this correctly and implement it appropriately and do it well. I also want to echo what the ABC director stated about realistic timelines, making sure that we don't just have a go live date and that we have to have everything completed, that we have realistic timelines for all of the agencies involved to make sure that we can get these timelines met and these requirements met. Otherwise, I think, again, you have my testimony. I would be happy to stand for questions if you have any.
Okay, thank you, Susan. Committee, we have any questions for her? Senator Thompson.
Thank you, Mr. Chair. Thank you very much for your testimony. One concern we heard in hearing all of these bills is, and a lot of these bills had a laundry list of every potential item that could be prescribed for, you know, pain, hangnail, I don't know, whatever. How do you possibly limit the scope of what a physician will prescribe this for as a state board of healing arts having an overview?
Well, that's an excellent question, and thank you for that. I think some of that will be up to you all, whether you want to list out in statute the exact ailments that can be, medical marijuana could be prescribed for, or if you simply want to legalize medical marijuana and leave that between the physician and their patient. I think that's a choice you all can make, because yes, I've read the list and it is quite lengthy. You know, you could certainly put other parameters.
Some of it's quite vague. I mean, to be honest.
I think one of them was chronic pain.
Yeah, chronic pain, for example, for one person has
Right.
a high pain tolerance, you know, whatever. The other question is with regard to the cost. I mean, that's going to be huge, I would think.
Honestly, it will depend. One of the bills that has been submitted in the past would have had a really significant fiscal note for my agency. One of them, really, I think we wrote a fiscal note of 0. It really depends on the bill. The one that had us issuing the certificates for the physicians and also the physicians submitting an annual report to us and for us to analyze those reports, and I think it had a report to you all annually from us of the analysis of their reports, that had a pretty high fiscal note. There was a bill that we didn't issue those certificates, and that one I think we had a 0 fiscal note, because then the only cost to us will be if we receive complaints having to do the investigations, and until we know how many complaints come in, we don't really know, you know.
And sorry, Mr. Chair, one last, and I promise I'll stop. Do you have any stats you could provide the committee with regard to the abuse of other medications and how it's tracked and traced, and, you know, how often it's followed up by physicians so that we know how it's being abused or not? Any information on that, I think, would be very helpful.
So if I'm understanding you, you want from us data on how many complaints and investigations and then discipline that we issue related to physicians inappropriately prescribing?
Well, no, physicians who prescribe medications such as an oxycodone or something like that, how often is it tracked and how often is it identified that the patient is abusing that? Because they may, in good faith, prescribe medication, but then that patient abuses that. I don't know if there's any stats on that.
So that would come into play with the Board of Pharmacy with the K-Track system that Ms. Blasey talked about. And we will occasionally, and I don't know the stats off the top of my head. We can try to get them for you. We will occasionally get complaints either from, sometimes it's from family members who will report that, you know, my mother, father, whoever, has been overprescribed by their physician or whoever. And then we can look into that. And if we get a complaint such as that, one of the first things we're going to do is pull that K-Trax report from that physician and say, like, what have you prescribed this person? Is it a reasonable amount? Is it not reasonable? Is this person only receiving prescriptions from one provider, or are they, you know, doctor shopping? Are they going all around? Which shouldn't be able to happen too much because those physicians should also be looking at K-Trax when they're prescribing. We sometimes will get them from, I think she mentioned the K-Trax Advisory Committee. They look at those K-Trax reports as well, and they'll notice like, hey, this person is, this seems suspicious, so they'll send them to us to look into. Sometimes there's a really good explanation for why someone's getting it, what appears to be an elevated amount of medication. But to answer your question, yes, we do look into them. I can try to find you some stats on that and get them to you.
Thank you. I appreciate it. Thank you, Mr. Chair.
Representative Meyer.
Thank you, Mr. Chair. Thank you for your presentation today. So I know you said that various versions of the bills have either been a $0 fiscal note to very expensive. Would recreational cannabis cost the Board of Healing Arts anything?
Likely not. And because I don't think with recreational there would be any mechanism for physician prescribing. So I'm without having seen anything, I'm going to say likely not.
Okay, just wanted to double check. Thank you.
Thank you. Thank you. Thank you for your time.
Yep. All right. Good morning, Senator Fagg and members of the committee. I, like someone else testified, was unsure of what I wanted to put in my testimony since there's not necessarily current legislation. So I'll just give you a brief overview of previous bills and fiscal notes and how our agency was impacted by those. So anyway, I'm Ashley Goss, Deputy Secretary for Public Health at the Kansas Department of Health and Environment. So over the past few years, several bills that have been pointed out have been introduced. Each bill is a little bit different legislation, of course, and involves our agency pretty similarly in most of them. So last year we heard about Senate Bill 555, which had given KDHE the authority to oversee cultivation, processing, distribution of medical cannabis in a pilot program, as well as conducting compliance and assurance testing. For that specific bill, the fiscal note for the first year would have been $3.5 million just for our agency. And then after that, it would be about 1.7 million SGF moving forward. Senate Bill 558 was also introduced last year that required the agency to register patients and caregivers, including issuance of medical identification cards, and lead a state advisory board for medical cannabis. So that advisory board would have been responsible for deciding, agreeing on what conditions medical cannabis could be prescribed for. The fiscal note estimated on that was 2.5 million in the first year and 2.7 in the second, which included more than 20 FTEs that would need to be added to administer the program. Other previous bills, as others have pointed out, have had multi-agency responses in them. KDHE has been present in the majority, if not all of them. We're frequently named in these bills to be the authorizing agency to certify eligibility of medical cannabis cards, card holders, register patients and caregivers, and issue the cards. So as mentioned, all the legislation in recent years have had certain things in common, specifically to our agency. We, for the most part, are responsible for overseeing the certification of the patient and caregiver identification cards. We, like the others, would need to add additional FTEs to administer the program, have additional database and technological capabilities for collecting and monitoring related to medical cannabis certification. And of course, they each, as I pointed out, have had multi-million-dollar fiscal notes. No matter the approach to regulating medical marijuana, KDHE would likely have some regulatory role. KDHE isn't aware of any role we would play should recreational marijuana be legalized. That's all I have to share with you right now. I appreciate the opportunity to provide neutral testimony to you. I am happy to answer questions. However, I do need to leave as soon as possible as I have to get to Kansas City for another meeting. Thank you.
Do we have any? Yes, Senator Alley.
I'll be quick.
Okay.
When you gave these estimates on what it's going to cost you, did that take into consideration the revenue that was going to be brought into when you give the fiscal note? Is that fiscal note just for your agency or part of the fiscal note for the overall program?
No, the fiscal notes are just for our agency. And if I recall correctly, don't have the fiscal notes in front of me. KDHE wasn't typically included in the revenue coming in to be made whole. So we had SGF expense or expenses only. No revenue would come back to us because we weren't the enforcement agency.
Senator Thompson.
I'll make it quick too, Ashley.
Okay.
Have you had any estimates of the cost to similar agencies in other states where they have recreational or medical marijuana? I'd be curious to know what the actual costs on the ground are from these other states.
For a state health department, for their role specifically?
Yeah, like a Colorado, like a Missouri, like a Oklahoma.
We can certainly look to see what information we can get. We have, over the years, as these bills have come forward, we have checked into other states to see what they're doing, where they're at, recommendations on different things. So let us check on that and get back with you.
Thank you.
Sure.
Thank you, Mr. Chair.
Okay. Ashley, thank you for being here today.
Thank you.
So next, last one for the first half, Mr. Leroy Burton from El Dorado, Kansas. Please step up and your title and organization, and welcome to committee, Leroy.
Now is it back on? Yeah. Do I need to start over? Okay. The toxic chemical exposures we have in the workforce deal almost directly with that of medical cannabis, of a medicine. We need to ensure the individuals are not exposed to harmful levels of toxic chemicals or harmful levels of medical cannabis. The principles of dosage, quality control, and safety that I've applied throughout my career are directly relevant to the management and regulation of medical cannabis. With that, I think it's critically important in medical cannabis regulations that dosage must be precise to ensure patients are neither under or over medicated. Quality assurance, QA, and quality control, QC, or in the industrial sector is managed by people like me before I was retired. Approximately, the measurements of the hazardous chemicals need to be measured, looked at, and make sure that the people that are using these chemicals use them properly and they are distributed properly. Some principles must apply to all of the cannabis regulations that might be out there, from cultivation, processing, and dispensing. All three of those need to be looked at and be part of what we're talking about. As I said before, I represent over 600,000 senior Kansas taxpayers. In the last 2 years, our senior-haired legislature has passed resolutions supporting medical cannabis. Last week, we had our annual meeting. We passed another resolution, and I think you should have a copy of that in front of you. And we are supporting a medical advisory board that would be put together by the legislature. We are asking for 2 seats for silver-haired legislators on that particular board, principally to make sure that the senior population, many of whom could benefit from medical cannabis, have a voice. We support dosing studies. We endorse the language from the Senate bill that has been proposed before, in that the Senate bill emphasized importance of the studies, and dosing is a critical aspect of this. If the doctor prescribes 5 milligrams, we need to be able to determine that we have 5 milligrams. If they prescribe 1 milligram, we need to make sure that we have that. There needs to be that kind of control present when you put this bill together. Cannabis must not be treated, or must be treated, as a medicine. It can't be treated as, we don't feel, as a recreational drug. This is a medicine that we're providing to individuals to help them with their needs. There needs to be strict guidelines. There needs to be good quality control. There needs to be consistency in everything that we do. There needs to be a proper delivery method, and there needs to be proper testing with these materials. Quality assurance and testing standards of medical cannabis facilities must meet strict quality assurance, quality analysis guidelines. They must comply with the Department of Agriculture guidelines. And to ensure cannabis for medical purposes, it must be free of contaminants, properly tested, and constant in potency. As I mentioned earlier, dosage is key to what we're talking about. Both in the industrial setting, we have to make sure if a person is exposed to benzene, toluene, whatever chemicals might be out there, we need to know how long they can be exposed safely to be able to do their work. And the same thing with medical cannabis. Dosage determines therapeutic effectiveness and patient safety. In conclusion, medical cannabis has the potential to greatly improve the quality of life of Kansas residents, particularly seniors who suffer from chronic pain, cancer, and other debilitating conditions. However, it is essential that this program be implemented with the same rigor and attention to detail that would be applied in any other chemical or pharmaceutical management program. The Kansas Silver-Haired Legislature fully supports legislation that ensures safe, effective, and consistent medical cannabis through proper dosing, quality control, and balanced oversight. Thank you for your time.
Committee, Senator Alley.
Thank you, Mr. Chair. Thank you for being here today. We appreciate that. In your professional opinion, how long does a program, starting from where we are today until we'll be able to prescribe this medication safely, how long does that take?
I think somebody's tried to answer that before today, and I think I agree. I know I agree with them. It can take years, it can take months, it can take weeks, but you have the ability. I think you're going to hear from some people this afternoon from some other states that have put this together. We have the ability to talk to those states to find out what is good, what is bad, and how things work. And we need to take advantage of those things because there is testing out there on dosage of these chemicals, what it can be used for what type of illnesses, and they can be shared with us, and we can be able to use those. But to start over, if we were starting it completely ourselves, I would say years.
And do you know about, I think you said, or somebody said 40 other states have some type of marijuana available to them. Do we know, do they have dosages, are there recommended dosages in their states?
I can't answer that. I don't know that.
Thank you.
Representative Heibarger.
Thank you, Mr. Chair. And Mr. Burton, thank you for being here today. I just had a comment, and just looking around, I think that our legislature is probably at least as silver-haired as your legislature, but yeah.
I wasn't going to go there.
Committee, Representative Kessler.
Thank you, Mr. Chair. I just want to make sure I heard you right, and I was going back reading your testimony. The last time you had a vote on this with your legislature, it was that 56-8?
In 2023, the
October
vote
23, right?
was 56-8, 8 or 9, and this year it was unanimous.
Thank you. That's what I want to get at.
Okay.
Committee, any other questions? Mr. Burton, I might ask you now, I want to make sure this, from what I heard there, you believe in no smoke?
Yes.
Just-
No smoking of any type, tobacco,
smoking, okay.
marijuana, whatever, none.
Okay, and then from your experiences, who decides the safe level? Is that an FDA thing, you think, that goes on?
I think it would have to be the FDA level. We would recommend that if there was a committee put together, that it be made up of a lot of different people, from the people that have spoke already this morning, to law enforcement, to legislators, and especially from the silver-haired legislature. This would be an advisory committee that would oversee all of the actions that would be going on, and be able to put the stamp of approval on what was going with this, to make sure that we had a program that was not conflicted by, by politics.
Any other questions? Leroy, thank you for your presentation.
Thank you.
Okay, we've hit the sacred hour of lunch. It'll be about 30 minutes long. I'd like to, first of all, say thank you to the people providing lunch today and also breakfast. And it was by the Kansas Consortium Group, which was Seabird, Silver-haired Legislators, Applied Therapeutic Solutions, Hollis Bioscience, Watlow Buddhist Association, Capital Lobby Group, Us Doing Us, Organic Nails, KC, Tina Hire Farm, and then Pho Vietnam OP, USA Protective Care, and Barbara Gilliam Trust. So I'd like to say thank you for that group. That's very helpful to us. We're going to take 30 minutes because we have a lot of things going on, and the food will be outside, so we will reconvene when we start up at 12:15. Thank you.
Good job, Mr. Chairman.
I was just told that there's some dessert over there on that black cabinet. I'm afraid to ask what that is at this kind of hearing, so. So if you get hungry, you can go up and.
Lotus cookies.
Lotus cookies, okay.
That's what I'm told.
Well, thank you all for being on time this morning. It's 12:15, so first off, we're going to have the Kansas Association of Chief of Police, Chief Darrell Atterbury, Legislative Committee Chair. Welcome to committee. You might state your name and stuff so we got it on the record. Make sure you push the button.
Got the mic on. I'm Darrell Atterbury. I'm with the Kansas Association of Chiefs of Police, Chairman Fagg. Committee, thank you for having me here. Right off the bat, I want to stress that we're still in opposition of medical marijuana in any form that's not approved by the FDA and the DEA process, the working together. To answer a question from maybe Senator Alley, how long it should take, probably about 5 years. I mean, it's going to take a while. If it's rescheduled from 1 to 3, from very difficult to do research, get authorizations to do research, to a 3 where they could do research to determine proper dosage, how much to be given, how often, what strain. And I don't know much about cannabis, I confess, but I've been told there are many strains and some are much more potent than others. And right now, the way it is and the way it's been in past bills, it's whatever somebody decides is they want, and we're not for that. So kind of got off track, but there. I want everybody to know that our hearts go out to people who are in pain, who are suffering from diseases where they think that this will work, but we don't think that the creation of a medical marijuana or whatever it might be called is the right way to go about treating diseases that do have FDA-approved treatments. We've seen an increasing trend towards legalization. I believe it's 37 states have some form. Only a few states don't. And if you include the CBD with THC that's authorized here in this state, I guess we're actually one of them that has some form of THC-based product legalized. One of the things I was going to start with, but I got off track, was that in the beginning, we heard, I was in the meeting, I was in the hearings, where the folks came in and said that CBD, the end-all, be-all is all we need. And then the next year it was, no, we're going to change that. We need THC in our CBD. And the incrementalism began. Okay? I think there's no doubt in anybody's mind that the end result is recreational, and we need to stay away from that as far as we can. But one of the next steps is the medical marijuana. And again, we are opposed to that. Even though there may be some good uses for it, we have some medications, Marinol, Syndros, Epidrolix. I'm probably not pronouncing those right, but they've been proven through studies through the FDA to have a use for different maladies. And we support that type of investigation to determine dosages and good uses for a product. One of the things that you ask us to look at and speak to you about today was veterans and the use of marijuana for PTSD and the like. And I've included a lot of this in my testimony, so please refer to that. But there are some things that the Veterans Administration has found that indicate that there might be a problem with CUD, chronic use disorder, by veterans. And some of those things include, it's not everything, but marijuana-induced psychosis, chronic bronchitis, lower life satisfaction and achievement, with heavy usage. This is for veterans. And psychiatric syndrome of cannabis use disorder. So a lot of negative effects from the use of cannabis by somebody with PTSD. And I've read so many research papers, kind of like Jason over here, he's read so many bills, trying to keep one separate from the next is sometimes difficult. But the common theme throughout all of those studies that I've read states the same thing. Marijuana use by somebody with just the slightest mental disorder associated with PTSD, it can exacerbate their problems up into include increased risk of suicide. So that's not something we want to see. And that is something that the VA is still studying. Many other organizations are continuing to study the use of marijuana products by veterans. And though they can have some temporary relief of some symptom, there is no cure that can be provided by use of marijuana or cannabis products. The other thing that was requested was about end-of-life care. And in the past, I've been before committees and testified that as an organization, our consensus was whatever you want to give somebody at the end of their life, you know, let's make them comfortable. And then for this hearing, I was doing research, and there's a study out by the National Hospice and Palliative Care Organization. And what I learned was I probably spoke incorrectly before. We should probably enter that very carefully because of the regimen of care for patients should be very specialized. And that's what it says in this report, a specialized treatment regimen, not somebody deciding what their dosage of marijuana is going to be because, well, it might contradict with some of the other medications they're taking for their whatever malady they have that's causing their condition. So that was for smoking. You know, they have a depressed immune system. And the smoking of marijuana, although it gets in their system faster, or vaping, could actually cause them to have a lung infection because of their immune system. Gummies or something that's eaten takes longer to get in the system, but many people they found in this research, they end up throwing it up. So it's not useful for them. And then, of course, the contradictions with the other drugs that they take. So let's see. The passage of anything having to do with marijuana is going to cause law enforcement some issues. I kind of liken it to when you pass legislation, you think you've done the best job you can do, and kudos. Many times it works out really, really well. But sometimes, and after 43 years in law enforcement, and all the bills that I've read, and looking through, sometimes line by line, to see where there's going to be a problem, I see this as a train wreck. I mean, whether it's medical marijuana, recreational, it's going to be a train wreck for law enforcement. The KBI, they take care of our state. I take care of one small city. We've got somebody giving testimony, they take care of a county, but the KBI takes care of the whole state. If anything were passed, there has to be an extraordinarily large sum of money set aside for the KBI to have more agents, more equipment, more lab testing equipment, more scientists, so that enforcement can be done in a way that I think you would like. So just keep that in mind. Okay, so the Board of Pharmacies, I believe it was, touched on packaging. We are still seeing packaging that is attractive to children in the products that we find on the street, and we're finding a lot from other states. That certainly going to need to be addressed. Where this product can be sold, it was suggested that if it moves from Schedule 1 to Schedule 3 and it can be sold out of a pharmacy, why are we having this hearing? Okay, that's something for you to consider also. There's going to have to be a different hearing, but it wouldn't be this one because we're still going to have problems on the street enforcing whatever is passed because of the law of unintended consequences. It's going to kick in. So some of the other areas, one of the other areas that we have a concern about is how you're going to treat, for instance, law enforcement. Some officer, fireman, EMT, doctor who has a medical marijuana card or uses medical marijuana. I don't know about you, but if my doctor just took a hit out in the garage or in the parking lot, I don't want him treating me. If I've got an officer who's got some problem and they're using marijuana, I don't think that with some level of impairment, they should be carrying a gun, driving my car, huge liabilities for us. And those are things that need to be thought about and included in any bill moving forward. So, pardon me. Have I hit about 10?
Yeah. I don't know where we're at.
Oh, well, I'll just stand for questions.
No.
Because there's
You got anything else, though?
oh, these guys have more.
Have to. Okay.
Oh, I do want to include something else.
Sure.
I put stars around it.
Okay.
So, I was contacted by somebody, and they pointed out, I told them what I was doing today, and they were a bit irritated that you don't have somebody from schools included in this discussion. Because all those kids that go to schools, once they pass the threshold of that school, they're taken care of by the school administration, teachers, and so on. And every single day, there are vape cartridges taken away from kids at school, and some of these are like 98% pure, refined vape cartridges. And they're getting them through the mail, no real problem for them to get them, but that type of thing is what the schools are seeing today, let alone the botanical substance and other drugs. But just speaking about marijuana-based products. So I wanted to toss that out.
Well, so I want to say thank you because that's the way we separated these dates so that
Okay.
I can try to address that.
Okay. I'll stand for questions.
Okay. Committee, got any questions? Representative Eliza.
Thank you, Mr. Chair, and thank you, Chief, for being here today, and thank you for all you do for our community. First, that study you referenced about hospice, what was the name of that study again?
It is in my testimony because I slipped it back in here.
If it's in the testimony, I'll.
This is a document. It's from the
that's
National Hospice and Palliative Care
okay.
Organization.
Yeah, I was just wanting to look that up so I can.
That's on. It's going to be in the notes on page 2, I believe.
Awesome. Yep, I will dig that up. Another question I had is about the CBD shops we see. You might see those in your town. I know Wichita, I see them. I believe there's one that's called Kansas's First Dispensary or something there in Wichita. I drive by pretty frequently. The THC levels and the CBD in there, do we regulate those? How do you guys enforce this?
You regulated that.
Okay.
When you passed the bill to allow 0.03 THC in the CBD.
So how?
So we can enforce it if we can determine how much is in the CBD.
Yeah, and that was my follow-up, so yeah.
So for me, I would look on the package. If it says .03, that would be legal. I don't know that there's actually .03 in there. I believe Kurt Thompson, with the previous director of the KBI, sent agents out at one point and was able to collect some, and it ranged. I don't know what the range was, some below, some above. So I don't know exactly who is doing the enforcement for the CBD. I know that you used Wichita as an example. That's probably not the best example since they decided not to prosecute that simple possession.
Yep, nope, I am very familiar with that. That's all I had, though. Thank you, Mr. Chairman.
Representative Heibarger.
Thank you, Mr. Chair, and thank you for being here. It seems to me I've heard that marijuana use among adolescents is trending downwards. Is that not accurate?
I can't tell you whether it is or not, but there's a website. It's samhsa.gov, and it's the Substance Abuse and Mental Health Services Administration, government organization. They have, I looked at the report a few days ago, and it's like 300 pages long, and it includes marijuana, alcohol, teen use, use by elders. Yeah.
Okay. Any follow-up to that? Okay. Representative Carpenter.
Thank you, Mr. Chair. So how's law enforcement evolved over the last period of time with us being literally surrounded by states that, well, on three sides, actually. Two are recreational, one is medical. So how has law enforcement evolved in that environment?
Part of this is going to be, direct answer, and part's going to be philosophical. What we do is when we find somebody with marijuana, we enforce the law as it is now. Okay. In my city, somebody wanted us to not enforce a speed limit in front of a school because their neighbors got tickets. And well, this person happened to be on my council. And I said, well, if you make it a 30-mile-an-hour speed limit, we'll enforce 30. If you make it 55, we'll enforce 55, because that's what we're tasked to do. That's what our oath is. We're here right now to try to get you to not go to 55 and not go to 30. We're trying to not have a change from the current law that we have today. So what we do in most of Kansas, outside of Wichita, is if we find, and a few others, yeah, but I'm right next door, is that when we find somebody with just user amounts, we determine whether or not, the officer determines whether or not they're going to make an arrest. That's their discretion. If they determine they're going to make an arrest, they write out a uniform criminal complaint, they serve it on the person, and they have a court appearance, and then they go before the judge. If they have more than user amounts for distribution, then we make that same arrest, and it goes through the district attorney's office, and they're charged, and we go through the district court process.
Very good. Thank you, Mr. Chairman.
Okay, we got one final question. Senator Holscher on WebEx.
Thank you. Actually, Representative Hoheisel asked my question, and unless you'd like to elaborate, Chief, it just sounds like while we have these defined levels of THC for products, it's not being enforced, though.
Well, there's only...
Because the packaging, I mean, it doesn't really matter what the packaging says. It's more about the product.
Well, the only product that we would enforce would be the CBD with THC.
Yeah, that's what I'm talking about. When you go, we're talking about that just a couple minutes ago.
Well, it's kind of the same with weak beer and strong beer. If it's 5%, we take it as being 5%. If it's more than that, we take and read the package, and that's what we trust the manufacturer has put in that container. So enforcement, if we went and found a bottle of CBD and it said 0.06, then we've got a different story. But if it's 0.03 on the packaging, it would be like the 0.05 on a weak beer.
Okay, thank you.
Okay, we're going to have to keep moving here. Thank you very much, Chief, for being here. Okay. Next on the list, we have the Kansas Peace Officer Association, Chief Brad Moore, Vice President. Chief, welcome to committee.
Thank you all. It's a pleasure to be in front of you again. Had the fortunate experience last spring to be here with you all, so thank you all for having me. Chief Brad Moore with Kansas Peace Officer Association, Vice President. I wanted to focus on a few elements here. Some of mine has to do with the rescheduling of this drug. So, you know, the DEA has taken a stance. It sounds like that's what they're kind of leaning towards at this point. But should it be rescheduled, the DEA then has to register approximately 15,000 dispensaries across the United States as pharmacies. Now, I'm not going to get into the pharmaceutical side of things. That's not my expertise. It's more of what we're talking about today with the rescheduling. But the manpower that would consume to get that re-registered, to have the inspections, do the things necessary to turn these head shops into basically pharmacies at that point would be astronomical. Not only that, but you know, you factor in the criminal elements surrounding the production, sale of marijuana that we've seen in every single state that has legalized it, from Colorado to Oklahoma. The cartels coming in, the black market industry booming based on legalization. You know, that's an even bigger problem. Nobody wants to pay taxes when it comes to this type of stuff. So, yeah, you know, we look at the money coming in, we look at the revenues coming in, the $900 million that Nebraska could see or whatever. Yeah, that's shiny and gold, but at the same time, you know, that opens the back door to avoid that tax, and there's always a market and industry for that. So that's a big concern. You know, the idea of rescheduling marijuana is partially based on the fact that it has less potential for abuse than some of the nation's most dangerous drugs, if you will. On the contrary, we looked at a study and some statistics from the Midwest High Intensity Drug Trafficking Area, HIDTA, out of North Dakota. We found in that legalizing marijuana caused a 336% increase in marijuana-related emergency department visits. This study, or these statistics, come from back in 2016. The numbers in 2016 were 556, and that was prior to marijuana legalization as far as the medicinal side. In 2023, the number of visits was reported at 2,424. And 2016 is when they voted to legalize marijuana for medicinal purposes. The law was put into effect in 2017. Those two stark contrasts, excuse me. In looking at this data, consumers felt it was necessary to seek immediate medical attention. That doesn't sound like a less potential for abuse than the nation's most dangerous drugs, as quoted in the initial reason for changing that. This is only one state. The strain on the medical system is one more reason Kansans can't afford medical marijuana. Rescheduling would also potentially cut federal taxes that companies pay, as Mr. Long over here, Jason Long, reported on. Yes, our federal government does tax what they've deemed illegal. It's taxed under trafficking, is the way they listed it. So if we change that from, you know, Schedule 1, Schedule 2 down to the Schedule 3, now those entities can deduct rent, payroll, various other expenses, and other business write-offs. And one group, one industry says the tax rate often ends up to be around 70% or more based on that. If marijuana is rescheduled, that also opens the door for FDA testing, which is what we've been looking for a long time, is to find, you know, the exact sciences and the exact derivatives and the exact things that are the medicinal side of this drug versus just opening the door and doing medical marijuana, or as some of us refer to it, recreational light. Because as in Oklahoma, you know, medical cards are a dime a dozen. You pick one up and now you've got a free ticket to any head shop down there. So Regulation is very, very important. Other issues that are going to come up with this rescheduling is potential pardons or expungements of marijuana-related offenses and crimes. As testified earlier, some states have kind of dabbled in that. I didn't do the research on that side of it, but our court system is strained as it is. So, everybody's going to apply to get that diverted or taken off expunged off of their record. So we're going to add another strain on the court side of things. It's not hard to see the correlation between violent crime and the drug industry. That's very blatant and obvious in our neighboring states. As spoken on before, the legalization of a drug does not lower crime rates. It will not. In fact, it will increase them in the form of illegal grow operations and distribution under the ruse of prescription. It's not hard to get the prescription card, go get your container, use what marijuana you purchased, so-called legally, and then just fill it with black market product after that. To show that you've paid your taxes and you've got your prescription marijuana at that point. We've got no way to prove that out in the field. We've got no way to say, well, this is prescription marijuana versus black market marijuana. There's no way for us to dictate that. There's no way for us to test that. There's no way for us to know. So when people do that, we're just left trusting that that's not illegal weed, illegal marijuana. In Oklahoma, the statistics out of there are they're astounding. Bureau of Narcotics has shut down 800 illegal grow operations in the last 2 years, arrested 200 managers and cartel lieutenants, seized more than 600,000 pounds of marijuana destined for the black market. Out of 6,200 grow farms, 3,000 are under investigation at this time. This brings in more human trafficking, more money laundering, more violent crimes, international black market ownership, as we've already seen with the issues they're having out of China. We already have an issue with U.S. foreign entities buying cropland and using them for illicit purposes. I don't want to see that in Kansas. Anybody who travels to Oklahoma typically will probably take I-35. You drive by Blackwell, Oklahoma, and you get hit with that odor. That's a quality of life thing. I take my kids and my family on vacation. I don't want that in my home state too, driving down the interstate and my kids are asking me why it smells like a skunk. We know what it is. Any other city down in Oklahoma, you drive by with your windows down because you're enjoying a cool spring day and you got a car goes by you and you just get the pungent odor. It's not conducive to the state of Kansas, I don't believe. Kansas law enforcement is going to face many challenges in this. Staffing, funding, we've already talked about all that. I don't want to beat a dead horse up here, but this has been a long road to get to this point where we're at. And as we've always had a stance, we continue to have a stance. The Kansas Peace Officers Association is against any legalization of marijuana, medically or recreationally. So I'll stand for questions.
Okay, thank you. Committee, you ready for questions? Okay, Senator Thompson.
Thank you, Chief. Appreciate it. I've heard, particularly in Oklahoma, where these cartels are coercing and threatening landowners so they can purchase their land for use for their illegal grow operations. I'm just curious what you've heard in that regard from other states like Oklahoma.
Yes, sir. So Colorado, similar in shape and size, they lost out on a lot of rental properties. When it became legal over there, the cartels and the industry bought up rental houses, boarded up the windows, taped up the windows, and turned them into greenhouses, thus driving up cost of living there in Colorado. Oklahoma's seeing the same thing. More right now, they're dealing with straw purchasing, which is similar to what you would imagine in firearms industry. They find somebody on the street, say, hey, I need you to sign these papers. We're going to go ahead and make this purchase under your name, but it's actually under the control of another entity, typically foreign, doing those things. The Oklahoma Bureau of Narcotics has many, many cases on individuals of that own, 20 or 30 operations, got nothing to do with them. They're indigent and living on the streets because they got offered a couple $100 to sign a piece of paper and it went through. So the black market is very, very strong in those industries or in those states, and the cartels and the drug enterprises are definitely coming in and taking control very quickly once legalization takes place.
Just one quick follow-up, and I've also heard with regard to those houses being purchased in neighborhoods right next door to somebody, The high humidity content in those grow operations, they have a huge black mold problem inside those houses, and they have bought the house after that, after the operation's been exposed and they've been kicked out. But then people will come in and flip that house, won't clean it up, and you've got some problems there too.
Correct. Yes, sir. Yes, sir.
Okay, we have a question on WebEx from Senator Holscher. Go ahead, Cindy.
Thank you, Senator. Not a question, or if you want to elaborate, that's fine, but I do think it needs to be pointed out. I mean, Oklahoma gets cited as an example in regard to problems with implementation. But like I said, I think it's very important to point out that their program was implemented via petition as far as voters. It didn't have legislation in terms of guardrails put in place, which obviously is very different in terms of the scenario as far as what we would be doing. We would be putting rules in place and those guardrails. So I just want to point that out for anybody listening in, that, I mean, it's kind of an apples to oranges comparison when you cite Oklahoma.
Yes, and if I can reply to that, sir. Kansas is one of the last frontiers. We are one of 3 states right now. In my vision and what I view of my state, worst case scenario, if this does go through, we have a responsibility to make sure that it is done, I'll use air quotes, correctly. We've got case study after case study after case study all the way around us on how these have turned out, the shortfalls, I wished I would have looked at this, I wish I would have researched this. So if that is the way that our state decides to go, I can't stress enough, please do the due diligence, do the homework, do the studying, take the 3 to 5, 10 years, I don't care how long it takes, to make sure that we don't end up like our neighbors.
Representative Kessler.
Thank you, Mr. Chair. Yeah, I agree with her. I mean, I think everybody in this room probably agrees that Oklahoma did not do it the right way, that it's a disaster there. I don't think anybody in this room will disagree. I see all the heads nodding. Nobody will disagree with that. Bad example there. But one of the things I was kind of under the impression, and I can't really cite why I was under that impression, but when Colorado went medical, talking to people in Colorado, I was under the impression that squeezed the black market almost completely out of the state, where they just stay on the highway, go right through Colorado. Is the black market situation that you referred to in Colorado, did that transition just since they went recreational, or was it always there even with medical? Because I was under, like I said, I was under the impression that when medical hit, that squeezed all that out.
I haven't seen a study on the black market industry getting pushed out per se. But if we look at pricing, taxation, all of those things, it would make sense that the black market would actually open up because you're avoiding those taxes. So again, the idea that you could get a prescription, obtain an ounce of prescribed marijuana, use that ounce in the week that you need to, and then turn around and get it at 35% reduced cost from your neighbor down the street or your cartel member, whoever it is that you would purchase from, restuff the same bag. Law enforcement has no clue. You save 35% on your prescription, I guess, if you will, and carry on with your business as usual. That opens up that industry. That opens up that market. So I don't see it being pushed all the way out, but I don't have any study to back that. So
when you were talking about that, I was just curious if you knew when it was medical only versus rec, if there was a difference there. If so, kind of what kind of brought that along? That was kind of my point I was trying to get to. Thank you.
Yep.
Chief, I got a quick question. Do you belong to a national association of peace officers?
Yes, the Kansas Peace Officers Association. No, not the NAC.
Now, that's Kansas. Is there a national?
Not the national, no, sir.
Okay, all right. When you talk about Oklahoma, is Oklahoma medical today?
It is medical today, yes, sir.
It's not recreational?
It's not recreational, no, sir.
So did the people vote on it not to be recreational down there? What was the vote for? Was it for medical? I was just trying to get that straight of what happened.
I believe it was medical, yes, sir. It was to vote for medical. I believe so.
Committee, any other questions? Okay, thank you very much.
Yes, sir.
Okay, next on the list, we got Kansas Sentencing Commission. Sheriff, no, okay, I'll jump the bill, sorry. Let's try it with the Kansas Sheriff Association. Scott? Sheriff, please state your name, title, and organization.
Scott Brown,
Make sure the
Sheriff.
button's pushed.
Oh, it's on.
right, thank
It's on. Scott Brown, Sheriff of Ellis County, President of the Kansas Sheriff's Association at this time. Thank you for having me, Mr. Chairman, and look forward to, I had a whole list of things, but by the time you're the third one in law enforcement, they pretty much covered everything, so I'll try to keep it short for you, okay? So the Kansas Sheriff's Association is, if marijuana is passed, we've believed in a long time that it should be monitored through the pharmaceutical side of it. So that way, when people are receiving marijuana, they know the dosage, it's controlled. Not everyone can just walk in there, not buying it off the street corners and those types of things. So our stance is we're opposed to it unless those types of things come in place to make sure that pharmaceutical is controlling the legalize the marijuana side of it, okay? So agriculture has hemp right now, and they're in the state of Kansas. And we support that, but we are cautious that we don't allow it to become legalized and by expanding upon the hemp usage of that. As long as it stays within the tolerance of our hemp, we're in support of that. So we don't want our agriculture to think that the Kansas Sheriff's Association is against that by any means, because we're an agriculture state and we need to support our farmers because they pay our salaries. So in regards to Oklahoma, you guys addressed some of those issues, but I will throw something out, some numbers that we had obtained. But when it passed, there was 8,000 grow operations that turned up in Oklahoma. Currently, the Oklahoma Bureau of Narcotics has shut down over 5,000 grows for the simple fact of they were meeting people on the street corners and they were having them sign paperwork and to obtain the ground because they had to have that in order to do so. One of the myths that we're hearing about is the opioid, that marijuana decreases the opioid. In reality, there are several studies which were cited within the documents you guys should have had that contradicts that. It actually increases the use of opioid use. And so that is a false statement. Another study that was conducted, published in 2019 in the National Academy of Science, America found that states that pass medical cannabis has seen a 22.7% increase in opioid-related deaths. We already have enough of an issue with opioid issues. So just please keep that in mind. When marijuana was out in the 70s, when it was being grown in the ditches and all over, it was like 5%. Now, they've definitely come a long way with that. We're looking at anywhere from 30% purity to 98% purity within the THC count. And that is concerning, especially for our young people. And we talked about gummies, we've talked about all of those. The thing about the gummies that are being manufactured is really don't know what the count is in there. Consequently, our young people who like the gummies and those types of things, they take one, they don't have a reaction, so they take another one. And then pretty soon they take another one. So the thought that you can't overdose on marijuana is incorrect. I think there are several studies out there that will show that you can. And there have been numerous medical calls, ER calls, people taking their touch and go. They need a medical profession. We believe that the 35% threshold is way too high. We believe if we did it under the pharmaceutical side, that it would stay well below that, and to ensure that people aren't overdosing and those types of things. One of the main issues that I would like to talk to you about, I've repeated some of the things that they have talked about, but since I'm a sheriff, I got to talk about a jail. Okay, so jail is one of our big concerns. So if it's legalized, we have a couple of issues, and I'm just going to read this paragraph for you. A big concern we have is what happens when a person with their medical marijuana certification lands in jail. Will we be required to provide federally controlled substance to them? Will we have to buy it for them? How will the courts rule on this? By calling it medicine, they're probably going to rule in favor. It opens a can of worms for the sheriffs. Or will we be exempt from doing it since they're within our facilities? Enforcement issues. You guys talked briefly about enforcement issues that we had. So we're going to talk about a few. As we all know, many of you probably have within your community canines. And we spend a lot of money on canines. I know this. I have one within, and I was a canine handler for many years. And so when we're buying canines, most of our canines right now are trained on marijuana because it's still illegal in the state of Kansas. The courts throughout the nation have ruled that if a dog is trained on marijuana, even though it's legal, and hits on the car, that they're throwing out, if there was meth in that vehicle, heroin, whatever it might be, they're throwing that out. So it's creating a problem. So our concern is our average canine costs about $20,000 by the time they're trained up. We're estimating that we have the number, about 85 to 90% of the canines in the state of Kansas are trained up on marijuana. So we would ask that, should this pass, that there be some funding, a grant process, so that we can, as small departments, can afford to replace those canines because they're a valuable tool for us. Issues identifying a medical card, and we kind of talked about that. There were several. The medical card is an issue because we're on the side of the road. Speed up. Okay, sorry. I've been known to talk a lot, so I'm sorry. Medical cards on the right side of the road. We need to establish a way that we can access that 24/7. If we can't access it, we don't know what to do. We'll probably have to seize that particular thing. And then last, the limits, the THC content is just way too high. We need to control that to save our kids, our public, so we don't have overdoses. I'll rest.
Okay, thank you for your presentation. Committee, got any questions? Senator Alley.
Thank you, Mr. Chair. And you mentioned marijuana in jail, and if it was legal and it's declared a medical, you'd have to provide that to them. Is there any evidence from other states that have made this legal? Is there evidence they do that in other states?
You know, I can't answer that. I don't know. I haven't really asked too many questions about that because we haven't been there. But when I leave this meeting, I'm going to start asking questions.
Senator Thompson.
Thank you, Mr. Chair. Thank you, Chief.
Yes.
A quick question with regard to industrial hemp, which we have and is legal in Kansas right now. Are there enforcement issues with that with regard to hemp in cigarettes, cigars, teas, any other products? Have you run into any of that?
Because it's not my area and I don't know that I actually have any hemp fields within my county, I think it's the next county over. I'm not sure I can answer that. We in Ellis County have not, so.
And I'm guessing you're talking to other sheriffs around the state.
Mm-hmm.
Are you seeing the most issues with marijuana in the border states surrounding, and then not so much in central Kansas? I'm just curious.
I feel like I'm a border state because I'm right down I-70.
Oh.
So that comes out of Denver, and I can answer that question. It's still being sold through the black market on the backside, and they're bringing it into Kansas.
Thank you. Thank you, Mr. Chair.
Representative Heibarger.
Thank you, Mr. Chair. This is just a follow-up to Senator Alley's question. If you have an inmate in your jail now that has a prescription for an opioid, how do you deal with that?
We have a nurse that is we hire, and they use other drugs to counter that, whatever their need is, based on a doctor's recommendation.
Okay, on WebEx, we got Senator Holscher. She's got a question. Go ahead, Senator.
Thank you. Mine just kind of piggybacks on that last question. So we have a system in place for distributing medications to our prisoners, correct?
You would be correct.
Okay. And I mention that because obviously the other states that have implemented a medicinal cannabis program have found a way to address this issue. And I'm guessing it's probably along the same format for regular medications.
Yeah, most facilities, not all facilities in the state of Kansas have a medical provider that provides the pharmaceutical medicine that they need, so.
Right. Okay. But obviously, we do have a system in place to get medications to prisoners. Thank
Yes,
you.
you're correct.
Okay, a question I have, do you belong to a national association?
I do.
Okay, do they take a stance on this?
You know, I don't know what their stance is. It hasn't come up. There's been some other things that have come up that I'm aware of, but this isn't one that I've seen, so I apologize for that.
No problem. Representative Gessler.
Thank you, Mr. Chair. Just to kind of go back to the whole jail comment here, just for a second here. I don't know, back in my head, I just keep thinking that, like, you might support part of this, because if we legalize part of this product, especially people that have small amount or small use or individual personal use marijuana on them, I mean, that could clear out your jail, right? I mean, that could clear out a pretty good significant portion of your jail, reduce your overhead costs and stuff like that, and give you more time to do other things.
Sure. I will tell you, and I only speak for the county that I'm in, we do not have personal use people within our facility. They may be arrested and post bond or a long form, but we don't. If they are distributing large quantities of marijuana, they may be within our facility. But small quantities, no. And I would say, I'm going out on a limb here, but I would say the majority of the jails across the state of Kansas do not have a lot of people in jail on marijuana.
Representative Paul Zeiser.
Thank you, Mr. Chairman. I just want to follow up on that. Why is that?
Because we are limited our jail space, and we have more serious crimes, person crimes, and those types of things. I'm not trying to downplay the importance of enforcing marijuana laws. I'm just saying that we have dangerous people that need to be within our facility.
And I don't dispute that at all. And thank you for what you do, arresting these violent people. I guess the point I'm trying to make here is, we've heard a lot of bad stuff today about how bad marijuana is, what it does to people. We have claims of it sends them into anger and rage fits and causes violence. But when they are in possession of it, we're not arresting them. So, no, I'm sorry. It just seems to me like we're saying it's serious and this is a very bad thing, but it's not quite bad enough that we need to arrest people if they have possession of it.
A simple possession, more than likely, is not being arrested at this point in time. Part of that is because of the courts. They have final say, and prosecutors, depending upon your prosecutor within your community. Secondly, as I said, we're all limited with the number of beds we have, and so therefore the courts are letting them out on corrections. They're being supervised, court services, those types of things. And when they violate, they end up back in there. But originally, they may not be within our facility, if that helps you.
I think we do have the sentencing commission there coming up later, but I believe if we're writing them a citation, what are we looking at? $50 ticket, $120 ticket, maybe some court costs.
It's probably about a $400 to $500 ticket.
So, but it's a monetary most of the time, especially on first offense, if it actually even goes through.
Correct.
I assume in some of these cases, local district attorneys don't even bother. They're just, whatever.
Yeah, it depends upon the attorney. You're correct.
So it seems to me it's kind of out of balance to saying this is a horrible thing, that this is what it's doing, but yet we're just not going to enforce it. I guess that's where this issue kind of gets me, is it doesn't really make sense to me that if it is a bad thing, I would think that we would want to enforce, because now everybody knows we're not going to do anything about it if you have possession of it.
What I would say is that law enforcement enforces it. Where it goes from there, we have no say.
Well, I mean, if somebody, what county were you from again, sir?
Ellis County.
Ellis County. So if I'm in Ellis County and I have, I'm not good at weight, so what, under an ounce of marijuana on me, we'll call it personal use.
Nope, we won't.
You will not arrest me?
That's a distribution.
Okay, what, I guess I'm ignorant to weights and.
Little, I don't know.
We'll say just a gram. We'll just say
there you go.
There you go. Whatever. Okay, I have a gram of it in Ellis County, and you pull me over.
Sure.
Can you take me to jail for that?
Yes, you've committed a crime, and we can take you to jail.
Okay, but you guys, every time if there's not something else involved, you usually just write the ticket?
Right. We would call that a long form system, and we'd send it to county attorney for review and how they want to proceed.
Okay. Thank you. Thank you for all you do again, sir, and thank you, Mr. Chairman.
Okay, we're running behind, Sheriff. Thank you very much for your presentation.
Thank you. I appreciate it.
Okay. Now we'll go to the Kansas Sentencing Commission, Dr. John Gerby. And then I think also the Executive Director, Scott Schultz, will also be here. So welcome to committee. You might state your name and organization title again for the speaker. Make sure the button's on.
Well, my name's John Gruby. I'm the Director of Research at the Kansas Sentencing Commission. I'd like to acknowledge Representative Heiberger, who's a long-standing member of the commission, and we appreciate all of the work that he's done while at the commission. You should have my materials with you. That includes both a prison bed impact statement as well as my written testimony. For those of you who don't know, the KSSC is the State Statistical Analysis Center as appointed by the Department of Justice and the Bureau of Justice Statistics. Additionally, we collect all data on felony convictions across the state and use that data to help inform policy decisions by the legislature. As most of you are aware, the KSCC prepares prison bed and admission impact statements for all bills that are related to criminal justice. So I'd like to thank you guys for having me here so I can give neutral testimony to the medical marijuana bill that may come forward. As you'll be able to tell from our prison impact statement in your materials, it's very difficult for the Sentencing Commission to make a determination as to what level of impact making marijuana medically legal will have. That's because the KSSC can't predict with any level of certainty the number of individuals who would be arrested for marijuana possession in the future that will have those medical cards or prescriptions. For example, we don't know if it's going to be easy for recreational users currently to get a medical card. Last year, the average age of felony marijuana offenders was 31. Is that going to limit medical necessity? Is it going to make that difficult for those who are using marijuana? Is it going to make it difficult for them to get a medical card? If they can get a card, and that's not difficult, and age isn't an issue, you could make an assumption that it is going to have a impact on prison beds. It will reduce the number of people who are going to prison. If they are not able to easily obtain a medical card, it's going to be difficult for us to determine that there would be any impact from medical marijuana legislation. It's likely that those numbers will remain the same. And in the impact statement I prepared for you, you can see that there were 260 felony marijuana convictions last year. That's in comparison to 4,782 arrests for marijuana. So you know, in order for it to be a felony, it has to be a third or subsequent conviction. I did also provide a breakdown of by severity level for all of the marijuana-related convictions. Based on those numbers, it would demonstrate that those who are being convicted are very, very likely to end up with a probation sentence. In fact, only 41 people were sentenced to prison this last year. Another issue with us being able to give an accurate impact statement is that if it is legalized medically, we don't know what law enforcement, both field level law enforcement, police officers and sheriff's departments, and then also district attorneys' offices, how are they going to continue to enforce and penalize marijuana convictions in the future? Obviously, states surrounding Kansas have legalized marijuana in some shape or form. I did provide, or I do have numbers from Missouri just for comparison. In Missouri, you can have 3 ounces of marijuana. That equals 85 grams. For those of you who are wondering where that falls on the Kansas sentencing grid, that is a level 3 felony in Kansas. So what's legal to possess in Missouri would be a level 3 presumptive prison sentence in Kansas with a sentencing range of 46 to 83 months. I also understand I'm not a Missouri legal expert, but it is my understanding that if you have over 3 ounces in Missouri but less than 6 ounces in Missouri, it is still a non-criminal civil penalty with a $250 fine, is what I have found in my research. But like I said, I'm not a Missouri expert. For comparison, Colorado, it's a 2 ounce is legal to possess, which is 56 grams. That's still severity level 3 felony. Michigan is 2.5 grams for comparison, and California and Illinois, those are both 1 ounce possession for recreational or medical use. With that, I would be happy to answer any and all questions that you might have.
Senator Thompson.
Thank you, Mr. Chair. Thank you. Quick question on the findings on the arrests, for example, on marijuana-related offenses. Are those strictly marijuana offenses, or is that marijuana along with other crimes?
Those were offenses that were labeled from the KBI database as arrested for marijuana. I don't want to dig too deep into the KBI data. There could be other charges, but those were specifically for charges that included marijuana.
So what I'm trying to get at, I guess, is in states where marijuana becomes legal, a lot of times you don't have any tracking of where marijuana is involved with other crimes. Say if they were arrested for another crime, but marijuana is involved, we're not getting the data. Is that data available here in Kansas where it's say some kind of robbery, but they also had some marijuana crime involved?
If it ends up being charged and convicted, the Sentencing Commission would have that information, so long as there is a felony involved, and it's even if it's a misdemeanor marijuana conviction, the Sentencing Commission would have that information. If it's all misdemeanor, the Sentencing Commission will not have that information readily available.
All right, thank you, Mr. Chair.
Representative Holohizel.
Yeah, just one quick question to piggyback on Senator Thompson. That KBI data, was that charges or convictions?
Those are arrests.
Just arrests, not convictions?
Correct.
Okay, thank you. Thank you, Mr. Chairman.
Okay. Got another question? Okay.
Thank you, Mr. Chair. Hey, thanks for being here today. In your testimony, I just wanted to touch base on this here just a little bit, where you noted that 68.3% of all offenders sentenced to prison have a criminal history of D or higher. I don't know what a D or higher is.
D or higher would mean that you have at least 1 person felony in your background. So 1 person felony conviction in your background would make you a D. C would be 1 person, 1 non-person. B is 2 person felonies, and A is 3 person felonies. So almost 70% of the folks who had a marijuana felony were had at least 1 person felony in their background, which might also be indicative of why potentially they were sentenced to prison, because based on our numbers, even at severity level 1, which just for reference, we had 1 severity level 1 last year, which is 30 kilos of marijuana. That person got probation. It could be that it's based on their criminal history that is really driving. You've already been in trouble perhaps multiple times in your past, and you've screwed up again. Perhaps they're less willing to plea bargain that down to a probation sentence due to their criminal history as opposed to the charge itself.
Last question, Senator Alley.
Thank you, Mr. Chair. Any states that have marijuana today that's recreational, do they also have medical? Is there a medical and recreational, or if it becomes recreational, is medical relevant at that point?
It's my understanding that Missouri does, but don't quote me on that. I'm not an expert. I believe Missouri does. As far as other states, I'm not certain.
Thank you.
Representative Heibarger.
Thank you, Mr. Chair. I'll try to be quick. It's my understanding that possession of a third or higher possession of marijuana, but below certain levels, level 5 felony, is that correct?
Yes.
Right, and so the way I read your data, only 56 of the convictions you referenced out of all the 600 and some were for simple marijuana possession then?
Correct.
Okay.
All of the severity level 5, so we had 56 severity level 5 possession felonies, so it's just simple possession. We had 56 of those last year. 5 were sentenced to prison, and the other 51 were probation cases. And I believe that's where we reference the criminal history D. Of those 5, I believe that all of the folks who were just convicted of possession all had at least a criminal history D or higher criminal history.
Okay, thank you, Doctor.
Thank you.
Is the Executive Director Schultz, would he want to add anything to this? I think he's here. I'm going to give you 30 seconds.
Mr. Chair, and thank you. That's hopefully all I need. I thank you for giving us an opportunity. I think one of the things that Dr. Gruby had talked about is very important to remember, and that, you know, we see a trend of even in a prosecution standpoint, it may not be in a law enforcement context because they obviously are enforcing the current laws, but prosecutors have much discretion in this process, as you know. And so both of us have actually been prosecutors in our former lives, and there is a great amount of discretion. And you can see the societal changes that have actually occurred during that time, and the fact that those pressures that we have now with the other states that have legalized it. So I would just ask the committee that we see the trends that enforcement of that at a prosecutor judge level is much less than it was several years ago.
Thank you. Any questions for Scott? Thank you. Okay, we're ready to move on to the Cannabis Justice Coalition for Kansas. Inga Selders, Executive Director. Welcome to committee.
Thank you.
Might state your name and stuff.
Yes, Inga Selders with Cannabis Justice Coalition.
Okay.
Just good afternoon to Chairman Fagg here and the members of the committee. As I just stated, I'm the Executive Director of Cannabis Justice Coalition. CJC is a bipartisan coalition. We're made up of elected officials, advocates, and stakeholders. We aim to be a voice for the overwhelming majority of Kansans who want to see our state align with our neighboring states, which are benefiting from legalized cannabis. Cannabis Justice Coalition is headquartered in the largest county in Kansas, Johnson County, which shares a border with Missouri, where recreational cannabis is legal. A growing number of cities in Johnson County, such as the City of Mission and the City of Prairie Village, in which I also serve as a city council member, have taken an official position supporting the legalization of cannabis and have added language within our legislative platform supporting this position as passed by our city council. As stated in written testimony submitted to you all from the City of Prairie Village, quote, Prairie Village is a border community in our neighboring state in which adult use of marijuana is legal. Between the accessible and legal patronage less than 1 mile from State Line Road to the east and the legal and gray market of THC and cannabis products, our border communities have de facto marijuana. Our law enforcement cannot escape the impact of adult use marijuana, yet they are required to enforce laws in Kansas with limited tools in a community that in practice appears to support some level of access to marijuana. They go on to say, quote, state law needs to acknowledge the real environment on this issue as it now exists. The longer we wait, the less control our communities and state can manage and control the situation. We have reached a moment in time where we need to align with our neighboring states on cannabis reform. These glaring disparities in law enforcement amongst Kansas and our neighboring states will only continue to grow, and with that, more and more people are going to legally get caught up in this gray area if our laws do not evolve with the realities of what is happening on the ground. In recent years throughout the state, Kansas has seen significant cannabis-related arrest activity. In 2023 alone, there were 4,645 arrests for marijuana possession and 380 for marijuana sales. These arrests cost the taxpayers millions of dollars in law enforcement time, legal bills, and cost to imprison people for doing what is legal in our neighboring states. They create needless criminal records, disproportionately impact working people, and they destroy families and lives. These laws also disproportionately affect people of color. The arrest data in nearly every city in Kansas shows this. We are at a critical juncture where we have a moral and ethical obligation to remove criminal penalties associated with cannabis and decriminalize it statewide, meaning no arrests, prison time, or criminal record for the possession of cannabis for personal consumption. Additionally, we need to expunge the records of any nonviolent cannabis offenses so that Kansans do not have a criminal record holding them back from employment and educational opportunities. The time, money, and resources our law enforcement officers spend on enforcing cannabis prohibition should be used on more serious and violent crimes that face our community. While enforcing cannabis prohibition costs the taxpayers of Kansas millions of dollars each year, legalization generates millions of dollars in tax revenue for our neighboring states. This tax revenue provides additional sorely needed funds for schools, roads, and other public services without further burdening property and income taxpayers. Based on the pace, current sales of cannabis and its derivatives in Missouri, the state estimates approximately $69.4 million in tax revenue will be collected annually. Our neighboring state of Colorado brought in over $274 million in tax revenue last year. According to the 2023 annual Kansas Speaks survey, the Kansas voting public overwhelmingly supports the legalization and decriminalization of cannabis. 67.2% of respondents supported recreational sales of cannabis for individuals 21 and older, and over 60% indicated that they would be more likely to support a candidate who is in favor of the legalization of cannabis. The benefits of legalizing cannabis in Kansas are numerous and well documented. Legalization creates jobs, stimulates local economies, and generates much-needed tax revenue for public services. It also reduces the burden on our criminal justice system, allowing our law enforcement officers to focus on more serious crimes. Even our two presidential candidates support legalization. Donald Trump posted last month on Truth Social, quote, "I believe it is time to end the needless arrest and incarceration of adults for small amounts of marijuana for personal use. We must also implement smart regulations while providing access to adults to safe, tested product." He said, as a Floridian, "I will be voting yes on Amendment 3 this November. That is a vote to legalize recreational cannabis." He also said, if reelected, he would support states who wanted to sell cannabis within their borders. Kamala Harris stated in a recent interview that I feel very strongly that people should not be going to jail for smoking weed. We have come to a point where we have to understand that we have to legalize it and stop criminalizing this behavior. Kansas, being one of the last states to enact cannabis reform, has given us some advantages. We can use this information and lessons learned from other states to craft a bill that includes the best of the best while avoiding some of the mistakes made in other states. In conclusion, it is time for Kansas to step in the right direction and legalize cannabis. The benefits of legalization far outweigh the costs of continued prohibition. It is a matter of fairness, justice, and fiscal responsibility. Thank you for your time, and I'm happy to stand for questions.
Okay, very good job. Committee, got any questions for her? No, one question. How many members do you have in your organization?
We have 4 board members and 4 on our advisory board.
You have an excellent membership. You talk about the board and stuff. How many members do you have?
So a total of 8.
Total 8? Okay. Is there any questions? Okay. Representative Howe.
Thank you, Mr. Chairman. Thank you for your testimony and being here today. You said in your testimony that there's a disproportionate amount of people of color that are incarcerated. Why is that? Do you have information about that? You cited.
It's systemic. I mean, you have people driving who might not have the opportunity to be getting a driver's license, their daily job might be driving more across town, across state lines. Where I live in Prairie Village, we directly border Kansas City, Missouri. So a lot of time people cross the border and not even realize it's state line. In a lot of my area, it's literally a residential road. If you didn't see the sign, you wouldn't know that you crossed over into Kansas. So I just think a lot of it is just, back and forth, especially in the metro areas. But yeah, so just with generational wealth, I mean, there's a whole system of reasons why that, but just if your car looks a little more suspicious for whatever reason, it's not up to date, tags are not renewed, whatnot, you're more likely to be pulled over. So I don't believe our officers are intentionally pulling over people of color in order to be giving them tickets. It's systemic.
Mr. Chairman, one follow-up question. I was just inquiring about that because I wasn't sure if it was something cultural or not only in the general population of people, but or is it cultural in the sense of law enforcement and how laws are enforced? You say it's systemic, but really, I guess that's a very broad statement, so I wasn't sure if you had.
Black people and white people statistically smoke marijuana at equal levels, but the proportions here in Kansas, you're 4.8 times more likely to be arrested for marijuana if you're Black. Where I live in Johnson County, that jumps up to 8.4%.
Okay, I guess I would follow up, Mr. Chairman, if the previous, conferee could provide some information from the Sentencing Commission, maybe that could help us understand that situation a little bit better. Thank you.
Would you like to comment on that, Doctor?
I don't have the data readily available specifically to marijuana, but for felony convictions in Kansas, that is accurate. Not only is there a disproportionate number of Black offenders specifically, I believe last year we had it was 20 to 23% of those incarcerated in prison were Black. Roughly 6 to 8% of Kansas is Black, so it is disproportionate. Additionally, of all the felony offenders in Kansas, 85% plus were indigent, meaning that they met some sort of poverty level threshold. So in general, you're already dealing with a group of people who probably do not have the same amount of income as many other people in the community. So I don't have the specific numbers for marijuana, but I would say that our data would back up those assertions that there is a disproportionate number of people of color that are receiving felony convictions in Kansas. The incarceration numbers last year, without seeing them in front of me specifically right now, it was 20 to 23% of felony defendants who were incarcerated in prison were Black, and compared to 6 to 8% of our population being Black. So it's a pretty big discrepancy there.
Kind of echo what Representative Howe asked for. If next time we meet, if you could have the numbers for just marijuana offenses on that.
Yep, sure.
Thank you.
Thank you, Doctor. Representative Howe, you got any follow-up to her?
Mr. Chairman, I do not, but I appreciate additional information. Thank you.
Any other questions? Thank you for
very
your
much.
presentation. Okay. Next on the agenda is Mission Green Alliance, Weldon Angelos, President, and this is via WebEx. So Weldon, welcome to committee if you're there.
I'm here. Thank you for having me, Chairman and members of the committee. Thank you for the opportunity to speak before you today. My name is Weldon Angelos, and I come before you not only as an advocate of marijuana reform, but as someone who has lived through the devastating impact of outdated marijuana laws. In 2002, as a first-time offender, I was sentenced to a mandatory 55-year prison term for three $300 marijuana charges. Even the judge who was forced to impose that sentence, a conservative George W. Bush appointee, called the sentence cruel, unjust, and even irrational, and urged the president to commute my sentence. Judge Cassell eventually resigned from the bench in protest of such draconian sentencing laws. After serving 13 years of that 55-year sentence, I was granted early release thanks to the efforts of a bipartisan coalition of lawmakers, including Senators Mike Lee, Rand Paul, and Cory Booker, alongside public figures like Alicia Keys, Snoop Dogg, and even Charles Koch. My own experience with the criminal justice system is a reminder of how our drug laws, especially concerning marijuana, have disproportionately harmed individuals and communities. Today, however, I want to focus on how Kansas can approach medical marijuana and decriminalization of small amounts of marijuana in a way that improves public safety, frees up law enforcement resources for more pressing issues, and protects the well-beings of its residents. One thing I would like to note, most medical marijuana users and recreational marijuana users are not possessing 1 gram of marijuana. I heard the statistics earlier about, hardly anybody being locked up for simple possession, but most medical marijuana users, including here in my home state of Utah, they're possessing an ounce to 4 ounces. And I believe under Kansas law, that could result in a prison sentence. And I would also like to correct some of the misinformation that continues to shape this debate. We have seen immense waste of law enforcement resources due to the enforcement of marijuana prohibition, and arresting and prosecuting individuals for small amounts, whether it's medical or recreational users, places unnecessary strain on law enforcement, our court systems, and prisons. These outdated laws divert critical resources. And so by legalizing and regulating medical marijuana appropriately and decriminalizing small amounts, Kansas can allow law enforcement to focus on true public safety threats. Instead of chasing down nonviolent marijuana users, many of whom are seeking relief from chronic pain, PTSD, and other serious medical conditions, police can dedicate their time to addressing violent crime, real drug trafficking, and activities that actually endanger communities. We've seen this shift happen in states that have implemented medical marijuana laws as well as decriminalization of small amounts. In these states, law enforcement has been able to prioritize efforts where they matter most. Studies have consistently shown that legalization of medical marijuana has not led to an increase in crime. And in fact, some states, the crime has actually decreased. I think the exception would be Oklahoma, but I believe Kansas would do a much better job. And a well-regulated medical marijuana program in Kansas will provide law enforcement with a clear, straightforward guidelines for distinguishing between legal medical marijuana use and illegal activity. This would reduce the confusion and ambiguity that currently surrounds marijuana enforcement. Officers would be able to quickly identify individuals who are in compliance with the law and focus on those who are not. So you don't end up like Oklahoma. And furthermore, implementing proper training for officers, Kansas can ensure that law enforcement is prepared to handle the new legal landscape effectively. Additionally, revenue generated through the medical marijuana program can be reinvested in law enforcement training, public safety initiatives, such as substance abuse, youth education programs, further enhancing community safety. Despite these clear benefits, opponents of marijuana reform continue to spread misinformation that distorts the reality of medical marijuana and its impact on public safety. Some claim that medical marijuana will lead to increase in crime and that it poses a danger to public health. These claims are not supported by evidence. Opponents often invoke the outdated gateway drug theory, suggesting that marijuana use will lead to harder drug use or increased criminal activity, and this is simply not true. Research from states with legalized medical marijuana programs show no correlation between marijuana legalization and increase in violent crime or drug addiction. In fact, medical marijuana can serve as a safer alternative to opioid medications for many patients. Furthermore, the idea that medical marijuana poses a significant public health risk is misleading. Under a regulated system, medical marijuana products are tested for safety, ensuring that patients have safe access to and reliable medicine. This is a stark contrast to the unregulated illicit market, where products are often unsafe, laced with unknown drugs. So regulating medical marijuana removes the criminal element and allows patients to obtain their medicine in a controlled, lawful manner. If Kansas continues to criminalize marijuana, the state will not only continue to waste law enforcement resources, but it will leave patients without access to safe, effective treatments. Families with children suffering from epilepsy, veterans with PTSD, individuals with chronic pain are being forced to turn to illegal means or even leave the state to seek medical relief. This is a public health issue, it's a moral issue, and it's a law enforcement issue. By creating a medical marijuana program, Kansas can join the growing number of states that have recognized the benefits of reforming their marijuana laws. A regulated marijuana program will reduce the burden on law enforcement, protect patients from criminalization, and ensure that law enforcement resources are used more efficiently. In closing, I would urge members of this committee to consider the evidence and reject the misinformation that has surrounded this issue for far too long. Legalizing and regulating medical marijuana is a common sense approach that will protect patients, improve public safety, and allow law enforcement to focus on real threats facing our communities. Thank you for your time, and I look forward to answering any questions.
May we have any questions? Senator Thompson.
Thank you, Mr. Chair. Thanks for coming here today. I'm curious, why did you use marijuana? For what purpose?
No, I was caught with, I sold three small amounts, $300 of marijuana in 2002.
So you were dealing?
Yes, correct.
Did your sentencing change your behavior?
Uh, I don't know if my sentencing did. I think, to me, marijuana wasn't such a bad thing in my mind. My background is in music. I used to produce hip hop music for Snoop Dogg and Tupac Shakur's recording group, and so cannabis had sort of been a part of our culture. And so to me, marijuana wasn't that big of a deal. We used it remaking music, making videos, doing things like that. And so my offenses stemmed from a confidential informant. So yeah, obviously my behavior changed because I served 13 years and I went to prison at the age of 24 and I got out at 37.
So do you believe, based on your own personal experience then, that marijuana being illegal would be, at least for some people, a reason not to engage? I guess what I'm saying here is it seems to me that I've known some young people who've been addicted to marijuana, and it's virtually almost ruined their lives. And with it being illegal, to me, I see it as a benefit because it prevents them from engaging in that. And I'd be just curious on your stance.
Yeah, I've never seen anyone addicted to marijuana. I've seen people that, it becomes a habit for them, but I've never seen someone suffer withdrawals like other drugs. And I grew up in California in the music industry, and everyone around was smoking cannabis, and never seen any of them that suffered from withdrawals as a result.
I would encourage you to experience that. I have, and it's not pretty, and it's quite frightening. Thank you, Mr. Chair.
Weldon, I'd like to thank you for being here in your presentation. We're running 25 minutes behind, so we've got to run here. But thank you very much.
Thank you.
Okay, next we go to the Kansas Medical Society. Rachel Colombo, Executive Director, and I understand Dr. Eric Both is here too, so at the appropriate time, you might introduce him. So
Yes.
welcome to committee.
Is this on? Yeah.
Is the button on?
Yes.
Okay.
Good afternoon, Mr. Chairman, members of the committee. I am Rochelle Colombo. I'm the Executive Director of the Kansas Medical Society. We represent physicians statewide of all specialties, and I'm going to give just a very brief introduction on this subject and to our medical expert. So this issue around medical marijuana has been before this body in a variety of committees for more than the last decade. And we've stood before you in opposition to the passage of legislation around medical marijuana for a very simple reason. As you all know, because of federal scheduling, it has not had adequate testing to ensure that it has medical efficacy. And there is no evidence at this time to suggest that it does. We do not support efforts to legislate medical procedures and medical treatments that haven't been shown to have medical efficacy. We believe that we should trust we have a process for this with the FDA, and that is how drugs should be approved rather than legislating around those things which protect patients. I'll say, really briefly, the last conferee said, you all ought to consider this so that you don't have patients seeking illegal remedies. But in passing a state legislation around medical marijuana, you would be asking physicians to prescribe illegal substances, federally prohibited illegal substances, and it puts them in a very difficult position in which they might have to violate their own Hippocratic oath. And so we do not support these measures. There are a variety, again, you're going to hear testimony around a lot of subjects, but we wanted to provide Dr. Eric Voth. He's here today. He is a longstanding expert on this issue and can talk about the harms that are proven and known and associated with marijuana. And so I'm going to turn over all of the specific questions relating to marijuana to Dr. Voth, but I wanted to give some basis for the position of the Kansas Medical Society on this issue, and I would be happy to stand for questions at the appropriate time. So Dr. Voth.
Doctor, welcome to committee. You might state your name in there too for me if you would.
Yes, I'm Dr. Eric Voth. I'm an internal medicine, pain, and addiction specialist. I grew up here in Topeka, and I've been before you all probably too many times, but I'm here again talking about the difficulties associated with marijuana. I want you to please understand
I practiced medicine for 36 years in Kansas, here in Topeka, all of it. I was also, later in my career, responsible for supervising the psychiatry facilities and all of primary care for Stormont Vale. I would point out that my comments are going to go back decades when the National Organization for the Reform of Marijuana Laws openly admitted that their intent on the medical uses of marijuana was to, quote, get the camel's nose under the tent. And that's been going on for almost 40 years now from that standpoint. And despite the fact that some people have perceived it's had great medical uses, the medical uses have really been shot down repeatedly. One of the things that worries me the most, in fact, this meeting today, when I was contacted, it was to talk about PTSD, and where are we? We're talking about legalization of marijuana. And that's the pressure behind this. So you've got to step aside when you think of the pressure coming from individuals who have made fortunes off of legalized marijuana and talk about the real rubber meeting the road, which is young people, people unsuspectingly using it, becoming heavily addicted, becoming psychotic, and having really serious problems with it. And that was a big part of my practice. I want to point out that the concentrations of what's on the street with marijuana have gone through the roof. When I was a young guy, which was a heck of a long time ago, the marijuana on the streets was about 3% THC, 3% THC. Today, the average smoked pot is 30% THC. That's 300 milligrams of THC for a joint. And it gets worse. If you talk about the vapes that are anywhere between 70 to 90% THC, that's 700 to 900 milligrams of THC. We cannot in any way stand behind legalizing that to put on the streets for Kansans or for anybody else for that matter. Now we're talking about the medical applications of marijuana. THC may have some medical applications, but I can write a prescription for it for anybody in this room. It's a Schedule III prescribable drug called Marinol. It's typically 5 to 10 milligrams. I've prescribed it for patients, and it's available. And sometimes it works and sometimes it doesn't. But compare that to the 300 milligrams that smoking a joint of marijuana would do without medical controls, without supervision. And that's what advocates are talking about today. I'd go so far, and I know this is going out on a limb, which I've done a few times, I really think it should be declared that physicians who recommend marijuana as street marijuana should be able to be sued for such decisions. When people get psychotic, end up in an institution, when they have car wrecks, when they have chronic difficulties with criminal acts, violence, etc., I think it's a deviation from the standard of care for a physician to have recommended that marijuana, prescribed a prescription, and not followed through nor adequately educated that individual as to what was being put out on the street. And I am in a position now, as the chairman of the International Academy on the Science and Impact of Cannabis, which is an international organization, that I will be pursuing that opinion. So when you really look at what's being used here, the marijuana advocates have gone systematically through the various applications, talked about the legal remedies, talked about the legal complications, and thought of every single reason why we should be legalizing it, except they have not disclosed the most important, which is there will be medical complications from it. Someone's going to have to take care of that, and people will be suffering from it. Right now, we have less of that going on in Kansas. Look around. Look at Oklahoma. Look at Colorado. They are desperate to do something about their horrible levels of marijuana usage. And what are they doing? Putting on legal stipulations, pulling back, cutting back, things that should have never had to be done in the first place because they legalized marijuana. I can provide you with literally several hundred articles on the medical uses of marijuana, medical problems with marijuana use. One of my colleagues is going to be testifying a little later today. I'd want to point out that the vape preparations and the staggering increases
of THC concentrations of anything we got to deal with is going to be central and foremost. I would pray that Kansas would stand firm and not legalize any form of marijuana for any use, and certainly not medical, because we have plenty of things that are available to the medical side of the world that really does not require THC be added to that. And if I so desired to use THC for a patient, I can use it via Marinol. Remember that drug, Marinol, 5 milligrams, 10 milligrams. So let me finish by saying, remember that these movements are different techniques that the marijuana advocates want to use to try to get it on the street, get it legalized, get it accepted. From a medical standpoint, there is no justification for marijuana as we know it, smoked, impure marijuana. We have THC available to the medical community, and it can be prescribed today. Lastly, I would argue that using street marijuana is truly a deviation from the standard of care and should not be allowed. I'm open for questions.
Thank you. Senator Alley.
Thank you, Mr. Chairman. Thank you for being here today. Is there using street marijuana, as you call it, is there consequences of doing that? We've heard from other testimony today, the revenue that we can make by legalizing marijuana. What are the costs?
I have read and been aware of a number of those studies. I can't just quote them off the top of my head, but I would say, generally speaking, the use goes up, so accidents, homicides, suicides, all of those things increase, and there's always a cost associated with dealing with those things. To put a dollar value on it, I don't think I could be super accurate in that regard. But very clearly, those things do go up. That's one of the reasons that states like Colorado are trying to throttle back and say, wow, we're having academic problems, we have violence, you know. I'm very concerned that a lot of the violence that we're seeing in some areas, particularly people that just jump out and do some violent act unexplainedly, have some connection to a marijuana-based toxicity. We've seen some of that show up in tox studies. I've actually talked to some of the pathologists that are responsible for some of those reports, and I've said, there's no marijuana mentioned in your study. And a couple of the responses were, well, everybody uses marijuana, we don't even test it anymore. How ridiculous is that? So I point out, yes, look at these violence episodes, look at the criminal responses. There's evidence, for instance, if you follow military literature, there's a Navy SEAL that got a lot of recognition for being, you know, one of the best Navy SEALs out there. And he and a friend were helping a young SEAL who had PTSD. Unknown to them, he was also a heavy marijuana smoker. The night before, they took him out to a target range because they thought, let's get him back, you know, firing his rifle and burning off some of his anger and stuff. He was smoking marijuana, as attested by his wife. The next morning, he went out to the firing range with his two friends and killed both of them. So, with that, I'll end. I do think it's pivotal that we realize that marijuana is not just some simple substance, as the marijuana advocates would like to propose. It has its harms associated with it, and if you're going to loosen up the laws on marijuana, they need to be tightly controlled.
Representative Howe.
Thank you, Mr. Chairman. Thank you, Doctor, for being here. I remember you testified before the House Federal and State Affairs Committee a few years ago, and I was there, so I appreciate you coming again now. With your work in addiction, is there a difference between patients you've seen over the years that have struggled with a prescribed addiction through a medication like an opioid versus street drugs and things like that? And if there is a difference, could you help me understand what those are?
Well, it's an incredible mess, quite honestly. You know, we've got opiate addiction right now, and, you know, a lot of that we know came through physician prescriptions, but a lot of it was on the street. And some of the studies have shown very high percentages of folks using marijuana prior to their use of opiates, whether they had pain, whether they didn't have pain. So the problem then is getting control of the indications. Do they have a legitimate indication for an opiate? In my pain work, I prescribe many opiates, but always with tight control. That's why I would say clearly, if anybody's really going to go out on a limb and think that marijuana is a useful medicine, well, use what's prescribable right now, Marinol, and then in doses that are low and appropriate, and keep controls on it. Same way with opiates. It's a matter of indication, control, and monitoring.
Thank you.
Last question. Okay, one more. Go ahead.
Sorry, Mr. Chairman. Just general question. Do you believe Americans are over-medicated, broadly speaking?
Yes, I think that Americans are over-medicated and Americans over-medicate themselves.
Senator Thompson.
Thank you, Mr. Chair. Oh, I'm sorry. You said you. You can go ahead first. Oh, I apologize.
That's okay. You can go ahead.
I was excited. I want to kind of touch on Marinol real quick. Marinol is a synthetic THC. I mean, is there a difference between a synthetic THC and a natural form of THC when it comes to therapeutics?
Well, for one, it's clean, so it's just purely THC, whereas, marijuana is going to have, about 60 cannabinoids in it and about 400 to 500 other substances, which is really one of the compelling reasons not to recommend people to be smoking marijuana for it, because you really don't know all that they're going to get. We also know for a fact that there are a number of contaminants that have been showing up in it, heavy metals that have been showing up in it, and that's not the case with Marinol, which is a prescription pill. Now, you don't have some of the other effects that may be positive, but those need to be defined. If you're going to smoke pot, exactly what is in that. I can't tell you of one other medicine in the thousands that we have available that would be prescribed by smoking. None, zero. And it's because you really can't control what is coming to the patients at that point.
You do have vapor, though.
Well, and with vapes, it depends on if you're talking about a vaporized medication, sure. But there again, that's a pure medicine that's put in a vaporizer and then inhale it. Whereas, vaped marijuana, you got the whole baby and it's a mess. I mean, some of the worst psychotic episodes I've had to deal with have been vape folks.
Dr. Vogt, thank you for your presentation. Executive Director Colombo, thank you for coming today.
Thank you.
Next, we'll move to the Kansas Pharmacists Association, Dustin Rogie, pharmacist. We also have written testimony from the Executive Director, Jared, in our staff. So welcome to committee.
Thanks for having us. Good morning, members of the committee. My name is Dustin Ruggie, and I'm a practicing pharmacist and owner of several rural pharmacies across Kansas. I'm also here today representing the Kansas Pharmacists Association, the statewide professional organization for pharmacists in our state. I'm here to express support for medical cannabis with a key point that dispensing of cannabis must be done through the existing network of Kansas pharmacies. Pharmacies in Kansas already excel at safely dispensing controlled medications. We already are experts at securely storing, monitoring, and dispensing these substances, as well as reporting to local, state, and federal agencies. Cannabis can integrate with our established system, which we already manage with great care and expertise. Pharmacists are uniquely positioned to provide essential services related to cannabis use, including screening for medication cannabis interactions, monitoring usage and potential misuse, and counseling patients on proper use and storage. Some legislatures we've talked to have questions whether pharmacies would be willing to take on the responsibility of dispensing cannabis. While I can't speak for every pharmacy in Kansas, I've spoken with many colleagues and the response is overly positive. Access to medical cannabis treatments is a consistent challenge, particularly in rural and underserved communities, and cannabis will likely face similar access issues. Utilizing our existing pharmacies ensure that patients across the state, not just those in large cities, can have access to medical cannabis if they choose. It seems to me that the proponents of medical cannabis often overlook the potential risk, while opponents fail to recognize the benefits. In pharmacy practice, we do not label any medication as inherently good or bad. We view all treatments as tools, and when used at the right dose for the right person at the right time, can provide significant value. But all substances have both positive and negative effects. There are clinically significant cannabis medication interactions, especially with the blood thinner warfarin, anti-rejection medications like tacrolimus, and others. Pharmacies are already trusted pillars in our communities. Rather than allowing out-of-state interests to dominate this new field, let us empower our local businesses to manage this medical cannabis distribution safely and responsibly. On a personal note, my mother is currently in her last day of liver failure due to autoimmune hepatitis. We have used prescription Marinol for her appetite, anxiety, and pain relief. To those that claim that cannabis has no accepted medical use, I will strongly disagree. Not only as a healthcare provider, but also as her caregiver. Marinol has helped my mother face her fears, restore some enjoyment of food, enable her to communicate her wishes. Sorry. Marinol does have some downside, like any medication. It's made in sesame oil, which is not appropriate for everybody. It can't be dissolved in water for people with swallowing issues. It's relatively expensive and hard to get. There's trouble with manufacturing processes, and I haven't been able to get it for a little while. Also, the dosage strength, like the doctor talked about, it comes in 2.5, 5, and 10 milligrams. For a lot of people, that's too low, and when you start going higher dosages, it gets to be very, very cost prohibitive for a lot of patients. In regards to the earlier questions that people had today, somebody asked what the federal reclassification would have on us. We have to follow both federal and state laws, and we have to basically choose the stricter of them. So, if the feds decide to go to class 3 and the state decides to stay class 1, pharmacies have to do class 1. That's just how it works, whatever's the stronger. Whatever the federal does, I would strongly recommend, if it's up to the legislature, to mirror the federal reclassification. It's just difficult as a business to have two different classifications. Other questions addressed today, how did they decide 0.3% of cannabis being, it was a research paper in the 70s. It was a Canadian research paper in the 70s. It really doesn't mean anything. It's not a clinically significant number. Most people say it's 1%. It just kind of got into the bloodstream, and that's where 0.3% came at. Representative Kessler asked how Delta 8 is dosed. So they take federally legal hemp, so like that 0.3%, and they do a chemical process with it. Basically, they add CO2 to it, and that gets you a CBD isolate, so basically very concentrated. Then they also do another process to it. They isolate it, I'm saying the wrong word there, but basically a chemistry process where they add acid wash to it, add heat to it, filter it back out, and then you get very concentrated Delta 8. That Delta 8 can be put in however milligrams you want. So that's how you can kind of get around. You can get different strengths and dosage forms up to a psychoactive dose or treatment dose. So that's pretty much all I have, and I'll answer any questions you have.
Senator Thompson.
Thank you, Mr. Chair. Thanks for being here. Very sorry about your mom.
Thank you.
I understand that. I'm just kind of curious, are you aware that the pharmacists and pharmacies in Georgia have been warned that any participation in this would be considered illegal by the DOJ?
Yes, sir, I have. So that was November of 2023. The 2023 earlier, they passed the law. They started basically saying, hey, we're going to go and register all these pharmacies. DOJ came out and said, if you do, you're going to have to forfeit your DEA license. That put a big pause on it. Since then, they've kind of backed off of that a little bit. The DEA and DOJ have kind of backed off of that to some degree. I know of pharmacies there that you don't have to have a DEA license to open a pharmacy. Alexandria talked about that before, but you could just dispense amoxicillin or whatever. You can, and I know pharmacies that are doing it there that are opening up pharmacies that are just all other medications, but no controlled drugs and cannabis. So yeah.
So I'm guessing, because you talked about Marinol, Epidiolex, and I know the other drugs that are available, are you okay with dispensing things that are not approved by the FDA?
Yeah, so that's a big question, right? Will marijuana or cannabis ever be, and a whole flower ever be approved by the FDA, right? I don't think it ever will, because there's 60 some cannabinoids in there, and strains are different or things like that. So are they going to, it's all everything else to say, well, we want it FDA approved. FDA approval is great, but they're only going to do one chemical or maybe two chemicals together, three chemicals together. 60, they're not going to probably do. It would be definitely new territory. Now, will people take that risk? It's a good question.
So I just want to make sure I'm clear on is this your stance or the stance of the pharmacy?
It is a stance of the Pharmacy Association, but I also want to say I do not speak for every pharmacist, and we're not saying that every pharmacy needs to do this. We want to have places to have the option to do so if it becomes legal.
Thank you. Thank you, Mr. Chair.
Any other questions? Okay, Dustin, thank you for your presentation. Next, we got the Kansas Cannabis Coalition, Cheryl Kumberg. She's an RN and president. Cheryl, welcome to committee.
Thank you very much. Got to put my little glasses on here. I have a throat thing, so excuse me. First of all, Chairman Fagg and members of the committee, I would like to thank you for your curiosity and your willingness to learn about medical marijuana and how it can bring relief to Kansans who are suffering from a multitude of medical conditions. My name is Cheryl Kumberg. I'm an RN, and I'm also a cannabis nurse. I am also the current president of the Kansas Cannabis Coalition, the only advocacy group focused on patient needs related to a medical cannabis program. My nursing career has spanned over 40 years, and it includes 28 years of experience in alternative health care. Cannabis nursing has been my focus for the last 8 years. I belong to 2 national nursing organizations, the Cannabis Nurses Network and the American Cannabis Nurses Association. I have been advocating on this issue in this State House for 6 years now. It's hard to talk about the therapeutic effects of cannabis without also describing the unique properties of the plant itself. Cannabis is made up of 500 different plant constituents: cannabinoids, terpenes, and flavonoids. All these constituents work within our endocannabinoid system, which humans and all mammals have. Our creator was so amazing, giving us receptors that interact specifically with cannabis plant constituents. We also have the internal ability to make fatty acids that are chemically almost exactly the same as THC and very similar to CBD. It's now hypothesized that disease processes stem from an endocannabinoid deficiency. I think one of the biggest misunderstandings about cannabis is that the acid form of cannabis, which is just the raw, dried plant material, either raw or dried, has different effects in our bodies than the decarboxylated or heated plant materials that we are used to seeing in the dispensaries. Most importantly, raw cannabis, THCA, is not intoxicating. I'll say that again. The acid form of THC is not intoxicating. Patients use both THCA and the acid form of CBD, so it'd be CBDA, as well as THC and CBD, along with all of the other plant terpenes, to get the best healing effects. Patients need access to all forms of cannabis. This includes raw, decarboxylated. They need tinctures, oils, inhaled products, edibles, topicals. Inhaled cannabis offers a quick relief within minutes and lasts usually between 1 to 3 hours. Ingested tinctures or edibles might take up to 2 hours for somebody to feel the relief, but they're going to last from 4 to 12 hours. Topical, usually when you put that on, lasts 1 to 3 hours. Patients often use different products singly or in combination to get lasting relief. So they might put a topical on their knee and they might put a little tincture under their tongue, and they're going to get a longer acting relief from that. Please remember that we can say the same for pharmaceuticals. There are dosage guidelines that must be customized at times to get the desired effect with different drugs. There are a lot of things that we know about cannabis, so please see my written testimony for the complete list and the cited resources. The things we know is that cannabis is safer than alcohol. The new studies have shown that cannabis is not a gateway drug, but an exit drug, helping patients suffering from opioid addictions to escape the cycle of dependence. Claims that cannabis is being laced with fentanyl are unfounded. The American Medical Association endorses drug decriminalization, and teen use has not increased in states with medical cannabis programs. We have to remember that we are not marketing medical cannabis to teens. They cannot get it unless they are a licensed patient, and they cannot get into dispensaries unless they have the proper ID and have a medical card. Kansans who want to take control of their health care by using cannabis are often disparaged, and they are judged as just wanting to legally get high. I've even heard it said that Kansans cannot be trusted to use cannabis responsibly. We believe that Kansans are already using cannabis responsibly, as evidenced by medical cannabis cards being held in Kansas and other legal states. We must provide access to clean, tested cannabis products at an affordable price to have a successful program and to protect public health. Patient, public, and healthcare provider education should be a cornerstone of any program that we put into place. Chair Fagg and committee members, I thank you again for this opportunity to advocate on behalf of Kansans who are suffering. We believe that cannabis was wrongly placed on Schedule I, that its medical value has been duly studied and documented. We believe a Kansas program can be affordable. We can address the past injustices while protecting public health and safety. It's way past due for Kansas to develop a patient-centered medical marijuana program. I also just wanted to speak to a couple points that were made. The history that was given at the beginning of this was amazing. It was so complete. The only things I would like to add is that since 2003, the Department of Health and Human Services has had a patent on CBD. So they know that it is effective, and they know what it does as a neuroprotectant and antioxidant. And that for the last 50 years, the United States has sent an average of $100,000 to Israel for medical research. 50 years we've been doing this. The other thing, I gave several pages of all of the supporting documentation for everything that I'm saying. It's important to realize studies have to be current. What we knew 6 years ago may have been completely changed now. There are programs that we have healthcare practitioners have access to. There is one called ks. It's an amazing program. You can look up disease processes. It links that to every current study that has been done so far, and you also get plant strains that work for that disease if they're known. It gets you the terpene profiles that you need. So you get all of this information, and it's available. It takes a subscription to it. But it's a very, we have so many resources available to the healthcare practitioners. The American Nurses Association, that represents 5 million nurses, has now just made cannabis nursing its own specialty. And I don't think they would have done that if it was, such as dangerous as everybody's claiming. So I would like to thank you for your time, and I'll stand for any questions.
Thank you. Committee, we got any questions? Okay.
I waited for my name that time. Thank you for being here. I've heard you speak before in a little bit, but and I appreciate you being here. But can I kind of get your perspective or your take on the difference between what I mentioned earlier about synthetic THC versus a natural full spectrum THC and kind of the difference between that, just briefly? I know we're running out of time, so not a big
I'll try
explanation.
to be quick. I am a whole plant person. I think you can't just, or you get better relief and you get better results for the healing and symptom relief with whole plant products. It takes all of those constituents to work. Our bodies were made to use all of the terpenes and the the cannabinoids together. I mean, it's an herb, it's not a pharmaceutical product. And herbal relief is, I mean, herbs function differently in our body than a pharmaceutical does.
Representative Meyer.
Thank you, Mr. Chair. So in your career, can you give me an estimate about how many patients you've seen working to help them access cannabis?
We cannot see patients.
Okay.
Yeah. Cannabis nurses, we do a lot with education. We do a lot with providing resources for patients to look up. Since we are, we work with physicians, and our focus is a lot on telling patients how to use their products. For instance, if people can't take it orally, then a cannabis nurse is probably going to suggest, hey, you need a suppository. And if you don't know how to make one because you can't get one at your pharmacy, let me show you how you can do that. So, I mean, nurses, we've been the educators forever. And that's kind of our role as a cannabis nurse, is an educator and supporter.
That's very good to know. So, because the question I wanted to ask is in relation to the previous conferee's testimony regarding psychosis and violent incidents when people are under the influence of cannabis. In my experience as a mental health practitioner, social worker, and someone who has aided patients in accessing medical cannabis, I have not seen that occur with the patients that I worked with. So I wanted to see if you could give us your perspective on the rates at which that might actually occur outside of extenuating circumstances, such as the unfortunate incident that we were just described about the individual who was suffering from PTSD and visited a gun range, which could be varying, I think, contributing factors that led to that. But all that to say, I'm interested in knowing what your organization and your perspective is on the actual incidence of violence and psychosis when it comes to cannabis use for medicinal reasons.
In my experience, data does not support that explosion of psychosis. There are a lot of cannabis doctors that I have heard speak that don't agree with what was being said here. That's, high dose THC can cause psychosis, but usually it's self-limiting. I mean, that's one of the side effects when you overconsume, is you can have some of the psychosis. But like I said, it's self-limiting, and it kind of will go away for most people.
Just a little bit of a follow-up. Would you say that Marinol can also produce the same psychotic effects in high doses as well?
I don't have that much experience with Marinol. My father was prescribed it for his cancer when he stopped eating. He was unable to take it. He had such severe side effects, and it was so strong for him. So he, in my experience, we didn't use it because we had such terrible problems with it. So I don't know. We would never use it in my house.
Thank you.
Representative Howe.
Thank you, Mr. Chair. You had mentioned different variations of THC. I think you mentioned THCA.
THCA, that's the acid form, raw, yes.
So it's my understanding that possibly that could change to a different form once heated or met with a heat source. So do you, I guess, in your opinion, as a healthcare provider, you think it should be segregated out and given in that form without a heat source, or is there a consensus on how to best utilize parts of the plant?
Studies show that THCA has slightly different effects from THC. So a lot of people combine THCA. They might take it as a tea in the morning. They'll just take a bud and put it in. The water's not hot enough to convert it, so they'll go ahead and they'll make a tea and drink that because they don't have any intoxication effects. So in the evening, if they can't sleep or they're anxious or whatever, they'll switch to a THC product. So they use them in combination. A lot of people like to juice for the health benefits of that, and they'll also use some THCA in that, so they get the THC benefit. But that again, you know, my uncle lives in Oregon and he has cancer, and the physician told him, you need more THCA. So he didn't like it raw, so he went to the tea and then switched to the THC product in the evening. And a lot of people do that.
Thank you, Mr. Chair. Thank you.
Committee, got any other questions? Okay, Cheryl, thank you for your presentation. Thank you for your 6 years of presenting here. Okay, we're ready to start into the business and finance. We're running late, don't have to tell you. We got the Kansas Chamber of Commerce, William Wilk, Senior Director of Government Affairs. William, welcome to committee.
Thank you, Mr. Chairman, and good afternoon, members of the committee. My name is William Wilk, Senior Director of Government Affairs for the Kansas Chamber of Commerce. The Kansas Chamber represents small, medium, and large-sized businesses across the state advocating for policies to improve the economic climate in Kansas. The Kansas Chamber appreciates the opportunity to submit testimony on the subject of medical marijuana. I also wanted to note before I get into the weeds of it that the Kansas SHRM, the Society for Human Resource Management, also signed on to our testimony as well. So in the past, on the medical cannabis issue, the Kansas Chamber expressed concerns over the bill language preventing businesses from enforcing their own specific drug testing policies. We have successfully asked each year that within the bill there be language added to protect the ability of an employer to determine drug testing standards suitable for their business. Previous versions introduced on medical marijuana have granted work comp and unemployment insurance benefits without question if the injured or laid off worker has a medical marijuana card. This shift in presumption is significant, and if included in future legislation, will be strongly opposed by the business community. As you've heard today, each state operates differently, but we do know some states have employer protections. For example, Colorado, Michigan, Montana, Oregon, and Vermont are among the states which protect employers from such legal obligations to reimburse medical marijuana as a part of workers' compensation. Within my testimony, I have attached language from the National Association of State Chambers clarifying protections for employers. Employers make operations, business decisions day in and day out, and safety is always of the utmost importance. And each business is unique in how they choose to manage their employees. For example, a construction and manufacturing firm likely will have a zero tolerance policy when it comes to marijuana, but while a small retail store might not have any specific policy in place. We believe employers know how to properly protect their employees from harm's way. In closing, we ask that the language attached be adopted if a bill were to be introduced from this committee's findings during the 2025 legislative session. This language offers clear guidance to employers and employees on the treatment of medical marijuana if it were to become legal in Kansas without implementing broad mandates on the employer community. Thank you for the opportunity to testify today, and I'm happy to answer any questions at the appropriate time.
William, thank you. Committee, got any questions? Okay, thank you, sir.
Thank you.
Next, we got the League of Kansas Municipalities, Spencer Duncan, Government Affairs Director.
Thank you,
Spencer,
Chair.
welcome to committee.
I am Spencer Duncan, Government Affairs Director for the League of Kansas Municipalities. I'm also in my second term on the Topeka City Council. So the League does not have a stance on whether you should or should not legalize it. We have cities who are for it, we have cities who are against it, and cities all the way in between that. But what we are unified on is if you do it, there are some steps you really need to take to help cities. And that starts with understanding that as you craft any sort of policy, you've got to include us as a seat at that table, because the agencies in this state who oversee all the regulated products do a great job, but they aren't there every day in the cities. Whatever gets put in place, it's the cities who are going to have to regulate this, monitor it, and see the impacts of it on a day-to-day basis. We operate our police departments. We're going to have to set the policies they follow that go in line with this. So you got to remember that partnership exists, and you're going to need cities to make this effective, whatever it is you choose to put in place. And if we don't have some input and aren't working alongside you, that's going to make this much more difficult to implement in the 625 cities across Kansas. So what is it we need besides just having that seat at the table and working with you? Well, first of all, it should not alter any local zoning authority. We want to make sure that all that stays in place. That isn't just a home rule issue, but that's also how most policies persist when it comes to any kind of regulated product. We want those to stay in place. Taxation, what does that look like? You probably haven't figured that out yet, but there's probably going to be two different models that are followed. The first is you're just going to collect regular tax like we do on any other product today, and we want to make sure that if that's the route you go, we still are allowed to collect our local portion and that can be remitted back to the cities and that's not touched. If you do establish a new tax of a system of some kind, then, and this will be no surprise, we would like a piece of that, right? That isn't just because we want the money, but it goes back to my first statement. We are going to have to be the ones on the ground regulating it and watching over it and using resources on a day-to-day basis to make sure it's working the way it's supposed to within our cities. There is a cost associated with that. So we want to make sure that if we're not getting the regular sales tax, if there's a special fund that's created, some of that gets back to the cities itself. And that can be done by either giving us a percentage of whatever you put in place or allowing us to have some sort of local tax with some cap, if you want, that we can collect that can be remitted back directly to the cities. You must, we think, also allow us to issue a local permit and assess a local fee for dispensaries, if that's the route we go. Very similar, if you want, to what we do with liquor stores, right? And even tobacco shops. Again, that's just so helps us know where everybody is, helps us continue, particularly as it relates to occupancy issues before they open up, gives us a chance to make sure they've checked the boxes, come and check with the city. We can go in and make sure they're following all of our own local codes, because local codes are not the same, right? We're all on different levels of building codes and ordinances to some degree, and so we need to make sure they understand they've got to come file something with us to say, we're in your city. We do support provisions requiring cultivators to comply with local zoning to obtain a license. We do support any legislation that prohibits driving under the influence of marijuana. And we do think it is a good idea to prohibit cultivation by those not holding state-issued licenses, thus prohibiting the home grow option that some states have gone for. We think those are the states where you see much of the testimony you heard today as it relates to black market issues or those problems. Usually that stems from those directly, not the other regulated system that the products are allowed to be sold within. And we have concerns about how that would impact our cities. We also think you should consider allowing an opt-in option for cities. So if Topeka wants to have dispensaries and Dodge City doesn't, let the local councils there decide we're good with it in this city, we're not as good with it in this city at this point. So we would actually consider that local option. And then the last thing is additional training for law enforcement officials and human resources would be helpful as we put in some system in place, some sort of funding development at the state level. If this does run through, say, alcoholic beverage control, they could create some sort of system to help us educate our officers, a centralized program so we can take that information all across the state to the cities across the state. So those are our asks as you look at this legislation that we think will help make, if you choose to go that route, make for a much easier transition of a marijuana system. That's all I got, Chair.
That's quite a bit. Okay, committee, got any questions for him?
All right.
Senator Thompson.
I always have questions. Thank you. Thank you, Spencer. I appreciate it. It sounds to me like, you're anticipating that if something materializes, that we're talking about potentially huge costs to the cities for regulation, law enforcement, all the unanticipated things. Do you have any kind of estimate of what kind of cost we're talking about?
Well, so that's a yes/no question, right? Answer, and I'll give you why. Yes, in the sense that there's going to be new training required. Yes, we're going to have to develop what those local permits look like, and yes, if new businesses open, there's a cost with that. Now, there's good things that come with all those too, but yes, so there's administrative costs that go into this. But the no is, my police officers are already on the street, right? My city clerk's office is already open. It's not like I'm opening total new divisions or things to help support this system. So yes, we think, and I think it was alluded to by some of the officers earlier, we have police dogs. We have to totally retrain all of them. That's not cheap. We're willing to do it, but it's not cheap, right? And so those kind of expenses are very real that we anticipate. Do we have a cost for you what that looks like? No, we've tried to kind of look at that, but it's like a lot of these things. Different states have such different systems that getting a grasp on what that cost looks like is hard to get.
Well, if every city had a different approach, as you suggested, you're going to have a wide variety of...
We would argue the system should be the same. It's just whether or not they want to join the system or not, right? So we would obviously advocate for standardization across whatever the system looks like, just an opt-in if the city wants to join into that system.
Thank
Yeah.
you, Mr. Chair.
Any other questions? Senator Alley.
Thank you, Mr. Chair. And this is just to follow up to Senator Thompson's question. As you've heard from some of our conferees today, that there's tremendous savings to our law enforcement, to our cities, if we do implement medical marijuana. Are you willing to help us with the savings on that also, if you go that way?
Well, I hope so. We hope there's savings. You know, I'm going to say, so I'll speak more as Spencer, less as the lead guy, just for a minute, all right? So the first bill that passed this legislature 5 years ago was written by Tuck Duncan and Spencer Duncan, all right? At that time, I was a contract lobbyist working for the Cannabis Coalition. We wrote that bill. One of the promises, though, we never made in those hearings was people said, well, there's all this money and savings. And what we said is, I can't promise you that. What I can promise you is no state has really lost money on it. But that doesn't mean states are making money or seeing huge savings, right? So I will continue 5 years later to say to you, do I believe the state will lose revenue or money as a whole when it's said and done? Probably not, but I sure as heck ain't gonna tell you we're gonna make all this extra money and it's gonna lead to all these extra savings either. That would be a fool's errand to run down that path.
Okay, anybody else? Okay,
Thank
Director Duncan, thank you for your presentation. Next, we have the Kansas Cannabis Chamber of Commerce, Aaron Wright, Board President. Aaron, welcome to committee. You might state your name and stuff up there so it's on the record. Thank you.
Good day, Aaron Wright with Kansas Cannabis Chamber of Commerce. Good afternoon, esteemed members of committee. My name is Aaron Wright. I'm the board president of the Kansas Cannabis Chamber of Commerce. I appreciate the opportunity to address the urgent need for cannabis reform in Kansas, with a particular focus on business and financial opportunity. As an organization representing law-abiding business owners, we see the prohibition of cannabis as a barrier to economic growth and fiscal responsibility. We can drive this growth, create jobs, stimulate investment by reforming our laws. Legal cannabis is one of the fastest growing industries in America, creating jobs at a rate eclipsing nearly every other field. The cannabis industry is not just about consumer use. It's a vast ecosystem with countless opportunities for direct businesses and employment. Cultivation facilities, processing centers, testing labs, retail dispensaries would sprout up across our state, creating thousands of jobs in agriculture, manufacturing, science, and vendors. Banks reports the legal cannabis industry in the U.S. supports over 440,000 full-time jobs, representing a 5.4 year-over-year increase. Leafify reports that legal cannabis supported more than 428,000 full-time roles as of January 2022. The demand for cannabis would also drive economic activity in ancillary industries, from lighting and irrigation suppliers to plumbing and general contractors. These are good-paying positions that would keep our young people from moving to other states in search of financial stability. A study by the Kansas City Federal Reserve found that legalizing cannabis led to a 3% increase in state income per capita. Next, we would like to bring attention to real estate. For commercial property owners and renters, the cannabis industry presents new opportunities for leasing and developing, helping revitalize previously underused properties and boosting local economies by driving up rents and property values. This influx of business not only bolsters the commercial market, but also has a positive ripple effect surrounding the surrounding communities. As the industry grows, so does the demand for services like restaurants, retail, and more, creating a thriving local economy. As workers in this field move here or had more disposable income, we'd see a boost in residential real estate as well, with increased home sales and values. Most importantly, there's the tax windfall. Imagine the possibilities of increasing state and local taxes. A Kansas City Star editorial estimated that cannabis could generate up to $50 million in annual tax revenue. Think of the good we could do with this new money, dedicating it to underfunded priorities such as education for our children, public health initiatives, and community service and law enforcement. As of August 2024, 21 states are already benefiting from levying a cannabis tax. We could be next. The residents of Kansas overwhelmingly support cannabis legalization. The annual survey for Kansas Speaks, conducted by Fort Hayes, reveals substantial support among residents for the legalization of recreational marijuana. The survey found that 67.2% of respondents are in favor of legalizing recreational marijuana for individuals 21 and older with the, with the intent of implementing state taxation. 16.9% expressed opposition to legalization. Additionally, 63% of respondents indicated that they are likely to vote for a candidate who supports the legalization of medical cannabis when electing their representatives here in Kansas. We ask you to listen to constituents, side with economic growth and fiscal responsibility, and to end the prohibition on medical cannabis. We urgently need framework before federal legalization ends the prohibition on medical cannabis. We urgently need framework so it won't potentially disrupt the own control that we have of our market. By acting now, we can create a program that benefits Kansas by creating jobs, driving economic activity, and securing new revenue for our state. I just want to express my sincere gratitude for taking the time to meet with us today and your prompt attention to this matter. Your consideration is greatly appreciated. And I also do want to add a personal note. Dustin, my heart goes out to you. I just lost my father 52 days ago to end-stage liver failure. Marinol was not an option for us. The side effects were too great. So, it would have been beneficial for him to have another avenue of pain relief in the last 30 days, especially in the last 30 days of hospice for him. Your consideration is greatly appreciated. I thank you, and I would be open to any questions.
Aaron, I've got a couple real quick. How many members do you have?
We have around 36.
36, okay. You made a statement right at the end about need framework before the federal part there at the end. I kind of was on that this morning at some time. Why is that?
So I believe that somebody else stated that the products that we have now, like the CBD products that we have now, it could not be safe medication. I mean, there's a potential for it to not to be safe medication because we're not testing it and we don't have any of those rules and regulations. So I believe it would be the same consistency with that. If we don't create the framework, then if it federally legalizes that what if chain, then we could potentially have unsafe medication for the residents of Kansas.
Okay, committee, we got any questions for, yes, Representative Meyer.
Thank you, Mr. Chair. Thank you for being here, and I'm so sorry to hear about your father. I had two questions for you. You may or may not have the answer, so no pressure if you don't. But my first question is, do you happen to know approximately how much in Missouri and Colorado and maybe even Oklahoma, not sure, is collecting in tax revenue from Kansas residents?
I don't have that exact number, no, but I can absolutely get that for you.
That would be incredible. And then do you also happen to have any idea how many Kansas residents are working in the cannabis industry and are paying taxes to other states at this time?
That is a great question, and I will look into that for you also.
Thank you.
No problem.
Committee, we got any other questions? Good questions. Okay, Madam President, thank you for being here.
Thank you for your time.
Presenting. Okay, now we're back to just 5 minutes late.
So the two people for 2:30 are not online yet, so could we take like a 10-minute break maybe?
Okay, so we've got two people, been kind of waiting for this all day, from other states. They're not online yet because they knew we was running behind, so we're going to take a 10-minute break. So Boy, a few people smiling now. They're getting where they weren't smiling, so. Well, it's my honor by WebEx, we've got Senator Evan Vickers, which is a Senate Majority Leader from Utah State Senate. And so, Senator, I want to welcome you to Kansas WebEx and thank you for agreeing to do this. Are you there?
I am. Can you hear me okay?
Yes, we can hear
Okay,
you very
great.
well.
Yeah, it's interesting. As I was walking from the committee meeting I was in to come over and log in with you, I was meeting with one of your former colleagues, an Erin Davis. She said she served in the House there for a while. Yeah.
So we got people
Anyway,
shaking their head yes with a smile, so they know who you're talking
that's
about.
good. That's good then.
Yeah.
So you give her high marks so I can see if I want to, if the state of Utah wants to do business with her company, I guess. Thank you. You know, I don't know if you, they asked me to give you a kind of a written presentation, and I hopefully that received that. I can just go through that. You know, I really appreciate the opportunity. As you mentioned, my name is Evan Vickers. I serve in a rural part of the state, and I'm a pharmacist by profession. My family and I own three community pharmacies and some other retail operations. And so I've been involved in medicine. I've been in the legislature 16 years, 4 in the House and 12 in the Senate, and the last 6 as majority leader. I've either been blessed or cursed to be working in medical cannabis the whole time that we've been involved with it here in Utah. I will tell you that it's a very trying space to be in, and it's complex, and there's lots of angles, and oftentimes I describe it as kind of tiptoeing through a minefield, trying to figure things out. But you know, we had a few bills that were considered regarding medical cannabis in sessions prior to 2018, and those bills had a lot of discussion. There was, you know, obviously proponents and opponents to the bills. Some advocacy groups put together a citizens initiative that was considered on the November 2018 ballot. There was a great deal of opposition coming from some faith-based organizations and drug prevention groups and the Utah Medical Association. There were advocates in favor, and you know, including a number who felt that this would eventually lead to recreational cannabis. The polling was close, but it did appear that it was going to pass. At that time in Utah, the legislature had the authority to modify and repeal and even refuse to implement any citizens initiative. The Speaker at the House at the time worked to put a group of stakeholders to discuss proposing a legislative version that would be more acceptable than the initiative language. The initiative used a model similar to Colorado that was medical at that time and not recreational, that allowed homegrown and dispensaries. I was asked to represent the Senate along with a couple of other members of our leadership team at the time. We spent countless hours hammering out statute, kind of line by line. What happened was the advocates really didn't trust government, and the government and other groups who were involved, and those opponents didn't trust the advocates. So we ended up hammering out a line by line bill over, you know, many days. Ended up being over 6,000 lines in the bill. Just some of the kind of the highlights of what we did as we started, and then I can tell you a few things we've done since. We purposely used a true pharmacy model, requiring similar laws to our current Pharmacy Practice Act, including requiring a licensed pharmacist on duty at all times when the pharmacy was open. We really adopted the model. A friend of mine, a colleague of mine in the House, when we first started, we adopted the motto that if it's medicine, let's treat it like medicine, both from the medical perspective and the regulatory perspective. And so we've tried to stick with that. Our goal was to have a medical professional working with the patient from start to finish, and not just having a bud tender or somebody that really wasn't a medical professional dealing with the patient and making recommendations. We limited the number of licenses for cultivation and pharmacies. You can grow a lot of product and, some square feet. You can grow enough to satisfy patients in the whole state of Utah with around 400 to 500,000 square feet of cultivation. We currently have over 80,000 active medical cannabis card holders in the state. To put that in perspective, I think it was 89,000 card holders last month. About half of them, about 45,000, actually filled a medical cannabis prescription. We did not allow for home grow. We set up a process where physicians and practitioners that would be prescribing or recommending medical cannabis were required to take additional education and receive a certification to become what we called a qualified medical provider, or a QMP. We set certain caps on how many patients any one practitioner could serve in any time in an attempt to avoid creating a pot doc kind of concept where you only saw. That was one thing that we learned from Colorado, that they, at the time, they had 5 physicians that were writing over 80% of the recommendations. So we were trying to avoid that. We were trying to spread it out throughout the medical community. Had some success with that, but the challenge we've had is we've seen some medical practitioners specialize in that area, started charging high fees to get a card. We've kind of been able to neutralize that, and I can talk about that more in just a minute. But we established a reasonable qualifying illness list that patients had to meet to get a medical cannabis card. As it turns out, a very high percentage of patients treated with medical cannabis are treated for pain. So be careful if you're developing a list, just kind of be careful what type of pain you allow and how you kind of govern that. We set limits on how much a patient could purchase in a 30-day period and how much they could have in their possession. We established an electronic verification system that providers, pharmacies, and law enforcement had access to. We have a kind of a dual regulation in our state. Some states I know have developed like a medical cannabis agency. We didn't do that. We put part of the responsibility with our Department of Health and Human Services and part of it with the Department of Natural Resources and Agriculture. So we kind of split up the responsibilities. We continue to do that today. We established procedures for a patient to obtain a card and for caregivers to receive a card. We established criteria for how licenses were awarded, the operating procedures for the entities, and the qualifications employees and owners had to follow as well for violating these regulations. We allowed the practitioners to either give specific recommendations to the pharmacy or work with the pharmacist to come up with a dosing regimen for the patient. Our experience has been that most of our physicians don't have a good training and background in medical cannabis, and so they're reluctant, number one, to get involved, and if they do get involved, they're reluctant to make specific recommendations. So we've found that our pharmacists end up being the medical professional that has been doing most of the work, and they work with the patient, do the consults, get back to the physician, and then, move forward with the patient. So from that perspective, it's really helped having those pharmacists in place because they become the ones that have really been the medical practitioner that most of the patients work with. That bill, the original bill, passed in a special session in December of 2018. We had our first pharmacy up and running in March of 2019. And of course, then it's kind of moved forward. We now have 15 pharmacies in the state, spread throughout the state. We have 8 cultivation licenses. We have a number of processing licenses, and we have a couple of labs that there's lots of testing that has to go on. Since then, we've had bills in the legislature every year working on various aspects of the program. We have put together a group of legislators that work in this space, including members of both parties in the House and the Senate. We've created a formal working group as well as a policy advisory board that has members representing the industry, patients, medical practitioners, and the public, and make recommendations to our working group. This has been very helpful. We have also recently established a research center at the University of Utah to work in this space because they do have a Class 1 lab. Now, if it does get rescheduled to a Class 3 by the federal government, then that would really significantly ease the difficulties it takes with the research component. The legislators that work in the space, we've been very collaborative. We usually divide up assignments, sometimes breaking them into those that affect health and those that affect ag. We have had a difficult time getting as many providers involved as we'd like, and that led to some unfortunate situations where a few providers were, even though we had capped them, they were charging high fees, upwards of $300 to $500 for a patient to get a card, and that led to some really difficult things. Since then we've been able to spread that out. A lot of the practitioners have been able to now charge just the insurance copay for a patient, especially if they're doing their whole care, their whole primary care, and be able to, that way it's been much more affordable that way. We did start a program where we called a limited medical practitioner. So we said, okay, any physician that wants to kind of test the waters can get involved with their patients and manage up to 15 patients at a time. That's helped. That's led to some additional physicians getting involved, but we still have some resistance. It's still in their mind an illegal substance, and so they're reluctant to get involved. But we're kind of expanding slowly, but we're getting more and more physicians involved. Some of the challenges we faced, it was mentioned about the fees that are being charged by patients. That has mostly modified, and more providers are including a patient's medical cannabis treatment with their overall care, leading to just the office copay. It isn't perfect, but it is getting better. Restrictions on advertising with the intent to avoid making it attractive to youth. You remember, there is one thing if you're dealing with cannabis, and this is documented scientific proof, that it will completely destroy a young mind up to the age of 25 if used on a regular basis. And so that's one thing that you have to be very aware of when you get involved in this space. The industry continues to push the envelope. We've been faced with whether to require, allow, or incentivize vertical ownership. So in my world, in the pharmacy world, vertical ownership's a bad thing, because you don't want a physician owning a clinic and a pharmacy and even the drug company in this case. So I went in with that preconceived idea that vertical ownership was bad. I've had people work with me, and I've kind of convinced me that the potential to reduce costs is better with vertical ownership, where you have one company that owns the cultivation and the processing and the pharmacy. We do not allow them to own the lab. We need to make sure that those are independent. But at the same token, now the pendulum is swinging a little bit, because we do have some independent operators in those licenses, and we're having they're actually sometimes able to produce the product at a cheaper price, and we're having a hard time getting those products in the pharmacies. So we're still navigating that. The constant push by some groups to introduce elements of recreational into the medical program. You just always got to be vigilant, whether it be allowing drinks, whether it be allowing certain types of gummies. We've really restricted the gummies to just a square, and not anything in its shape or colors that would make it candy-like. We've had to kind of stand firm in this area. Our goal has always been to just have the very best medical program we can and leave it at that. Some other challenges, patients getting cards and then buying product on the black market or from other states. They try to buy the product, they use the card, and then they buy the product on the black market to try to say they're legal by having it in their possession. Our laws require it to be in the package that came from the pharmacy. So if a law enforcement stops someone and they have product that is not like that, then it's considered illegal. Price transparency at the pharmacies, trying to keep reducing prices. As we compare our prices to the patient at the pharmacy level, it compares very well, very favorably to other medical states. We're seeing prices come down, but they really need to come down quicker. We need to be more efficient, make it more affordable. The problem, the challenge is that insurance won't pay for this, so the patients are stuck with paying cash, and it can be a burden sometimes on the families. We have allowed delivery with some restrictions that has helped reach out to some of the rural areas and less served parts of the state, but it's still a work in progress as well. I could probably go on for a long time. We've been involved in this quite a bit, but I'd really like to answer any questions that you might have and be as helpful as I can.
You have been very helpful, very interesting. I've got a question, Senator Peterson.
Thank you, Mr. Chair. Did you guys do anything with packaging to make it not attractive to young folks?
We did. We have specific restrictions on that. That it has to be pretty plain Jane, opaque packaging. Even the bags that it goes in have to be opaque. Just basically, a brown plastic bag, something like that. So we've tried very hard on the way the product looks. So the packaging itself, so that like the gummies and that, they have to be very plain Jane. The advertising, and that's a constant battle. We're trying to, and one challenge you can do is you can regulate the advertising with your, say, the license holder, whether it be the pharmacy or the processor. But then you get these third-party entities, the advocacy groups and that'll advertise for them, and they put other stuff out there that isn't legal. So that's a challenge we've had in that advertising arena. It's kind of a constant vigilance, but yes, we have put significant pieces in place to try to avoid it looking like something that would be attractive to children.
Thank you. Thank you, Mr. Chair.
Representative Hoheisel.
Thank you, Mr. Chairman. Thank you, Senator, for being here today. Here in Kansas, we consider the House the upper chamber. I just want you to know that. Quick question on your guys's your cap you have on doctors, your doctor-patient ratio. What does that cap look like?
Yeah, we started out with 200 patients, and then we expanded it up. It went up to 600 for a specialist. Then as we got into it still wasn't working like we wanted it to. We were still getting very high initial fees charged by practitioners for patients. So then we're fortunate to have one of the people that is in the House as a physician, a family practice physician. He became a QMP and started working in his space, so he had personal experience in it. And he started finding that if he worked with the patient as a primary care patient, then he could charge the insurance for their office visit. In fact, now we're finding that insurance will pay for the office visit for just about any of the qualifying illnesses. So we changed the provision that we allowed a physician that would utilize that tool to discharge bill insurance and charge the office visit, that we would allow them to have more patients. And that's been fairly successful. I know some states do not have limits. I'm kind of torn on whether to advise you to have limits or not. It just depends. And some of the other states that I've talked to have kind of gone through the same kind of history we have with, physicians charging a pretty high price at first, and then it kind of moderates over time. Probably ought to talk to you more about that, but I think there's value, and you could probably learn from some of the mistakes we made early on.
Mr. Chairman, follow up if I may.
Absolutely.
Do you guys have a I guess time frame on a pre-existing relationship between the patient and the doctor? Because I know a few years ago we had in some proposed legislation here in Kansas, you had to have a 6-month pre-existing established relationship with that doctor before you could be prescribed or recommended medical marijuana. And the issue I saw with that is we have veterans that go to the VA. That's where their primary physician is, who would then not be able to get it because it's at the VA, would have to go and establish another relationship with a physician and then wait the 6 months before they'd have access to it.
We didn't set that requirement. We do require a face-to-face visit with the physician on the, especially on the first visit, and then we do allow for some telehealth after that. But I can see what you're talking about. And the challenge we had there is we just didn't have enough physicians and practitioners that were interested in getting involved in this space. And so we would have been faced with having like 4 or 5 practitioners in the whole state doing everything. So we didn't have that requirement. Although we're finding now is more and more physicians are treating it as their total care package. So they're, working with the patient on all of their primary care, and then cannabis, medical cannabis, is just another tool that they're using.
I appreciate that. Thank you, Senator. Thank you, Mr. Chairman.
Senator Thompson.
Thank you, Mr. Chair. Thank you, Mr. Majority Leader, and sorry to get you caught up in between the bragging rights between the House and the Senate here in Kansas. Appreciate you coming in here with us. Do you know if the pharmacies there have to register with the DEA, or whether they've been notified by the DOJ, as some of the pharmacies in Georgia have been, about the illegal prescriptions?
No, because it is a class 1 substance, and the DOJ hasn't been involved. Now, one caveat to that is if the federal government reschedules it, reclassifies it to a Schedule 3, it's going to do a couple of things. Some people think, oh, great, I can just go to a pharmacy and get it. Well, no, that's not the way it works, because in a traditional pharmacy, retail pharmacy, you're going to have an FDA-approved product. A class 3 would open the door to easier research and more research, but it was also open the door to the DOJ coming in and having regulations inside the pharmacy, because it is a class 3. So right now, the pharmacies do not have to, but I can see that in the future if they reschedule it, they would.
And then that kind of leads to my follow-up question with regard to that. I lost my train of thought there for a second. Sorry about that. One question I do have. So it's a pharmacy model, but they don't have to be limited to just the FDA-approved drugs, correct? And follow up on that is, are they prescribing to people under 25 in the state of Utah?
21 is our cap in Utah, 21. And we do have, so let me follow up a little bit. So the pharmacies, the cannabis pharmacies, they only carry cannabis products. They do not, carry any of the other products, including aspirin, Tylenol, those kind of things. So that is the case there, and we've been able to handle that pretty well. You just can't go to a traditional pharmacy and get it. But and I'm like you. What was the other thing you were talking about?
Yeah, I know. He gets so much running through your head. Well, we asked about 21. Oh, the pharmacy.
Oh,
the pharmacy.
age.
Yeah, the
Yeah,
age, and you answered that. So the pharmacy model you're talking about, you're not dispensing through a Walgreens or a CVS. It's just a dispensary that acts as a so-called pharmacy, correct?
Yeah.
Okay.
Yeah, and be careful with talking to a pharmacist. I always tell the guy, you got to make sure that it is a pharmacy. It is a licensed pharmacy with licensed pharmacists there and staff, that follow the regulations that we do with our Pharmacy Practice Act. What I wanted to follow up with you on the age is that we established a compassionate use board. So it's a team of physicians that are appointed, and if we have a patient, whether it be age-related or condition-related, that doesn't meet our guidelines, their recommending physician can refer them to the Compassionate Use Board, and the team of physicians on the Compassionate Use Board can review their case and determine on a case-by-case basis whether that patient is eligible to use medical cannabis. So in some cases, we do treat children less than that, typically, for some type of a seizure or something along those lines, epilepsy or along those lines. But that board is the one that makes those decisions. Also, if you have a patient that the recommending physician feels like that they don't have a qualifying illness that meets the guidelines that we've set, but he or she feels like that they should be able to use medical cannabis, they can refer them to the Compassionate Use Board, and they can look at that case and determine whether they agree or not. And they also, when they do that, they can put a time frame on it. They can say, okay, yeah, will allow you to use a certain amount of medical cannabis for 6 months, 3 months, a year, you know. So that's kind of the way we've handled kind of the one-offs that and it's been quite successful. That's worked pretty well.
Thank you, Senator. Thanks, Mr. Chair.
Representative Carpenter.
Thank you, Mr. Chair. Thank you, Senator, for your time. So do you have reference numbers assigned? First of all, is it grown in your state, all grown in your state? All the...
Yes, actually by federal law, it has to be. You can't transport it across state lines, so it has to be.
Okay.
Has
and
to
then
be grown in the
secondly,
state.
do you employ or contract with a reference company, a company that keeps track of where it's grown, seed to source, I think they call it?
Yeah, that's the electronic verification, part of the electronic verification system that we use. And there's some companies out there, and if you want, I can tell you one that we had originally and ended up having to change because some of the challenges, but that system will track it seed to sale.
Thank you.
Representative Howe.
Thank you, Mr. Chairman, and thank you, Senator, for imparting on us your information and expertise and experience. My question is, and if I've missed this somewhere in your testimony, I apologize in advance, but what is the fiscal note for the state of Utah in terms of administering this program and standing this up?
Okay, he's muted.
Oh, sorry.
There we go.
Looks like I must have waved my hand over my laptop and hit mute. Sorry about that.
You're back.
So anyway, when we negotiated the original bill, that was one component that the advocates were very firm about. Some states do tax it. We do not, and that was one thing they did not want to tax. So we chose to fund this all on the backs of the license holders. So we charge pretty high fees for licenses. You know, for example, $50,000 a year for some, $100,000 for others, depending on the license structure. And we put that money into a pool, and that's how we fund the operation. Our intent is not to make money on it. We just try to gather enough money to administer the program. And it runs about, I'm trying to think, between the two agencies, somewhere around $3 million a year, I think it is right now. I could be off on that. I probably ought to go check my figures on that. But the bottom line is we fund it just solely on the licenses. And right now, we've been doing the program long enough, we're starting to reevaluate those licenses, see if those prices can come down. But we do not tax it, and we do not take additional revenue out of it to go into the general fund or anything like that. Some states do actually tax it and try to make money on it. We've chosen not to do that.
Thank you, Mr. Chairman. Just to make sure I understand correctly, Senator, you're saying that this is solely fee funded and there's no state general fund resources going to subsidize, I guess, the administration.
That's true. That is accurate. That's how we've done it.
Senator Thompson.
Thank you, Senator. One kind of following up on that, you're talking about just the funds required to administer. Do you have any idea? Because in your testimony it says the black market is very strong in your state. One, have you seen that black market increase since you have gone to medical? And number two, do you have any idea what it costs for all the other costs, to law enforcement, social network, increased insurance costs for uninsured people in hospitals, showing up in the emergency room for hyperemesis, things of that nature? Do you have a total all-in cost by any chance?
No, I don't. For your first question about the black market, I think the black market is pretty strong in every state. What we're finding is that as near as we can tell, it has not increased. It hasn't, we've seen some increase in youth use, so that's one thing that you got to be a little careful of. We do have a strong prevention program that we fund. We have some money going into, and we also package that with cigarette, prevention and alcohol prevention programs. So with the youth, but we have seen some increase in, for example, cannabis vaping and that in teenagers. The the prevention side, working on that is something you have to really continue to work on. We haven't documented any additional. In fact, as we've worked with our law enforcement people and even the hospitals and that, we have not seen a significant increase in those kind of instances. Most of the instances we see in the hospital setting still come from the black market use, not from the medical use. As far as the law enforcement side, they've pretty well navigated through that. We haven't, we do have laws that if you're impaired, you're impaired. It doesn't matter whether you're using a legal product or an illegal product. Same thing with opioids. That we try to treat that aspect of it the same way we treat opioids, but we have not documented any significant increase in some of the social costs that you see through a recreational program.
Thanks, Senator. Thanks, Mr. Chair.
Senator Alley. Thank you, Mr. Chair. Senator, going back to your pharmacies, these pharmacies, you have the regular pharmacy, the one you have normal, and then you have the pharmacies that administer the medical marijuana, right? Is that correct?
That is correct. Yeah, they're a standalone separate pharmacy. We require them to be in certain zones and in cities. We do have the cities have some autonomy to where they put them, but we do require that they allow them in certain zones, primarily a commercial zone or agricultural zone. Some states have allowed cities and counties to choose whether they allow them or not. We did not do that. We required them to be allowed, but to give them some guidelines and flexibility on where they could go within their community. We capped the licenses right now at 15 pharmacies for the state of Utah. We have a population of 3.5 million and a medical cannabis cardholder population around 80,000, a little over 80,000. We're in the process of looking at allowing some additional pharmacies. But they are a standalone pharmacy, separate from a Walgreens or Bullock Drug. In my case, that's the name of one of the pharmacies that we own. And then we do limit the way they can advertise and how they, and you can't necessarily, the kind of traditional is the green cross. That's kind of the traditional indication that it's something to do with cannabis. That's pretty much the only thing that you can use on the outside. Other than just to say, have the name of the pharmacy on it.
And these pharmacies don't sell the normal pharmacy products. They sell basically only the cannabis product. Is that correct?
Right. Yeah, and we only allow cannabis patients or caregivers to enter the pharmacies. We don't allow them to bring children in and others.
And then the last question, is there a fee to establish that pharmacy? Do you get a fee for that pharmacy?
Yes, those licensors are quite expensive. They're about $50,000 a year.
Okay. Well, thank you very much.
Mm-hmm. I could hear something in the background, but I couldn't hear anything else.
Okay, I didn't have my button pushed. Okay. I wanted to congratulate you on rich state, poor state. You're rated number 1 in that area, so I wanted to congratulate you on that. I don't know if you're aware of that.
Yes,
Two is that you have
years
We
in a
have a
row.
senator by the name of Ronald Winterton.
I sure
And
do. He's a good
I
colleague.
see him about twice a year, so you'd be sure and tell him Senator Fag said hi, that you straighten him out. So I
will.
appreciate, I appreciate that. And if we don't have any other questions, I want to truly thank you for your time. You've been very informative, and we appreciate all that you've given us.
Yeah, I'm happy to help anytime. And one thing you might want to consider, a colleague of mine in the House, when we were working on this a few years ago, took a road trip and went to Connecticut, Pennsylvania, and New Jersey. I wouldn't recommend going back to New Jersey, but Connecticut and Pennsylvania are very helpful. And if you ever want to put together a group to come make a road trip out here, I'd certainly be glad to facilitate that for you.
Thank you very much. Okay, with that, we'll let you go and have a good day.
Okay, thanks a lot. Appreciate it.
All right. Thank you. Okay, our last one for the day is a gentleman by the name of Ken Newberger, that's Executive Director for the Mississippi Medical Marijuana Association. He's here by WebEx. Ken, I want to thank you for your patience. We've had a long day, a lot of great discussion, and we're excited to hear from you. So can you hear me?
I can hear you. Can you hear me?
Yes, sir, we can.
Great.
So
Thanks for having me. And I remember when we were doing our bill, long days at the Capitol, hearings and discussions just like this. So thank you so much.
okay, you want to go ahead and tell us about what's going on in Mississippi?
Yeah, so I got my start in this back in 2020. I ran the ballot initiative for medical marijuana in Mississippi. It was overturned by our Supreme Court on a technicality, and then our legislature got to work, much like what y'all are doing right now, trying to craft a law. And we had really four key tenets at the beginning of the program. It was number one, to make this patient focused and as patient focused as possible, making sure that if patients could have medical marijuana, then that was the number one goal. Number two, we wanted it to be a free market system. So that way we didn't box out any companies favoring large companies, either in state or out of state, that could, buy their way in. Three, we wanted to give decision rights to the actual physicians. And we also included nurse practitioners and physician's assistants to also certify. And four, we were really keen on making sure that the program was self-sustainable. So we made sure that not only with the initial fees collected, but we actually did decide to tax the product itself at the same sales tax as all other retail drugs in the state. So those were our four key tenets. And I would say we succeeded. We've got a little over 46,000 patients that have medical marijuana cards right now in Mississippi. We've got just south of 400 different types of businesses in Mississippi that touch medical cannabis, and that is our dispensaries that dispense it to patients, cultivators, processors, testing facilities, transportation companies, disposal entities, and testing labs. And then we also have research facilities, but really the only research facility that exists is at the University of Mississippi or Ole Miss. They're the only entity, I believe, that has registered for a research license from the Department of Health.
Okay, committee, got any questions for him here at this point? How long have you, it is medical marijuana that you have in Mississippi, correct?
Yes.
Okay.
Yeah, it's just medical.
You had that?
We've had it for a year and a half of sales, but the law actually passed in February of 22. And then the first licenses were issued by July of 22. We did a really fast turnaround. Our Department of Health worked really hard to actually get it done. We gave the retail portion of the entire program to the Department of Revenue, but we gave them oversight by the Department of Health, and the Department of Health administers all other facets of the program, from the patients to the cultivation and the processing and the testing and the seed to sale.
Ken, what kind of challenges have you had with that?
Well, our biggest challenge, I think, has been we have so many different licenses. It's not as bad as just south of you guys in Oklahoma. We don't have like thousands of people running around with licenses, but it's still people bought licenses thinking they were going to get rich, and then they realized that this is actually just a program made for medical patients, and there aren't a million people to buy medical cannabis in Mississippi. There's only 46,000 right now. So you got 46,000 patients that are buying cannabis at roughly 170 stores across the state that are dispensaries, and there's just not enough to be profitable for that many dispensaries. I think what that proves is that the patients are really getting the best quality medicine they can get, because we kept costs low on the actual product by having that much competition, but the industry is suffering. I would say nobody else is really having a problem. The patients are getting the medicine they have. We haven't had any problems with diversion. We haven't had any problems with the black market. We haven't had any problems with law enforcement not knowing what to do. We haven't had any problems with the Department of Health. They've really scaled up appropriately. I mean, overall, it's been a pretty smooth program. We just the businesses feel like they're not making enough money, and I think if the only complaint you have is people who don't think there's enough money in the program, I think that you're doing a pretty good job. Because like I said, our number one thing was making sure patients got the medicine.
Okay, Representative Howe.
Thank you, Mr. Chairman. Thank you, Ken, for being here. I view Mississippi as a fairly conservative state. Could you describe to me a little bit more about the legislative process that unfolded in Mississippi to get that law? Was it cumbersome? Did it flow fairly easily or easier than expected? Were there a lot of floor amendments? Could you shed a little light on that? Thank you.
Yes. So I would say it was maybe one of the smoothest pieces of legislation I've ever worked on. As a lobbyist working on different pieces of legislation, this was one of the easiest ones to actually get passed by the time the session came around. Our Supreme Court overturned Initiative 65, which was our ballot initiative, back in May of 21. And our first hearing on medical cannabis to actually draft a bill was late June of 21. So from late June of 21 until February of 22, Representative Lee Yancey and Senator Kevin Blackwell, the bill's initial author, worked on this really for about 8 months. It was really most of what they did. I would think if y'all wanted to reach out to them, they'd be happy to answer any of your questions about how they did it. But from my perspective, working with them, it was a lot of meeting with them, introducing them to people in the industry outside of the state, people who wanted to see it come to Mississippi, inside of the state, getting them to know patients who would be using the product, getting them to understand the process in other states of what happened. I caught the tail end of the last presentation who that senator actually spoke to our legislature as well when we were getting things going. They went to other states. I think they went to Missouri, Oklahoma. They went to Utah, I know, for I think an ALEC conference. I mean, they were all over the place looking at how other programs worked. Then when it finally came time for the session, the House got together to talk about what they wanted to do. The Senate got together to talk what they wanted to do, but they had mostly worked out the kinks ahead of time. Between the bill's initial introduction, they lowered the amount of cannabis you could buy per month by an ounce. And then they also made some minor zoning related amendments on the floor, but they didn't do much by the time the bill actually came to the session. I mean, it flew through the Senate pretty quickly, and then it had 3 amendments in the House, and then it passed.
Thank you, Ken. Thank you, Mr. Chairman.
Senator Thompson.
Thank you, Mr. Chair. Thanks, Ken, for coming to testify. Do you know, I'm guessing you guys use a card system for verification, medical marijuana card or something like that. Is that true?
Yes.
Yeah.
It's a
Yeah.
digital card, but yes, we have a
Okay,
card.
okay. Do you know how many cards have been issued in the state?
How many have been issued? I don't know exactly. I know we have just north of 46,000 active. If I was going to guess how many have been issued in the past 2 years, I'd say around 60. We've had a pretty decent drop off of people who either died, decided not to use the product again, or have just stopped buying cannabis altogether.
And so, how many dispensaries did you say you guys have down there?
Open, it's about 165. Total
Okay.
license, it's about 195.
Okay. All righty. Thank you.
Mhm.
Thank you, Mr. Chair.
Senator Alley.
Thank you. Thank you, Kim. Is any of this covered by insurance?
No.
All cash, basically.
You can use debit if the provider can work it, but you cannot use a credit card. It's either debit or cash.
Any other questions, committee? Ken, what's the cost if somebody went in, just average cost for something like this?
So it varies. Cultivation is the one with the most change. So the lowest level we call them microprocessors and micro cultivators, which are for businesses that are 100% Mississippi owned. They can have fees as low as $3,500 or $4,500 to get their license. But if you're a highest, our tier 6 cultivator, which is the largest, it's between 100,000 and 150,000 square feet of canopy. They're 160,000 to get their license, then it's 100 every year after that. So that's on the cultivation side. But for dispensaries, it's just a flat fee of 40,000 up front and then a $25,000 fee every year afterwards.
I was wondering, like on the retail side, the customer, what would be the average cost for something like that? But that was a good information there, though. So
Yeah, so the average cost, it started really high right out of the gate. Everybody's trying to figure out how much things cost. It started really high, but right now, if you're going to buy, let's say you're buying an eighth of flower, it's probably around $25 to $30 if you want to buy, kind of a budget eighth of cannabis. And we allow all forms of cannabis. We decided we didn't want to limit what kinds you can get. We did limit the THC percentage. In flower, it's 30% THC, and in all extracted products, it's 60%. I'm not sure we hit the mark on that or not, but I do think that, overall that hasn't been much of a problem.
okay, thank you. Committee, got any other questions? Well, Mr. Executive Director, thank you for your time and putting up with us this afternoon. We appreciate the information, and we'll let you go. Thank you.
Thank you. Talk to y'all soon.
To see. Representative.
Is it your intent that this committee might recommend legislation or not?
I think it kind of develops. I'm still kind of absorbing what we took in today, to be honest with you. And if you guys have suggestions in that area, you have been around this longer than I have. So I'm saying with the information we've layered to this, I'm kind of interested to see what directions that we'd like to see on the 28th, and between now and then, give you some time to think about that. Maybe we can discuss that at that time. So is there anything about today or the 28th that we need to, I know I wrote down education. I think that guy made a point. I'd be interested to hear from the schools. Is there any areas that you think we might have missed? Representative Hohlheiser.
I think, Mr. Chair, as banking chair to a banker here, I would like if we could possibly get somebody with the banks in to talk about the SAFER Act or instances, basically the barriers that banks are facing right now in other states processing these transactions. I know we heard something today a little bit about the, all cash business and the safety threats that kind of presents. So if we could get somebody from the banking community here to talk about that issue, I'd greatly appreciate it.
Okay, good suggestion. Representative Carpenter.
Mr. Chairman, thank you. I'd like to see some testimony from one of the tracking companies that track it. I can't remember some of the names, but I know Missouri and Colorado both use those. It's seed to source or something like that. They track it from the time it's planted to the time it's harvested. I'd like to hear from more on that.
Okay.
Thank you.
Yeah, going back to Representative Hohlheiser's request, I mean, if we have somebody from the banking industry presenting, I think we'd be also interested to hear from one of the 10% of banks or 5% of credit unions who've managed to figure out how to process payments in this industry. Get both perspectives, maybe.
All right. Senator Alley.
I think one of the things we talked about last time was testing lab and how that testing is performed. I think that needs to be included in that.
Okay.
Sorry, it just popped in my head when he said testing. I am rather interested in, if that's not the purview of this committee, that's fine, but maybe somebody from KBI to talk about the testing of the CBD oil with the THC, and if I believe it was the sheriff earlier that alluded to a former KBI director. They did a sweep one time. They found some with above the THC threshold, some below it. I'm just curious, maybe from KBI's perspective of, is that something that they need to look into as well as further enforcing that?
Okay. Senator Thompson.
Yeah, thank you. First of all, I think we had a lot of good information today, and I appreciate everyone who testified. The agencies had a lot of different estimates on potential costs of regulation, FTEs, things like that. I don't know if our research could kind of aggregate that for us to get us some kind of rough. I know in committee in Fed and State, we had a rough estimate, but I would like to see if there's a newer version of that. And also with regard to the tracking, which is a good idea, I'd like to get more information on the disposal, how it's being handled, whether or not, with the end use of the plants that, or the part of the plants that's not used, how it's disposed of, whether it's disposed, where we're tracking that at all, and where that ends up. Something of that nature would be interesting to me. Thank you, Mr. Chair.
Yeah. Representative Meyer.
Thank you, Mr. Chair. I would really be interested in hearing from growers and business owners from states that already have a medical cannabis program in place to see how they've addressed that, and maybe other representatives. I know that Missouri in particular had a rough patch with some of that, with out-of-state businesses coming in. So I'd like to hear from states more in particular about what those issues might be, and then from states with growers who are actually homegrown and local growers, and how that looks and what all that operation is.
Okay. Representative Howe.
Thank you, Chairman. I agree with Representative Meyer. I think there's a lot of uncertainty and maybe a lot of risk out there for a grower, and just understanding what those risks are, just the uncertainty of what the federal government's going to do or not do, and maybe what we're going to do or not do, and just learning a little bit more about some of those challenges, as well as challenges from maybe to the south of us in Oklahoma, and specifically based on what they've done, and maybe some of the negative side effects of that model compared to something like Utah or Mississippi. Getting into a little bit more information, I think, would be useful. But I'm also interested to hear what all of you think should be some of the aspirational things that we should be really discussing. You know, is it patient centeredness? Is it quality of life? What are we really aspiring to do? And so I'd be kind of curious to learn more about where everybody else is on that. Thank you.
Representative Gessler.
Thank you, Mr. Chair. I want to kind of go on Representative Meyer's question there for a minute, or their statement. But we have a wealth of information within our state too. I'd kind of like to maybe incorporate them too. We have producers, processors here in the state. We have processors that deal in the industrial hemp side of this stuff, and which is a fairly close relative of what we're talking about. But they understand the laws. We actually have a resident in Kansas. He owns dispensaries and processors in 8 different states too. So I mean, and he lives here in Kansas. So, but we have we have them in Wichita too. So I mean, I think we should hear from some of those. Maybe reach out to some of those that come. I'm sure they'll have a totally different experience about direction that we should be heading.
We only got 2 days here, and we've already spent 1. No. Is there anything else that you'd like to add to that? Well, staff, I want to thank you for your hard work today. Committee, I want to thank you for all the great questions. I thought we got through a lot of good stuff today. And anybody that has any suggestions, I got open ears on how we do this, because there's a lot of great ideas come with that. And we'll have a discussion at the backside of the next one as to how we should go from there. So this gives you a little time to digest what we heard today and do some thinking, and then we'll get serious on the backside of that. So is there any other questions or any other comments that you'd like to put in today? We were scheduled for 4:30 and we're out at 4 o'clock. So we'll just call this a day and we'll adjourn. Thank you.